Ms. Shaini Pradeep, Assistant Professor at the Center for Trade and Investment Law, Professor Leila Shukron, Professor of International Law at the University of Portsmouth, and Dr. Geraldo Vidigal, who will be joining us virtually. He's the Faculty of Law at the University of Amsterdam. I invite Professor James Netherbrud to talk about the session now.
Thank you, Pushkar, and good morning to all of you. Today we have a very important session in the morning on trade and sustainability related issues as part of the 9th International Conference on International Law and the Changing Global Order. In fact, this session will be chaired by Mr. Sumanta Chowdhury, who is a former Secretary to the Government of India. He will be joining within a few minutes. So in the meantime, I would like to give a bit of description about the Center for Trade and Investment Law, which is the center sponsoring this session. We are part of the Indian Institute of Foreign Trade. We have been established way back in 2016, 2017 with the goal of enhancing and strengthening India's capacity in international trade negotiation, dispute settlement, and general advisory matters. And we have been involved along with our sister center, Center for WTO Studies, in relation to a number of trade agreements, of which the trade and sustainability is an important provision and a core component in fact. And when we think about trade and sustainability, it is not traditionally limited to environment and labor. A number of new areas, including sustainable food system, anti-corruption provisions, and the related matters are also getting included in free trade agreement negotiations. At the same time, negotiations are also happening in the WTO, in the structured discussions on environment. So anyway, I think the world is actually going into a more inclusive and sustainable world in a way. I think these kind of concepts cannot be ignored or cannot be, lost sight of. But at the same time, these kind of provisions will have deep implications for a country as well. So in the context of the sustainability and the objective of the global community to meet the SDG goals by 2030, we thought that it is extremely important to have a conference inviting some of the most important and some of the major, scholars in this area. We are joined by Professor Kathleen Clausen, a very eminent academic now based in Georgetown University Law Center. She also teaches at Harvard Law School. And then we have Professor Leila Shukron. She is also a professor at Portsmouth University. We have Ms. Anuradha. She has been a pillar of India's trade and sustainability negotiations in WTO and related matters as well. And lastly, we have myself and Shaini. So thank you and welcome to all of you. Without further ado, let me invite maybe whichever. Who wants to go first?
A very good morning, ladies and gentlemen, dear colleagues and friends. As usual, it's a great pleasure to be in Delhi and to be with the Indian Society of International Law, seeing many friends and colleagues we know of for many years. I'd like to thank the Indian Society of International Law to start with, its presidents, the many colleagues, and in particular Vinay, who's here for supporting the organization of this beautiful conference. Let me also thank Professor James Netherbrud and the Center for Trade and Investment Law for inviting me to participate. So this morning I'm going to address the question of sustainability, as you understood, but from a particular angle, that of social sustainability. And I think our colleagues are going to go deeper into the details. In particular, Kathleen is going to address the question of labor. So we thought it was a good idea for me to start from a rather general angle. So as you can see here, social sustainability is often forgotten, and yet it's a very central concept to achieve the UN goals. So let's get into the details. Trade can be beneficial to growth, and it's now generally accepted. However, as you all remember from an Indian perspective, opening up to the world has not always been a priority. For many years, governments were relatively closed. The question of India, China, and many other in the 60s or 70s. So indeed, international trade and investment can also challenge state sovereignty and their regulatory choices in favor of, for instance, sustainable development. This sort of pendulum swing, this constant change between liberalization and restriction has called for regulation, but a regulation which has long forgotten to take social and environmental sustainability into account. This tension between the right to regulate and the desire to trade and attract FDI has been revealed to a great audience by a large number of contentious cases and global movement questioning, indeed, ISDS. So that's probably one of the reasons a more general audience knows about that today. Trade and investment. Trade is generally present at each level of our daily lives, and it meets all the 17 Sustainable Development Goals. We'll go into the details later. Yeah, I think there is some echo, isn't it? Yeah. Excellent. All right. Echo is still there, but maybe you see better the presentation. So this, I was talking about this idea, this pendulum swing between the right to regulate and indeed the right to trade, or the idea of trading. Interestingly, a new generation of international investment agreement and trade deals include now SDGs and sometimes relatively precise provisions. We'll see that into details again. Let's move on. I'll move to the next slide. Here. Right. Oh, I'm stuck. Sorry. Our technicalities. Which one? Okay, great. The 17 goals, you all have them in mind, obviously. Some are very precise, some are less precise. For those of you who follow the work of the Center for Trade and Investment Law and Professor Nadine Para, in December we organized a big conference on the right to food, food security and food insecurity, and you see here that we are very much ticking the Sustainable Development Goals boxes with the goal number 2, right? Okay, so the goals, as I call them, rather than the SDGs, have been created, designed to meet certain targets by 2030. And then there is more to it, because of course the UN knows very well that, not all the goals are going to be met, far from that. So we have also some sort of common agenda, which has been published in September 21. And this common agenda looks at the next 25 years. So we're looking even, further down the line. And we see what we can achieve in looking at 12 different chapters of the common agenda, which basically cover the goals, but in a more, let's say, encompassing and somehow interdisciplinary approach as well. So trade, as I said in the introduction, can be a vehicle, but not necessarily. Today, you have a large number of international investment agreements and trade agreements, generally speaking, which have incorporated the SDGs, very often in their preambles, more sometimes as well in very precise provisions. For example, since the adoption of the Sustainable Development Goals agenda by the UN in 2015, you have something like 224 international investment agreements which have been concluded, and in that, 31% include provisions addressing the SDGs directly. The W itself prides itself for participating to the SDGs realization. But often trade and investment contradict or impede the SDGs realization. That's something we have demonstrated very clearly during our December conference. The case of hunger, food security, or rather insecurity is sometimes fueled by very trade principles. But what sustainability are we talking about? So generally speaking, when we talk about sustainability, people have in mind the environment and economic growth at best, but rarely social sustainability. This being said, you have a number of studies, and I've referred a few here by UNCTAD or by more specialized UN agencies on indeed social sustainabilities, but you see from these studies that the social element of sustainability is very rarely introduced or included in international trade agreements. For instance, they've looked at a number of BITs from the Asia-Pacific region, and in particular BITs entered into by LDCs, the least developed countries. And you see that you do have a few provisions on sustainability, but generally speaking dealing with the environment, and very few with social sustainability. So I will call that the Arlésienne, to use a very French word. So this is basically something you talk about a lot, but you never see. So the approach is very, very generally variable and relative. So you have very variable and relative definitions and approaches. Just to give you some example, and you'll see how different it can be. From the perspective of the World Bank, social sustainability and inclusion, it's interesting to use the term inclusion as well, formerly known as social development, reflects the World Bank focus on addressing long-lasting barriers to development, strengthening the focus on people who have been excluded from economic and social opportunities, and increasing investment in inclusive growth. Social sustainability is about inclusive and resilient societies where citizens have voice and government respond. So you see the choice of words. We're basically replacing the concept of development, which is a controversial one, because if you develop, you come from something which was not developed, with something more politically correct to some extent, social sustainability and inclusion, and we use the term inclusivity, resilience, and you'll see later on as well, vulnerability, citizenship, government responsibility, according to the World Bank perspectives, this social sustainability is quite critical to address poverty and indeed reduce this poverty towards prosperity. You see that, for instance, the bank works on a number of issues, including just transition for all, environmental and social safeguards, conflict and fragility, gender-based violence. Very interesting, because these topics were before addressed by other UN agencies, for instance, UNESCO, or to a lesser extent maybe UNDP. But you see, it's interesting that today you have World Bank including gender-based violence, for instance, in its reasoning. So it's a very people-centric development, and as I said before, you see concepts coming up like vulnerability, resilience, citizenship, which are not necessarily very frequently used by trade lawyers. We generally use this concept from a sociological or political angle, really. Yet, it's quite confusing, because I don't think people are necessarily at the center of trade deals. They are very often absent from these trade deals for the reason you can imagine, because we're talking about the States. So again, l'Arlésienne, really. Let's take another perspective, that of the UN Global Compact. As you can see here, the definition of social sustainability is slightly different. For the UN Global Compact, social sustainability is about identifying and managing business impacts, both positive and negative, on people. The quality of a company's relationship and engagement with stakeholders is critical. Directly or indirectly, companies affect what happens to employees, workers, in the value chains, customers, and local communities, and it's important to manage impacts proactively. So here the perspective is not necessarily people-centric, but I would say rather business-centric. And we look at the impact of businesses on people, positive or negative. So comes into mind the whole, before we used to call it the Ruggie framework, the UN framework for businesses and human rights, and this type of principles, looking at the OECD guidelines and so on and so forth. Indeed, in the first 6 of the UN Global Compact principle, you have this focus on social dimension of corporate social responsibility. So they even call it corporate sustainability, of which human rights is the cornerstone. So slightly different perspective again, not necessarily people-centric, but business-centric, with some sort of allusion to human rights and, for example, the right to health. So now, how to reconcile all that? What I find interesting intellectually, so to speak, is that you have some sort of intersectional, to use a fashionable term, approach. So you all know about intersectionality. We're alluding to the work of Kimberly Crenshaw, the scholar who introduced the term. And we're talking about 20 years ago, really. We're talking about black feminist and critical legal theory, which has had an impact as well on international law. So I find it quite interesting to see the sort of approach we can call intersectionality or interdisciplinarity. But I like this idea of intersectionality anyway, to show that everything is interconnected, that you have categorizations such as race, class, gender, which apply to a given group and intersect indeed. The same is true for trade deals. You can't approach a trade deal without having a broader picture in mind, and indeed a very interdisciplinary and defragmented approach. That's what we seem to see more and more in trade deals, but it's not yet very clear. And I would personally support this approach rather than an approach by exception. I think a number of my colleagues are going to deal with this idea of sustainability as a sort of exception, actually derogating. So I would support rather a positive, people-centered approach rather than a trade approach by exception, which makes sustainability and social sustainability in particular a derogation. So that's it for me. Thank you very much. I'm more than happy to respond to all your questions. Thanks a lot.
Well, first of all, my apologies for coming in late, and very good morning to all of you. And of course, it's good to see a lot of old friends and colleagues, and so welcome once again. And I've had the opportunity of hearing Leela only partially. But let me just say that this is a topic on which, I guess any session which is there today cannot but, in some sense, deal either directly or indirectly with this topic. Or in other words, whether you want to or not, it seems to confront you. And I think that is one observation that is, I think, I would just make a couple of points, and particularly I am no lawyer and I'm in front of legal luminaries. I am more a trade practitioner, so I will really speak more from the prism of trade as far as it relates to these topics. The first of all is that, in terms of its multilateral importance, the sort of climate change and negotiations and climate change issues are in fact now absolutely central, and they probably, at one point of time, probably it would have been maybe the WTO Ministerial Conference, which might have attracted more global attention. But today, that paradigm is fast changing, and legitimately so. Now, of course, there are a lot of challenges in the climate change, which I don't intend to speak now, but I will sort of draw attention to one particular aspect which has a bearing on what I am going to say rest, and I'm sure others will touch upon it as well. And that is, and I'll quote here, a certain article of the Paris Agreement of the UNFCCC, which states that all parties should strive to formulate and communicate long-term low greenhouse gas emission development strategies, mindful of Article 2 that takes into account their common but differentiated responsibilities and respective capabilities in the light of different national circumstances. And it's a fairly loaded statement with many, many subparts to it, which I will come in the course of mentioning. Now, we all know that whether we like it or not, climate change is a cumulative consequence of what mankind has collectively done over the past so many centuries. And obviously, therefore, the way that different countries, depending on their own development pyramids, have in fact some sense led to it, is obviously very, very different and non-uniform. And that is, of course, one of the reasons why you have this principle of sorry, common but differentiated responsibilities. The other sort of very, very intriguing part, which is now is the fact that this is now becoming a very integral part of industrial policy. So, climate change mitigation, high carbon, getting away from that. So, all countries in some sense now, and particularly so those who have the resources and the capabilities, are providing support and assistance in different forms to this transition. And of course, this sets its side, brings to the fore challenges of its own, particularly in relation to the multilateral trading system and the rules that are under the multilateral trading system, because there are obviously certain constraints within which such support can be given. And therefore, there is this intersection point between, but this is a trend which is happening. The other, of course, is that the reverse side. So this is more an incentive side. You are providing an incentive, whether it is for electric vehicles or hybrid vehicles, whether it is for low carbon emissions and so on. And the other is looking from a more penal point of view, where you penalize those who don't respect this. And this penalization can take various forms. There are unilateral measures which are now in, I think, the last stages of contemplation, even to be implemented, which deal with this. And just to take an example, but not to single it out, is the CBAM, where essentially what EU is saying that since my own industries and businesses have to meet some of these standards and there are costs involved, when you import similar products, then others have to pay a price, in simple layman's language, or a penalty, in order to provide some kind of level playing field. Now, I don't want to enter into a debate of whether this is WTO compliant, whether this is non-WTO compliant, but this is, and there are various forms of such penal measures, which are largely unilateral, but there are certain domestic imperatives also, which are leading in this direction of penalizing those who are not able to do so. A third and very integral part again is now the so-called new age trade agreements, as compared to the kind of agreements which were, the result, the norm till about not so long, 5-7 years ago, which was basically looking at the core market access, goods, services, and investment. But today, whether they are trade agreements, whether they are softer things like the IPF, we are all looking at this issue of sustainability and its relationship with trade agreements. And in fact, if you look at the last 5-7 years, the trade deals, particularly the bilateral and the regional trade deals that have largely been done, particularly by more so the developed world, whether they are with fellow developed countries or with other developing countries, this is a uniform pattern. Of course, the degrees to which they may have gone, the depth to which this is covered may differ, but invariably, this is something that is becoming almost an integral part of such trade agreements. Now, many of these so-called new age agreements have a lot of general obligations on sustainability, and they deal with a couple of issues. And let me take a couple of examples. One is, of course, fulfilling the parties' respective multilateral commitments, whether they are labor based on the international labor conventions and codes, and the multilateral environment agreements where it refers to environment. They also sort of, in some sense, what is often called prevent a race to the bottom. But the question also is, in trying to prevent a race to the bottom, are they also leading a race to the top? So this is something that, or is there a balance that needs to be struck much better than is possibly being done? We know that these standards are still very much different, and sometimes absolutely legitimately so. There is often, for example, a distinction again since between a comparative advantage or a cheaper labor, or which is governed by, among other forces, the demand and supply of labor. There are, of course, other market forces and other market interventions that affect it. And, of course, not adhering to conventions. And where this dividing line ends, that is, of course, a matter of some controversy. So, many of these, as I said, talk of non-derogation of the current, or from the current, either international commitments or standards. And sometimes your own domestic compulsions may lead you to have certain domestic imperatives that could be even higher. You may not have been in a position to commit or take binding commitments, but on your own terms, it is part of your own domestic policy regime. And how does this again intersection play? So these are, in some sense, I would say, some flashpoints which are now happening and are continuing to happen, and they will continue to happen, both in terms of its own agenda of climate change as a standalone, and in terms of its interplay and interrelationships with trade agreements, with whether they are regional, with the WTO system, and with their international labor and environment covenants themselves. This is a challenge that we have to collectively face, and I'm sure that there are many sort of such instances of this kind where I think further debate and discussion on this is absolutely critical. So once again, let me thank the hosts for holding this very topical kind of seminar, and for inviting me to it. Thank you. I now request Professor Kathleen Clausen to make her presentation.
Right. Well, Good morning. It's a pleasure to be here, and I'm honored to be invited to join you all today. I'm going to spend my time focusing somewhat on labor provisions in U.S. trade agreements, and this follows, I think, very well from what we heard from Leila a moment ago, in the sense that it's social sustainability in sort of next level as the U.S. sees it. I could talk about these all day, these issues of sustainability in U.S. trade agreements, but I will try to constrain myself lest we go too far into the following hour. I just want to start by talking a little bit about the meaning of sustainable and inclusive trade, at least as I see it from my work with the Biden administration now a couple of years ago, and studying these over the years. And again, I think, Leila, you set the floor very well for this. Increasingly, I see two different paths or groups that are developing on what does sustainable and inclusive trade actually mean. There are those who see the path to sustainable and inclusive trade through trade agreements that liberalize and that we can put in chapters that will create regulatory convergence on those items. And then there are those, on the other hand, who see it as the way to sustainable and inclusive trade as following through unilateral tools and apart from this liberalization vision toward more of a discipline of companies. And I'll say a little bit more about that in a moment. The difficulty with the first position is that it relies heavily on exceptions, and that makes many people uncomfortable. The second position is seen as inconsistent with trade law's fundamental core. And so these two are very much in tension. The one that wants to do liberalization but use exceptions to achieve sustainability, and on the other hand, those that wish to concentrate on unilateral measures that appear to be in tension with international trade law. At the same time, I think, at least in the United States and the US trying to create this vision throughout the world, trade's values are changing. And some criticism about how US trade policy is now seeking to achieve progressive aims that are actually not achievable at home. And so does that create some hypocrisy? That's, I think, a major criticism of the US position at this time. Now, I won't spend my entire time talking about the history of labor and environmental provisions in US trade agreements, though I'm happy to elaborate that at a later time. Some of you will know that that history goes back to the North American Free Trade Agreement in the 1990s, which was the first time the US tried to incorporate labor and environment into a trade agreement, except they didn't quite get there. Rather, there were side agreements on labor and environment in the NAFTA. And over the intervening 30 years, we get increasing procedural and substantive developments in these two areas. They bring them into our trade agreements now as standard as they are, and they develop and add more and more labor provisions and environmental provisions over the last several years. There is some path dependence in that. That is to say that Republicans and Democrats have only been able to reach compromise on certain issues, and those are the ones that we see repeatedly in our trade agreements, the same language again and again, and some diffusion throughout the world of that same language. There is now that language is put into the congressional legislation that authorizes trade agreements. And so that creates the sort of four corners of what administrations from both sides of the political spectrum are able to achieve and get through Congress. Of course, now we're in a world where we're talking about agreements that don't have to go through the US Congress, particularly the IPEF. What will the future of that be? We could talk a little bit more about that in a moment. The two standard principles that are repeatedly found in both our labor and environmental chapters are those of adopting and maintaining certain domestic laws in these spaces, on the one hand, and then second, effectively enforcing those domestically. And so you'll find repeatedly we say that countries should, our trading partners in the United States as well, of course, should adopt and maintain, for example, the International Labor Organization principles, different conventions of the ILO. Those should be entrenched in our domestic law. And then secondarily, not only are they on the books, but they should be effectively enforced in our various territories. Now, one question that has been front of mind front of mind in these debates is whether these are working. How do we measure success in our labor and environment chapters and in sustainability through trade agreements? I'll just note 3 possible metrics through which we might do this. One is by saying, are we achieving reforms? This is a big priority for the United States in negotiating, for example, very recently, the US-Mexico-Canada agreement, where an emphasis was placed on Mexican labor reform. And again, we can talk about that in greater detail if you wish, but I think many would say there's been a success in that, in having our trading partners achieve these reforms. The second is creating a cooperative dialogue that should be mutually reinforcing, where the United States learns from best practices from our trading partners, and likewise trading partners adopt and develop their own best practices, especially on certain intractable issues on each of our territories. And so then on cooperative dialogue, I think also there's a sense that there's been a great deal of success. We're now talking more and more about this in all of our various spaces, not just at home. The third possible metric for success on labor and environment in the US experience is that of enforcement. That is enforcement of our trade agreements on these binding commitments. Now, this is the buzzword at the moment. This is the magic word. If you want to come to Washington and sound cool, you talk about enforcement in trade agreements. Well, maybe that's just among our trade community. You sound cool. But why is that so? Why is enforcement the major focus at the moment? And one reason is because at least this administration is not so interested in doing these big free trade agreements, right? So instead, we talk about enforcing the rules that we have right now. And that brings me to an important note that James mentioned this morning to me, reminding me of a case that I lost on behalf of the United States. That is, I was the lead counsel for the United States in a case between the US and Guatemala when I was at the US Trade Representative's office. And this is the first and only instance we have in the US experience of seeking to enforce a commitment in the US Central America Free Trade Agreement, the only labor case of its kind in the US experience. Here was the claim in a nutshell. The claim was that Guatemala was failing to effectively enforce its labor laws throughout the country, that there were many instances we could point to of workers not being able to access their rights under these particular, under Guatemalan labor law. So Guatemala had the labor laws on the books, it was in the domestic law, but the Ministry of Labor was not effectively enforcing those particular laws in all these various factories, work sites, farms throughout the country. So the United States, after many years, this was 8 years that this litigation went on in one form or another. After all those many years, the US went to a panel, and at the conclusion, the United States was not successful in demonstrating, at least in the panel's vision, that Guatemala had violated the trade agreement. And interestingly, the panel concluded that Guatemala had failed to effectively enforce its laws, so that sounds like it breached the agreement, but it was not shown to be in a manner affecting trade. Those 3 key words, manner affecting trade, they're in the trade agreement, and that was the piece where the United States fell short in the eyes of the panel. Now, this was a critical milestone in sustainability in our trade agreements in the United States because the labor community was outraged, feeling that things were so bad in Guatemala, and if we couldn't be successful in enforcing this provision of our trade agreements, in the case of Guatemala where things seemingly were so bad, how could we be successful going forward? This is a pivotal moment because now you come to the USMCA, the next big trade agreement, and the focus was not so much anymore on these state-to-state commitments, because again, they were seen to be a failure after the Guatemala case. So we get the biggest change we've seen in 30 years in this recent US-Mexico-Canada agreement. And what is that? It's the key point that Leila mentioned a moment ago. If I leave you with nothing else, the new model for US sustainability in trade agreements is direct applicability for businesses. Yes, we still have the state-to-state commitments in our trade agreements, but this administration is particularly interested in corporate accountability, in using trade agreements to go after bad corporate actors, or who they perceive, of course, to be bad corporate actors. the cornerstone, the major piece of this in USMCA is something called the Rapid Response Labor Mechanism. The Rapid Response Mechanism is like nothing we've ever seen before in a trade agreement. And what it permits is it allows one of the three countries to take action against individual companies operating in the territory of another state. So let's give an example, and again, I'll stay with James as my example here. Let's say James has a factory. Maybe James, you have a factory on the side we don't know about. James Toy Factory, okay? And in James Toy Factory, we'll put it in Mexico for now. At James Toy Factory, there's a sense that perhaps the workers are not able to unionize. I'm sure this would not be the case at James Toy Factory. If the workers were not able to unionize at James Toy Factory in Mexico, what that would mean is that the United States could go and stop the toys from James Toy Factory from coming into the United States. That is the mechanism, right? So where the United States finds that the workers are not able to unionize, this is particularly about the right of collective bargaining, the right to collectively bargain and form unions. If it were in the view of the US Trade Representative that the workers at that factory were not being able to unionize, they can stop those goods at the border from that particular factory until the matter is resolved. Now, again, that's generalizing somewhat, but that's the principal tool and the aim of that rapid response mechanism. It's been used now a half dozen times since the entry into force of the USMCA. We have 6 different factories that have been petitioned by civil society that brought to the attention of the US government. The US government has intervened. Very interestingly, they all come from one sector. I should give points if anybody knows the sector from which they come. And the answer is the automobile sector. They're all in the engagement of either making cars or making car parts. So this has been the centerpiece of US trade and sustainability over the last 15 months. A very strict concentration on Mexico because of this particular tool. It only applies between Mexico and the United States or between Canada and Mexico. And this is really the center of the worker-centered trade policy as the Biden administration sees it. So as we come to the IPEF, the IPEF, these same questions are on the table. And for those at least who are in the trade pillar, those trading partners who are involved in Pillar 1 with the United States, they're thinking about these issues of design. Will we see another rapid response mechanism with our trading partners of this type? And if not, what else can we see there? Will there be aid? For example, a number of you I know are involved closely with these discussions as they relate to India. But beyond this, there are similar questions of shared norms, a rapid response mechanism, foreign direct investment opportunities, public-private partnerships, but not without criticism. Again, Mexico, on the receiving end of many of these cases, has raised issues of extraterritoriality, of sovereignty infringements, and other concerns about the way the US has carried out its use of this tool. So that's it. From the US side, the focus in sustainability is on corporate accountability. I don't think that's going to change for the next couple of years, and I look forward to seeing how it develops and to discussing it with all of you. Thank you so much again.
Well, thank you, Kathleen, for taking us through the evolution in the US of sustainability provisions in trade agreements. And I think 2 particular things that are, I think, striking. The first, of course, is the issue of enforcement. And this is also a difficult provision, even domestically, as you are saying, apart from the interplay with any kind of agreement. And the second one, of course, is to some extent the parallel of an investor-state dispute settlement, where it's the state which goes after a company or which takes a company. So it's almost the sort of, the mirror image of the other side. So let me move on then. May I hand to Professor James Nedumpara for his remarks.
So thank you, sir. So my topic is actually on a very narrow and specialized topic, which is actually called the non-regression provisions in the trade and sustainability chapter in the trade agreements. Catherine has already touched upon that issue, and Laila had also spoken about it in a bit. If you look at any kind of a trade agreement, any kind of an FTA which may have a sustainability chapter, there is actually a provision that deals with the general commitments, right to regulate, and environment protection. So it is a kind of, it actually sets out the objective of that particular chapter. And the provision very clearly says that it is basically a recognition of a principle. The principle is that it is inappropriate for a party to encourage trade and investment by weakening or reduce the protection afforded in the domestic law. So that means it's actually an age-old debate. If a country has got certain kind of a labor or environment standard, and if that country is not actually implementing the labor or the environment standard in the appropriate manner, with a view to giving a kind of an advantage to the domestic industry, it will basically tilt the level playing field. So it is actually a kind of a fairness argument. When countries actually trade with each other, ceteris paribus, the labor conditions, the environment conditions, everything should be equal. But there is also a very long and old argument here, and that is actually reflected in the 1995 WTO declaration as well, that if some of the developing countries have got an advantage in terms of the low labor cost, that shall not be actually worked to their disadvantage. So in a country, if their major advantage is actually low, the abundant supply of labor and cheap labor or low wages for that matter, it cannot really work to their detriment. That is also a recognition of a principle. So now let me come to the second element of the principle, which says, a party shall not waive or otherwise derogate or offer to waive or derogate from the laws in a manner that weakens or reduces protection in order to encourage trade or investment. And Catherine was actually talking about the manner in the Guatemala case as well. And the last thing, this is again a principle which says that neither party shall fail to effectively enforce its environmental laws through a sustained or recurring course of action or inaction. Again, what is the objective? To encourage trade or investment. So now, when we really look at this kind of language, there is in fact a confusion of purposes. What is actually the real objective of the trade and sustainability provision? Some people say that there is a fierce urgency of now. We have to act, the planet is in peril. Every country will have to cooperate in order to have a safe and a sustainable planet. So that seems to be the ultimate goal. And when I say that there is a confusion of purpose, the confusion stems from the fact that some of the trade and sustainability provisions are actually working to neutralize the advantage, the competitive advantage which some of the other countries, maybe a developing country, may possess. And therefore, it actually has become a very controversial area in almost all the trade and sustainability chapter across the world. It is there in most of the agreements which the European Union has signed with its trading partners, including Korea and Singapore and many other countries for that matter. So a considerable amount of literature has actually happened around this particular area. Some people actually call it the non-regression provision. And some people actually call it the non-sliding provisions for that matter. Now we have to come back to the original question. Every country passes a law. In India we pass a law not to disobey the law. We pass a law in order to implement it. But every country, especially a developing country, will have implementation challenges. If you really ask me the question whether India is actually enforcing the laws properly and adequately, there's no answer. Because the amount of granularity actually goes to a factory or a facility level. Think about a toy factory. She was actually mentioning about James's toy factory. Who will know, who can basically find out whether as an employer I'm actually paying the wages, whether I actually require the workers to work for extra amount of time, whether I provide the sanitary conditions, whether I provide the reasonable break in work hours, whether I provide a maternity leave. It is for the employer to find out. And any country will have difficulty in enforcing the law because of the size of the economy and the kind of the labor force it may have. But the problem here is that these kind of trade and sustainability chapters are trying to actually remove that kind of a policy space from the implementing country to a transnational level. In the sense that under the enforcement mechanism of the free trade agreement, the committees or the dispute settlement panels will have the final say whether a country has actually derogated or ineffectively implemented the laws to confer an advantage to the domestic industry or not. Now let me again address this point. So if you really look at the pattern of trade agreements in recent times, as Mr. Sumanta Chowdhury rightly mentioned, the objective is actually to prevent a race to the bottom. That is a traditional classic argument. And in recent times, it has also been, I think, renamed as to prevent climate leakage in the context of the climate change. Because if the labor and environment laws in a country is actually weakened, there is a real possibility of the industry shifting lock, stock, and barrel to another country where the standards are actually lower, and then it can actually provide maybe a disadvantage to the other country. So in order to prevent all these kind of things, there is actually a particular mechanism that we can see very clearly in all these trade agreements. One is actually, so if you really look at any trade agreement, there is a long recital in the Trade and Sustainability chapter. They'll talk about the Rio Declaration, the Johannes Declaration of Sustainable Development. It will talk about the future we want. It will actually list out a number of these kind of international commitments and say the parties then recognize and affirm and all these things. And there is another obligation to affirm these kind of principles. A party shall affirm these kind of principles. One point which Catherine mentioned is absolutely right. The amount of jurisprudence in this area is so limited that nobody can understand, nobody knows what will actually happen if a real allegation of the treaty provision is actually raised. How will terms be interpreted? Will this affirmation language be treated as a standalone obligation and brought to an international dispute settlement? Nobody knows about it. In the Guatemala case, thankfully, I won't say, since I'm in the global south, I can say that the panel took a stand which ultimately saved the Guatemalan government. But you never know, in the sense that it was actually more centered on the language affecting trade and investment. So what is actually affecting? There is a causal relationship. To what extent it actually affects, it is again a matter of degree. But in many of these agreements, so as I mentioned earlier, there's a clear scheme. Most of the countries will have to affirm the international instruments. Then they will have to pass the domestic law. And once they pass the domestic law, they cannot actually derogate from the domestic law. So they can weaken or reduce the level of implementation for that matter. This kind of a pattern has been, is seen very clearly from the NAFTA days. So if you really look at the investment chapter, chapter 11 of the NAFTA, there is a provision which is basically in the context of investment, which uses a should language with respect to this kind of a non-derogation. In the US-Jordan FTA 2001, the same language is there. In the US-Singapore FTA, it is also there. Then, if you really look at the European Union agreement, in most of these agreements, this kind of a non-derogation provision is there. So the one question is that, perhaps, we can't predict the future. The real challenge is that, will this kind of a non-derogation or non-regression provision actually become the FET of the investment? Because we know that the FET principle actually became a catch-all concept, and any kind of a violation came within that FET thing. Will a similar thing happen with this non-derogation? So now we know that there was another case against Korea. Even in that case, actually Korean actions were, in a way justified. But the panel also found in multiple places that Korea had actually violated, in the sense that, did not realize and respect some of the provisions. So one challenge is that any country that enters into a free trade agreement with a sustainability chapter will have to be mindful of the consequences and the direction in which this kind of language could be interpreted in the future. And when I'm talking about the FET, I think that is a real danger, because international tribunals, which are very ad hoc in nature, can come up with any ruling. And if you really want to prevent that kind of a slide, the countries will have to take adequate precaution. Another term which I want to mention here is, I'll only take 2 more minutes, the language called sustained and recurring. So sustained and recurring, so if you look at trade agreement, they say that if a country has not actually ratified all the ILO convention, then the country will have to make sustained and recurrent efforts in order to ratify that convention. In the Korea case, the issue was how long a country can actually do that kind of a good faith effort in order to ratify the convention. The panel said that the duration is not actually something that we can judge. But think about the situation. In India, we know that collective bargaining and collective bargaining and the right to protest. The right to protest, especially in the considered government servant, is actually a major issue. And India hasn't actually ratified a 1948 ILO convention. So if India has taken this obligation to make sustained and recurring efforts in order to ratify the ILO convention, and if it hasn't taken that ratification in the next 10 years' time, some people can say that there is a violation, right? So, and again, the danger is that this language, sustained and recurring, is actually written in stone now. If you really want to change sustained to repeated, there will be opposition. So that means, again, it is actually becoming a customer international kind of a standard, which is deeply problematic. I'm raising these issues only for this audience to think about it. These are matters of wider concern. Perhaps countries will have to negotiate these agreements carefully. But as everyone feels, sustainability is something whose time has definitely come. We can't run away from that idea. And in all the future agreements, countries will have to negotiate it carefully. Thank you.
Thanks very much, James, and thanks, I think, for pointing out, in some sense, the other side of the story, and the fact that something that we all know, this issue of where the comparative advantage ends and where you enter into another realm. And there is no such line. It's an artificial line. It depends on so many circumstances. And by the way, jocularly, James, reminded of your right to protest in government. I used to work in one of the longest Marxist states in India, which is West Bengal. And you realize that every day they had only the right to protest. They had no right to work, because you used to be gherraud virtually every day. So everyone has, what I'm trying to say is that circumstances are very different. And therefore, looking at it from the same prism, even in these so-called pure implementation of labor codes, is perhaps not the most appropriate form of doing so. But having said so, I would now move on to Ms. R.V. Anuradha, whose partner Claris Law Associates, and she would be speaking on the legal, political, and ethical dimension.
Thank you. Good morning, everybody. Thank you to ISIL and to CTIL for this very topical issue, and thanks also to the previous speakers for putting the lay of the land. So my comments on each of the areas that I am planning to speak on will be more reflective of the issues that have already been made. And let me actually start with labor related aspects and then move on to the environmental related issues. So picking on from the issue of what James had hinted upon, which is essentially that labor is a factor of production. So it's not necessarily that countries are exploiting labor to derive a comparative advantage, but that you can enforce labor standards, you can comply with labor norms as per your regulatory framework, have a comparative advantage, which essentially reflects in differential wage norms. As a lawyer in India, I don't get paid the same rate as the lawyer in the United States, but that is not exploitation. It is a factor of my comparative advantage, my competitiveness in rendering services in a particular manner. So, and this is where, James reflected on the, I think you're referring to the Singapore Declaration in 1996, which actually brought out the issue that labor cannot be used as a mechanism for protectionism. And Kathleen reflected on how US FTAs have evolved, and she did explain, in terms of the Biden administration's views in terms of how worker-centric trade policies is pretty much the mantra, that is the focus. And of course, one can debate endlessly in terms of how that came about to be, the domestic imperatives that have led to that evolution of those aspects. But just picking on one singular aspect of the USMCA, which you mentioned, Kathleen, is perhaps one way to perhaps address a number of these issues. What I find particularly worrying, if that becomes the norm is the auto industry component of the USMCA, which mandates that the cost of, if I remember correctly, the Mexican labor producing automobiles for the purpose of trade would have to be equivalent, as in $16 per hour, which is the minimum wage in the United States, as opposed to what is prevalent in Mexico, which I understand to be in the range of $7 to $11 per hour. Now, the fact that Mexico agreed to it willingly, voluntarily, it's not like anyone's putting a gun to its head, perhaps is reflective of the fact that it may work, but to replicate that across trade agreements will actually defeat the theory of comparative advantage entirely and put into question what are trade agreements all about and whether this should really be, or which this can be the way forward. Which takes me to the second issue in terms of ILO conventions, and the format in which these are actually enforced. And it's a matter of fact that United States has not ratified, as has India, the Convention on Collective Bargaining. In fact, there are 8 ILO fundamental conventions. US has ratified only 2 of them. India has ratified 4. EU may have ratified all 8, but it differs. And the reason for that is actually also rooted in the way the ILO works. The ILO works on a tripartite agreement principle in the sense that as an arm of the United Nations, they work with employers, with worker organizations, and with government. And the way this works, for example, at least in the Indian experience, is that it actually brings out the principle of what you referred to in terms of the cooperative action. Because every year there is a report that goes from the Ministry of Labor and Environment, Labor and Employment in India, which talks about how we perform in relation to each of the conventions and candidly also admits where are the shortcomings. And what needs to be addressed. So, for example, obviously child labor is something which is prohibited in India, bonded labor is prohibited in India, but there could be certain shortcomings in terms of universal implementation of it. How do you address that, and where does ILO intervention can come to actually better implement many of those aspects in terms of universal education, in terms of economic opportunities, and addressing all the socio-economic issues that lead to certain problems. That is the manner in which that part of international law on labor seeks to achieve compliance with certain social norms. The reason I'm emphasizing it is because of the increasing trend, I mean pretty much the norm, and we have accepted it, we are going to be accepting it in free trade agreements going forward in India as well, is the idea that somehow trade agreements are the magic wand to achieve all the problems that prevail, whether in terms of environment or whether in terms of labor. But in doing so, they are not actually holistically addressing it. Contrary to what Laila may have, if I understood you correctly, in terms, you mentioned in terms of fragmentation versus actually achieving things more comprehensively. I would argue that free trade agreements in their selective, piecemeal approach to labor and environment are actually fragmenting the entire area of international law when it comes to aspects of environment and labor. Now, come to think of it, sustainability and sustainable development is not something that any of us would be opposed to. Sustainability is core in fact, it's actually quite amazing that we keep talking about this principle, but there is no international law or instrument which defines what sustainable development is. All we have is the Brundtland Commission of 1987, which makes this beautiful principle and statement, which is basically that humanity knows that development can be achieved in a manner that will not compromise the ability of future generations to achieve economic growth in a sustainable manner. I think I'm paraphrasing it, but that is essentially a statement of vision, a statement of the ability of humanity to achieve economic development in a sustainable manner that was crystallized in the World Convention on Environment and Development, and that is the principle of sustainability that has actually evolved. But if we actually see in terms of the principles of sustainability, it has 3 pillars. It has the pillar on economic development, on environment, and on labor. And there is no question of giving primacy to any of this, because clearly each pillar has to be strong enough to achieve sustainability. But what really has been happening over a period of time in terms of introducing more and more of social and environmental dimensions without the adequate checks and balances, which are prevalent in international law, in the standalone labor agreements, in the standalone environment agreements. Those are not being incorporated into any of our sustainability chapters. Let me take the point that James was making in terms of non-derogation, non-regression, that you will not encourage trade and investment in a manner that will compromise your environmental norms, environmental science. Of course, makes complete sense logically. Who can oppose this, right? It's common sense. Let me take 3 observations from the Supreme Court in recent times, from our Supreme Court of India. So one was an issue, a case where, it was a case of land reclamation in Bombay. What is land reclamation? You're actually, basically reclaiming land from the sea, right? Obviously, you are intervening with the environment. There are going to be certain issues relating to that. The dispute that was raised was the extent of land reclamation which was being planned to build parks, gardens, and cycling tracks. The Supreme Court intuitively responded. It was actually Justice Chandrachud who made the statement that because the petitioners in that case, an environmental group, was making the argument that reclamation to this extent is actually going to lead to climate change related issues. It is going to lead to environmental concerns. And Justice Chandrachud makes this observation in open court. But only developing countries do not contribute, to climate change. Pollution is done by developed countries. Now, to say developing countries must stop all their projects because of climate change is wrong. The court eventually allowed land reclamation to proceed with a bunch of safeguards, a bunch of environmental norms that had to be adhered to. So in its vision that this is the way in which you can balance out interests, the right of a developing country to actually have certain facilities which are important for its people and safeguard the environment. But this was a relative observation in terms of what was sensed as important within a particular fact situation. Another fact situation involving a very tenuous and controversial area of environmental law in India in terms of getting a post facto environmental clearance. Okay? Environmental clearances, getting environmental clearances before a project is implemented is the norm. But in certain situations, there is the power of the executive to grant post facto clearance also, and also regularize in that process certain activities that may have already been done. And the question that I keep raising is, will this be interpreted to be a question of a derogation, a regression? Because it is law as implemented in my country according to my law, but is this something that can be interpreted as a dilution? In a case that had come up involving post facto clearance, again the Supreme Court notes that the court cannot be oblivious to the economy or the need to protect livelihood of hundreds of employees that are employed in a particular project, in that case, which was seeking a post facto clearance, and others dependent on that project. In other words, you have to safeguard livelihood, employment of people who are already engaged in a particular project. Of course, even in this case, environmental clearance was granted, subject to a bunch of safeguards. So that is the way in which the weighing and balancing occurs in real situations. Third instance, another recent matter. This involved the cutting of trees to pave way for construction of railway overbridges. This was in West Bengal. So when you have to cut trees, obviously highly sensitive issue, and this project had been delayed for over 6 years because the Calcutta High Court had granted a stay and the project was not implemented. The court appointed a committee, and the committee found that if you do not build the railway overbridge, you're going to continue having human casualties, hundreds of people dying every year in the absence of a railway overbridge. If you have to cut trees, so be it. But that has to be done in order to achieve safeguarding human life, and that's exactly what the court noted, that avoiding loss of human lives due to unavailability of overbridges has to be balanced with whether you need to cut trees or not. In that case, they did allow for the cutting of trees to build overbridges. The reason I raise these issues is because it is really not possible to have a one-size-fits-all kind of a vision to environment or development. Sumanta sir raised the important issue of CBDRRC, the common but differentiated responsibility and respective capabilities. In other words, countries are placed at different situations. They have different obligations, different responsibilities. So that has to be emphatically recognized while implementing environmental obligations. This is recognized in our environmental agreements, in our environmental treaties. Is that incorporated into trade and sustainability chapter? Magically, no. We are not doing that. We are not going to be using our trade chapter or sustainability chapter in a free trade agreement to enforce what agency after agency have acknowledged is a failure of developed countries to contribute to a simple $100 billion climate finance by 2020. We are in 2023, we are nowhere near the $100 billion climate finance. Where was that commitment? It was a commitment in the Climate Change Convention. Was that ever implemented? No, it was not implemented. Is that obligation part of a trade and sustainability chapter? No, it is not. Okay. So the point simply is, this is the reason I'm saying that what we are incorporating into trade and sustainability is a very convenient vision of a one-sided, one-prism view of what sustainability is all about, and that trade can be used as an enforcement mechanism to achieve this, to achieve sustainability, without the concomitant obligation of, say, a CBDRRC or any of those aspects. Let me also take a moment to highlight a few of the statistics, because when we talk about trade and sustainability, another important element that we find constantly getting into this debate is liberalization of what certain countries call our environmental goods and services. Now, this debate has been part of WTO discussion for over 20 years. Since the Doha round, liberalization of environmental goods has been on the agenda. Countries have come up with listing of environmental goods over a period of time, but there has been no uniform agreement in terms of, sorry, Shani, you wanted something? Sorry. Okay. So there has been absolutely no uniform agreement of what those environmental goods really are, okay? Because of the fact that most goods cannot be slotted into a category of environmental goods, completely benign, without non-environmental uses. So just take an example of, say, wastewater treatment. If you have to lay a pipeline for that, wastewater treatment can be an environmental purpose, but that pipeline can be used for various other purposes also, which may not strictly fall within the category of an environmental good. So because of the potential of dual uses, WTO members have not so far managed to agree to it, but this is going to be an important element of discussion in what James had referred to as the TESST. This is a joint group of certain countries which are negotiating and focusing on certain elements to try and achieve quick achievement of results on trade and environmental structural development discussions. Let me quote an UNCTAD study, which reflected on some of these aspects, and it notes that so one of the elements that the TESSD countries at the WTO are referring to is a OECD list. OECD, as we know, is predominantly developed countries, and they have come up with a list of environmental goods. UNCTAD looks at that particular list and says that the OECD's combined list of environmental goods, if you look at it, the top exporters of the goods are EU, US, Japan, there's China also in the mix, whereas the net importers are developing countries. So UNCTAD says that the tariff liberalization of this will result in a loss of $15 billion per year for a developing country. So their argument is, can a country like India impose tariff, use that as revenue for the purpose of various other developmental activities? Wouldn't that also achieve sustainable development? So the question is, choices really. And can environment norms in a trade agreement, can the bogey of liberalization of selective category of goods, can that become the only way, in which to achieve sustainability in a trade agreement? Or is it really a proxy for market access for a developed country? Protectionism by a developed country to achieve certain worker-centric objectives or certain what it believes are environmental objectives without the concomitant obligations which are actually inbuilt into an international agreement of environment or labor. The reason the primary reason that I find bringing in obligations of environment and labor into a trade agreement selectively is the fact that it will fail to achieve the balance that environmental agreements have achieved in multilateral environmental agreement sphere or labor agreements in their sphere. If we really wanted sustainability truly, I would say scrap all FTAs, scrap all multilateral environment agreements and labor agreements. Let us look at a universal agreement of international law that achieves each of these pillars logically and fairly, which would mean then for climate finance, obligation of a developed country to contribute to that, obligation of a country to contribute to technology transfer, and then subject the obligation of a developing country to achieve its environmental goals subject to the compliance of these obligations. In fact, the UNFCCC has that provision. Article 4.7 says that the extent to which a developing country will be required to achieve emission reduction will be contingent on the extent to which financial and technological assistance is available. So, and that is something which is completely missing in our trade and sustainable development chapters in a free trade agreement. So, a point is that unless we do complete justice to the balancing of rights and obligations in an environment agreement or in a labor agreement, and bring that justice into a trade agreement, what we are achieving is hogwash. What we are achieving is a selective and a piecemeal approach to sustainability, which is going to make some people feel good, but it's not really going to achieve more than perhaps diluting an advantage perceived or a dilution of a responsibility in the environmental sphere. Just to conclude, Sumanta sir brought up the issue of the carbon trade border adjustment measures, which is EU's measure that they are bringing into, it is essentially saying that EU has to achieve certain emission reduction targets. Why does EU have to achieve those emission reduction targets? Because it is good for EU, but also because it has agreed to it under the UNFCCC and the Paris Agreement. India has also agreed to emission reduction targets through our own nationally determined contributions we have notified. EU's targets and India's targets are differential. Why? Because that is what was agreed between international countries under the UNFCCC. Now EU says that if you want to bring your good, an Indian good, into the EU market, you have to equalize. You have to ensure that the carbon embodied in your good is equivalent to the obligation that I'm taking. What would that mean? It would mean that India will need to raise its obligations to clean up in those sectors for which it is exporting to EU. What does this do? It dilutes two aspects. It dilutes the ability of India to achieve economy-wide emission reduction in the manner that India would see fit. Why? Because it has to now focus on goods and products that are being exported to the EU to match EU's level of environmental reduction. Fundamentally, commonsensically, this completely makes a mockery of emission reduction obligations, differential emission reduction obligations under the UNFCCC. Is that fair? Well, that's the question that I would leave you with. Thank you.
Well, thank you, Anuradha, and sort of for highlighting the issue of checks and balances. And this is, of course, a universal sort of. So, let me move on to the next speaker, which is Ms. Shaini Pradeep, who will speak on revisiting the sustainability impact assessment of FTAs.
Good morning, everyone. Thank you for the distinguished panelists for summarizing the key concerns that arise based on the trade and environment or sustainability and labor negotiations that are happening today, and also the domestic concerns because of the measures and the kinds of industrial support that countries are unilaterally considering. So my presentation will focus on sustainability impact assessment and the need to revisit it in today's context, given the grounds of convergence that need to be attained for the global south and the global north. So in today's presentation, the three assertions that have come out are that the concerns of sustainability are ever increasing and urgent, and therefore addressing and engaging on these issues is to an extent inevitable, whether in the regional context or the multilateral context. Second, that the standards that the developed North has been proposing create certain insurmountable challenges and to some extent apprehensions for the developing South. And therefore, the third part is that the resort to countermeasures or aggressive measures may not be amenable to many developing economies, including the major ones such as China and India. So, given these assertions, it may help to take a step back and see the institutional mechanisms from an objective standpoint to ensure that the commitments that countries have undertaken under their multilateral environmental agreements and as part of the ILO conventions do not get sidelined in the matter of undertaking newer obligations as part of the free trade agreements. So while the standards that various trade negotiation agreements today, including the EU, Canada, and the US's standard approach set, have been discussed very elaborately in today's panel, and these constitute certain general obligations to not derogate from the obligations and commitments that have already been undertaken under the ILO and MEA commitments. But how to ensure that and reconcile the balance of trade and ensure that they do not impact in a manner which impedes the trade opportunities and comparative advantage for developing economies, and also do not raise barriers in a manner where developing economies are not able to adequately exercise the policy space and sensitivities that a lot of times they face post the implementation or negotiation process of an FTA. So to see the sustainability impact assessment studies of the three major economies, Canada, US, and EU, the very elaborate ones have been taken for today's reference, and those are those of the EU, where there are certain standards that are followed of basically two process parts, which include quantitative analysis, which is generally the general equilibrium studies and aggregating the common outcomes for trade factors with respect to the sustainability issues, including on labor, now gender also, human rights, and traditionally environment. And the second part of these sustainability impact assessments generally focuses on stakeholder consultations and public participation process. Now this second part is where the non-trade policy objectives find a place, because the first part of quantitative analysis generally recognizes and focuses on the various trade impacts and how trade increase in trade will eventually result in impacts on various fronts, including environmental hazards or beneficial to the environment, or decrease in labor standards, or decrease in comparative advantage, or neutralizing comparative advantage. So that generally is focused within the first part. Now in the second part, it's more about how the stakeholders that are going to be impacted based on the FTA and what are their concerns. And in the given sustainability impact assessments that are seen today in the three major economies, EU, Canada, and US, while EU focuses on the other trading partners' domestic concerns also and undertakes an assessment of the domestic sensitivities, it is often noted that the stakeholder groups and the representative groups that are part of these studies are generally very limited in number. So a lot of times, since the sustainability impact studies initiate right after the exploratory discussions or during the time the country decides to enter into a trade negotiation with a trading partner, a lot of time these sustainability impact studies take months or sometimes even 2 to 3 years to complete. And that is when the trade negotiations have advanced to a stage where around 7 or roughly 5 or 6 negotiation rounds have already happened, and the obligations that the countries are considering have come to a rather advanced stage. So taking a step back from then gets very challenging. And therefore, it becomes essential that to ensure that the outcome is institutionalized and not completely segregated in the trade and sustainable development chapter, requires that the sustainability impact studies do not just start and work in complete isolation or separation from the negotiations process, but they are carried out through the negotiations process towards the very end outcome, and that is towards the implementation phase of the agreement. And even post that, where there are chances of disputes and resort to dispute settlement mechanisms arising from the other trading partners. So the major reform areas that can be identified for sustainability impact assessments include deliberative consultation processes, that is through deliberative polling, where stakeholders are called upon in different groups and in different segments, and the deliberations happen, after which there is polling on the kind of interest that specific FTA is looking to address. So the various thematic areas that can be covered can be deliberated upon through consultations within different groups, and that is how the right group of stakeholders as well as the right interests can be identified. The second is to identify and then rank the priority areas of interest. That is, they will obviously depend upon the trading partner in question. So for some trading partners, a specific environmental objective may be more prioritized than, say, different objectives. So for example, air quality may be prioritized for a specific country as compared to water standards. And therefore, that is where the practical implementation aspect of the FTA will kick in. And finally, this part focuses on using these studies as policy instruments to ensure that they are not segregated within the initiation phase, where it's used more as a tool to alleviate the concerns of the stakeholders in the developed trading partner. Rather, they are used as tools to ensure that the cooperative mechanisms that are envisaged in the TSD chapters are operationalized to a rather practical extent, where it makes a difference on ground for the developing economy in question. So that may require engaging with the stakeholders in the developing country and getting the concerns addressed in the first go. And then that will also ensure the general obligation. That is, for example, the obligation referred to today was acting in a manner which is affecting trade or investment and taking sustained or recurrent course of action. So a lot of times these actions or these concerns are persistent for a specific developing economy. They may not be standalone measures where it's a one-time action that a standard has been violated and the concern has been addressed by the specific government. A lot of times these are because of challenges in terms of resource constraints, financial resources as well as technical resources, implementation, and in larger economies it could be because of the kind of caseload that the judiciary faces. So given these concerns, it would be important to take the sustainability impact assessment as a tool to negotiate the FTAs throughout the implementation process, instead of focusing on the beginning part, where it's used as a tool to alleviate the concerns of the stakeholders in the developed economy itself. And therefore, the cooperative mechanisms, obligations of the specific agreements will have to be better operationalized in consonance with, right impact studies with appropriate weightage to the sectors as well as the standards of sustainability in terms of both labor standards and environment protection being accorded in the beginning itself. So thank you for my remarks.
Thank Shiny for, I think, drawing attention to the fact that a sustainability impact assessment is actually a far more holistic and it's not that narrow sort of assessment of simply what is contained maybe in the provisions of that agreement. It has to be a much broader. Let me, since we have now, I think, sort of gone through all the speakers. There's is a virtual thing? I think there is a virtual presentation by Dr. Geraldo Vidigal.
Hello, can you hear me now? Yes, I see two thumbs up from Kathleen. Thank you, Mr. Chair, and I take it that you can still hear me. Okay. Oh yes, I'm now on the main screen. I see. That, so can I continue? Yes. Thank you so much. So thank you very much for accepting that I take part in this great event remotely. Thank you to James for the invitation, and this has been very enlightening. I learned a lot, especially since India very much. We know I'm based in Amsterdam, and we know superficially what's happening there, but it's very interesting to see your specific points of interest and the issues that will preoccupy you. So what I thought I would do is say also to alleviate having to look at my face for the next 15 minutes, that I have a small presentation. It's only 3 or 4 slides, but I ask you to stay with me. Let's see if I'm allowed to share my screen. Yes, I am. So now, yes. So can you now see the screen? Sorry for asking for confirmation as a question. Let's hope from now on it's good. So I just to be clear, I cannot listen to you. So please let me know on chat if something happens. So I want to talk as sustainability as shield and sword in international trade agreements. And this will very much going to summarize a lot of what you're saying and give it a bit of what I think is structure. And so, I mean, we all know, and that's something that the national started mentioning, that office availability as shield, right? So what does this mean exactly? And those of you who do more stability law will be tired of hearing this. Is that WTO rules and these rules were taken up by international agreements. You can see this most recently in the panel in Ukraine with that ban provides some exceptions to the trade rules. Right? And normally, under trade agreements, you would not be allowed to impose barriers to trade. So there is an exception. There are exceptions in all agreements. In Article 20 of the GATT, most famously, but this also appears in all other provisions that impose restrictions. Right. So instead of saying that no barriers to trade are permissible, you would say there restraints are unjustifiable. Or if you say that no discrimination is allowed, you say, well, no arbitrary or unjustifiable discrimination, or no illegitimate discrimination. So what does this boil down to? It boils down to what was a general exception, and is now called what I like to call a general authorization. And this is what the EU mostly is using as an interpretation of WTO law that allows to adopt all of these systemic measures. So, as those of you again who know WTO law will know, Article 20 is the provision of WTO law that provides that nothing in this agreement shall prevent members from taking measures to protect health, conserve the exhaustion of natural resources, prevent the use of prison labor, etc. And so this provision was meant, I guess it's as conceived in the 1940s, to allow countries to adopt measures inside their territories that they would, to make sure that the agreement will not prevent members or at the time that contracting parties from adopting certain necessary regulations internally. Now, what happened in the WTO, and that's something the third body did, is that first of all, extraterritorial effects are permitted as long as they're non-discriminatory, right? So the first big case on this was US Shrimp, and the panel in that case, which is the first instance adjudicator, stated that the U.S. in this case, the United States, was not allowed to adopt measures deciding how shrimp has to be caught in the Asia Pacific. So one of the components is India, also Sri Lanka, Pakistan, and Malaysia, if I'm not wrong. And then what the panel said was no, I mean, the environmental regulations are outside the scope of trade law, so you're not allowed to impose this requirement. And the third body said no. Well, the other Article 20 says that members are allowed to adopt measures to make sure the conservation of the resource and hurdles that you're trying to protect are natural resource. Therefore, this is allowed. So this circumvented the question that the legislation had extraterritorial effects. And also a broad definition of pesticides, right? So that's most visible in Brazil tires, and this is the case in which Brazil had a measure to combat dengue, which is a tropical disease in the Americas. I don't know if it exists in South Asia as well, but the idea here was that prohibiting the importation of retreaded tires would stop tires from accumulating, and the mosquito that transmits the disease reproduces inside used tires. And so what the appellate body here said again was, well, this is necessary because it makes a contribution to the net. So it's not speaking necessary to stop importing retreaded tires specifically, but this makes a we can see that there is a rational connection between what you're doing and the objective of the measure. Even though you can think of many other ways to stop a retreaded tire from being around in the country. For example, having a system, a public system that works for that purpose. Now, we know that in developing countries it is not always possible. The state doesn't necessarily reach all places, therefore but this means then that the key requirement for any measure that you can credibly claim that is aimed at one of these say noble objectives, I would find it difficult that anything that appears in the Sustainable Development Goals cannot be justified under Article 20. So anything that you can credibly claim that is to aim one of the Sustainable Development Goals, then you can essentially apply it also to imports on the sole condition that it's non-discriminatory. Now, the issue here, of course, is that how does this discrimination, and this is something that some of you have pointed to, when you say, well, it's non-discriminatory, what does it mean? Can Switzerland suddenly say that a worker in India has to make the same as a worker in Switzerland for it to accept, because this is for improve that it's a moral issue for Switzerland that workers have to make a certain amount, that would make the comparative advantages of the workers null. So can it say that certain regulations in Brazil have to be the same as the one in the EU? Can the EU say that? Well, it's unclear. And so taking advantage of this broad interpretation of Article 20, the EU is now in 2022, and some of these have been enacted, some of these are about, in the process of being adopted three regulations. So one is carbon border adjustment mechanism, the other is the EU regulation on deforestation-free products, and the third is the EU regulation on elimination of forced labor. And all of these regulations, I'm not going to go over each of them in particular, provide that products imported into the EU have to essentially have complied with at home, where they were produced, with certain rules set out by the EU. Now the issue is that it's unclear that this is prohibited by the law, and at this point we're probably not going to find out anymore, since there's no other body functioning to tell us to what extent it can work or not. So countries will have to negotiate. So in that sense, sustainability is working as a shield for essentially developed countries, as you pointed out, although not only, right, the group hires shows that this can also be worked by developing countries, to, let's say that they can pursue certain objectives, and in particular in the case of the EU and the US, they can pursue these objectives extraterritorially. Now, the novelty we have, and of course, I mentioned this, is that we now have sustainability as a sword. And last year, we published a case on how countries are using sustainable, are using regional trade agreements. So what kind of disputes there are. I adopted a very broad understanding of disputes. So you see that the rapid response mechanism that the US MCA has appears here prominently. So there are 5 instances. I think now there are 6 already. And there has been quite significant use of these regional trade agreements. Again, if you understand it as in this broad sense that disputes can be any kind of dispute settlement mechanism that is involved, or enforcement mechanism that is involved under the RTA. So I found that there are about 20 or 19 at the time disputes under RTAs, and then out of these, half of them concern sustainability one way or the other. So the US MCA labor mechanism appears prominently here. This is the lower table. On the top table are the regular trade cases that would have been brought, depending on how it would work, would have worked under WTO law. And you see that also is automotive rules of origin is here. It's a case in which Professor Clausen here was a panelist. But below you see all the cases that, so there are quite a few of them. Again, many of them under USMCA, but not only, right? So after the Guatemala case, about which Catherine spoke, there have been Korea labor commitments under the EU-Korea FTA, Peru Forest Protection Agency under the US-Peru FTA, and Korea fishing activities under CORO, the US-Korea FTA. So in all of these cases, the developed countries sought to enforce through the dispute settlement mechanism the sustainability conditions. And in the case of EU-Korea FTA, we have a decision. It has also been
I request you to please wrap up in a couple of minutes, if possible.
Pardon me?
If it is possible to wrap up in maybe another 3-4 minutes, if you can wrap up.
Yes, there is. I only have one more slide. So where can we still go with this, right? So we can think of this. I foresee this expanding quite a bit in the future, or at least they will be pushed by the EU and the US to expand these mechanisms. So normally now we have government to government. And you can think of NGOs bringing cases, for example. If you look at the USMCA Environment Commission, it does NGOs take cases there. You could have local entities bringing cases. for example, labor union, for example, could bring cases. Then domestically, of course, many of the developed countries are trying to open up their systems for other agents that states start a case. So in the EU, for example, there's a trade enforcement regulation which allows industries to poke the Commission to start cases, and why not open this to NGOs or labor unions? There's a case in Peru, Colombia, in which the workers in Peru and Colombia have tried to bring a case using the EU under the EU Peru-Colombia trade agreement, and also domestic competing, right? So the steel industry in the EU could try to bring a case directly to a tribunal, like as it happened in investment law against India, for example. Now, in terms of enforcement, there's a big discussion on this, whether you can retaliate using trade measures or not. I think that is important, but not, let's say, it's not something that appears to be central, because most of these cases, all of those cases that have been brought, actually have had a very high rate of compliance. So Korea, Peru, Mexico all have complied with when the cases were brought. So sanctions, it's an important discussion, of course, and I can see why people are troubled by it. But in terms of how these mechanisms affect state conduct or state behavior, I see that the very mechanism itself is potentially very effective without the need for sanctions. And I'll stop here. Thank you very much.
Well, thanks a lot, Geraldo. We have, of course, gone through the entire list of speakers, but may I now quickly throw open the debate to the floor, and maybe we can take a set of 2 or 3 questions. And what I would request each one of you to be very brief, and in case the question is addressed to a particular panelist, to please mention the same.
My question is to okay. My question is to Kathleen, that what is the impact going to be on the, because you talked about the enforcement dialogue, etc. What will be the impact on the small scale sector, MSME sector, because the greenwashing and there is a lot of usage of capital, by the advanced countries, and because of these norms, which are going to impact even the supply chains also. So we are going to see a lot more of inequality as far as these things are concerned. There will be a lot more of greenwashing also. There will be, the rules of the game are going to be massively distorted towards large businesses, because the value chains and supply chains are quite rigid as far as advanced countries are concerned. And even with the new, for example, metals, lithium, etc. We see quite often, that, the mining, etc. that takes place, is going to impact, the developing countries the most, because labor is going to be the one that is going to suffer over there. And so the transparency is not going to be that, that much as we see, So what exactly is to be the norms that we see, basically, so that, there is a level playing field. And eventually we do not go into a situation where the ESG norms and basically simply become again another, become a thing of turmoil and create more turbulence.
Ma'am, my question, ma'am, my name is Kavya. I'm from VIT AP School of Law. and my question is to Catherine ma'am. Actually, my question is regarding environmental norms, which are like when developed countries think, like US, think that the main reason for pollution, environmental, this now after the developed countries have exploited the environment, they now believe in ecological moderation, if we can put it in that way. Is it not fair on developing countries? Now we are thinking in a standard view approach, where we think minimum exploitation, which maximum, usage of the resources. Now, after the developed countries have exploited the environment, now they're thinking of ecological moderation. Is it not fair on the developing countries like India to put up like this kind of norms now? So, is it not fair on developing countries? That's my question, ma'am. Thank you.
Kathleen, obviously you are the most popular among the speakers, so may I turn it over to you.
Thank you so much for the questions. I won't be able to do them justice. They were so rich, but I'll try to say a little bit, and perhaps we could speak more about the environmental one offline in the shortness of time. That would be great. So, but let me focus on the first question and come back to a point that Anuradha made a little bit earlier about the political imperatives that I think the Biden administration is facing, and I certainly do not speak for them, to be sure. But I think there is the pressure that they feel, which was embedded in your question, about both accommodating the supply chain resilience, dialogue, and importance, but also upholding what they see as this worker-centered trade policy. So I don't think they are sort of ignoring the outcomes that you mentioned. I hope that that's not the case. But I think they find it very difficult to square the circle of all the issues that you raise. And I do think that they're trying to forge a middle path between the two the binary that I mentioned at the outset and that Geraldo re-emphasized, but maybe not doing so as successfully as one would hope, especially from the developing country perspective, in their efforts to sort of create this broader compromise, shall we say. So one way to answer that, and I know we have almost no time, but just one example might be with respect to trying to take the pressure off the state. This is one justification that they raise for why they do things like the rapid response mechanism. That is, now we don't put Guatemala in that position because maybe Guatemala doesn't have the capacity to actually address those problems, right? And so rather than force Guatemala to do it, now we, the United States, or this is, here you have your neo-imperial sort of view, but nevertheless, that's the image that they seek to portray, that we're actually helping the developing country by not putting the pressure on them, but rather going after these corporate actors, which we really see as the worst actors in this story. But it is nevertheless extremely selective, to pick up on that earlier point, not just in what it covers, but also who gets targeted. And that, I think, goes to the question that was raised. I think I better stop here, but maybe if you'll permit me one footnote, Mr. Moderator, that I think there's an underlying question in all of our presentations, perhaps, about whether this is trade, or whether this is appropriately the province of trade law. Are these even trade disputes? I mean, Geraldo and I have had this conversation about whether the rapid response mechanism counts as a dispute, and we can debate more, Geraldo, you and I, about compliance, as you know. But what is the effect of treating them this way? We've talked about what's left out of trade agreements, but we tend to increasingly see trade agreements as the vehicle for bringing these in, and yet one wonders if maybe now we are asking too much. We are doing through the front door what corporate social responsibility, business and human rights, with those agenda we're seeking to do maybe through the back door. And one wonders if that actually is going to be successful for all the reasons that my colleagues have so expertly mentioned. Thank you.
Yes, I think I will throw it open to the other panel.
So my question is actually to the other panelists as well. So when we really look at sustainability, we know that sustainability, as if it is considered to be a locomotive, it won't actually move unless it can piggyback on something. So if you really look at the Biden administration policy, it is actually worker-centered trade policy, right? So sustainability can move in that kind of a framework. When you have got an objective of worker-centered trade policy, sustainability can be an important component of that policy. Or when we think about even trade for that matter, right? We can actually enforce sustainability on its own. And that is why all these multilateral environment agreements, you know, they were non-starters. I mean, they had commitments, some kind of sometimes soft commitments, but were not able to achieve the objective. So you need something to piggyback. So I was just talking about Anuradha's question as well. Throw away all these kind of trade agreements. Can we achieve the ultimate goal without trade or investment?
Make that much sense anymore, although I totally understand that in climate you have some requirements, And the whole comparative advantage discussion as well doesn't make sense, because trade today is not the trade of the 80s. It's much, much more complex. So I think we have to move one step forward and see sustainability as something everybody could benefit from, wherever you are in the world, and not necessarily something imposed as, you know, by the North or whoever it is, to as a disguised protectionism or something like that. We've passed that years ago, really. And I know you disagree.
No, I think the point really is, again, as I said, nobody can say no to sustainability. I want sustainability. I think it's all on visions of sustainability. And I keep getting reminded of this absolutely phenomenal movie of Akira Kurosawa, Rashomon. Many of you would have seen it. It's about perspectives. Okay, it's really about perspective, because, you know, it's actually, that story is about a brilliant movie about a murder from the perspective of 4 witnesses, and each one is a different narrative. So the question, again, I agree, is not necessarily a strict developing country divide. What I find problematic is really the piecemeal, picking and choosing of causes without actually the balance that a multilateral environmental agreement would otherwise seek to achieve. And when I said, James, that scrap environmental agreements, I meant that, I agree with you that, why is it that trade and investment agreements are so attractive? It is because of the tool of enforceability and sanctions. And when did this come about? It didn't come about in the 40s, 50s, 60s, 70s, 80s. It came about with the brilliant experience of the crown jewel of WTO dispute settlement, which today has been pushed out of the door, but is now that avatar, that mantle is going to be taken over by free trade agreements. Now, if you bring in more and more into the free trade agreements without the balance of international law on environment, eventually my concern is that it will become a skewed view of what is going to be enforced without the adequate support to be able to achieve it. And when I say that scrap it, I meant that then incorporate it into my vision of international law on trade, environment and labor comprehensively, which builds in the checks and balances of a multilateral environmental agreement like the UNFCCC, and a sustainability chapter that can meaningfully say that there will be an obligation to enforce, an obligation to bring down emissions, and an obligation for tech transfer, and an obligation of financial support. That's really what my vision of just and fair world would be.
Well, I think all good things must come to an end. I hope it was good for everyone. I'll just sort of end by saying this, leave you with a philosophical question. What is going to be sustainable about the sustainability debate? I think that is, in some sense, a matter of perspective. But let me thank each one of the panelists and request the audience by a vote of acclamation for all the esteemed panelists. Thank you.
Small announcement as well as is that on behalf of Indian Society of International Law, we would like to present the Indian Journal of International Law to all panelists. I request a mark of gratitude from the Indian Society of. I request Professor V.G. Hegde kindly give the IJIL, Indian Journal of International Law, to each of the panelists. And we request all of you to contribute your article into the IJIL or bring a one set of the, what you can say, this panel, one book form, something which could be useful for keep it at the 9th International Conference. Thank you. Now, we are going to hold the parallel sessions. One is on nutritional health law, which will take place in this hall, and another is cross-border investment. That WTO cross-border investment. That session will take place at room number 204.
on the rights of the child. So there are provisions, but most of the time we don't really try to join them, or we just talk about the right to health and the access to medicines or pharmaceutical patents, and which brings us to the WTO, the TRIPS agreement. And since it has come into existence the time it has come into force in 1995, it has raised many concerns, particularly the access to medicines. And because of the emergencies of pandemics and other things which were there in the many African countries, Brazil, Thailand, South Africa, so HIV and AIDS and other things which have happened, it raised a lot of concern, and then we come to the declaration on particularly the declaration on the TRIPS agreement and public health. That was in 2001, followed by 2003, that is the decision, and that was the implementation of para 6 of the declaration on public health, and which was permanent shape was given by Article 31 bis, which was added to the TRIPS agreement, and so far it is the only amendment made to the TRIPS agreement, and then you see it is in force, but it is not, there is a criticism that whether it really gives the access to medicine and it helps. And then we have the, particularly we have the 2016, the report of the Secretary General, high-level panel report. Again, it reiterated that the developing countries and least developed countries, they need to have the access to medicines. So there are issues, and right now you see after COVID-19, the pandemic, again the issue was it came before the TRIPS Council, and they have given the waiver for 5 years. That was in July 2022, and thinking that it will be extended to diagnostics and you see the therapeutics. But it has not happened so far, because just the waiving of the patent is not enough, because many times the patent product, it comes along with the therapeutics or diagnostics, which again makes it very difficult to access that. So I have just given you some idea that how this canvas of the international regulation of the health is, at the moment it is there, and I'm sure that we have a very outstanding panel, and particularly, and they will throw light on many of these aspects. And I have with me my very dear friend, an outstanding scholar, and very well versed, because she is working, Dr. Manisha Sridhar, she is working with the WHO for the last so many years, and she knows ins and outs that what is happening at the WHO vis-a-vis the WTO and on the health law particularly. So without taking much time, I now request Dr. Manisha to kindly deliver the keynote address.
Thank you, Dr. Surinder, and thank you to ISIL for getting me here and asking me to talk to you. I must tell you that when I met Dr. Surinder for the first time, it was in the Ministry of Micro, Small and Medium Enterprises, when there were certain projects, and I was put as chair of a certain committee, and we were to look at patent and how MSMEs could be given certain programs for them. And it's been many years, but let me tell you that the best proposal we got at that time was from Dr. Surinder and from ISIL. And that set us on a very close friendship, which has stood the test of time, if I can say that. So we are both sitting here as friends. And if she says something about us, please also discount what I would say, because I think I could be held for bias. But we had, after that, I was engaged in WHO in 3 very major conferences. And the entire team, Dr. Surinder and Vinay and Parineet and the entire team did an outstanding job. Dr. Surinder has just mentioned to you about the 2016 UN report that came out. It was passed by the UN Assembly. And she was instrumental at that time in the conference when we discussed it in 2017. And the Ministry of Health requested us to discuss that report. And we had a very major international conference here in Delhi. And that led to certain deliberations in the World Health Assembly that took place later that year. So just to flag to you that a lot of work that we did earlier has found place in the WHO deliberations. I think Dr. Surinder has really raised the context very well for today's discussion, and I can see we have a very eclectic group of speakers, and they will be covering many subjects. She very rightly stated that there is no international health law as a unitary field of work, but we do want to flag that the international sanitary conferences that began in the early 1860s, and they were actually a response to the cholera epidemic across the world when immigrants were going to the United States from Europe, and they had to be put in quarantine. Now that actually led to a series of international sanitary conferences that culminated in the formation of the Health Committee before the United Nations in the League of Nations. And this Health Committee, which was at that time supported by the Rockefeller Foundation, because they were very active in public health. They still are. Their foundation is still active. And that eventually culminated in the formation of the WHO. So WHO actually is the first legal UN instrument on public health. And its articles of association govern the way we work. And the reason I flagged it again was because Dr. Surinder mentioned about the international health law. The international health regulations that are under the WHO, it is not under Article 19 because that covers the treaty obligations, and there's only one treaty, as we all know. It is the Framework Convention on Tobacco Control. There's no other legal engagement that the countries have agreed to under the treaty framework. But under Article 21, we have these various World Health Assembly resolutions, which are not binding, but it is for each country to adopt them. And of course, the international health regulations, which was under Article 20. So these health regulations were actually supposed to be the mantra and to be able to control all pandemics. And this has come into focus because of the COVID-19. And therefore, our current work in WHO is that they are looking at whether we need a treaty framework to handle future pandemics, because it is well known that between the evolution, the virus is also evolving, and we are likely to have future pandemics. And so how should the world be better prepared so that we are not caught the way we were for COVID-19? And so there is a lot of work which is taking place just now in WHO, where they are looking at international treaty obligations. And in this context, as Dr. Surinder also mentioned, there have been earlier engagements in the WTO, where we had the Doha Declaration on Public Health, and she mentioned the 2016 engagement as well, which I have just discussed. But more importantly, as she mentioned, last year we had this it is a decision on COVID-19 which took place in the context of vaccines. And we need to bear in mind that vaccines is a closed system, because before COVID-19, vaccines were being administered to children. So you knew who are the children, you knew your cohort, and so the vaccines were prepared for them. And whatever has taken place under the various FDAs, particularly the US FDA has been a leader in this regard, has stemmed from vaccine regulation. Even the drug regulation and all therapeutics and diagnostics, the base is the vaccine dissemination. And in this context, we also have to bear in mind that a lot of that has been extended to drugs and therapeutics as we go along, and that is where the international legal framework sits. Because of the COVID-19, the vaccine regulations and the legal framework under which the US FDA was working, it had to be crushed in terms of timelines. You know, we were all waiting desperately for vaccines. You remember January 20? We were in a very difficult situation. So for the first time in the history of vaccine development, rather than finishing clinical trial 1, which looked at, say, mice, and then they looked at clinical trial 2, small human samples, 3 and 4, which was larger samples, this whole process would take a period between 10 to 12 years for vaccine development, but we crunched it and vaccine was available in a time frame of just 1.5 to 2 years. So how did that happen? That happened because for the first time, they went on a roll-on review. Before clinical trial phase 1 was entirely complete, but the US FDA and the other stringent regulatory authorities under the International Conference of Harmonization, the ICH system, they started looking at promising vaccines, and they went into clinical trial phase 2. Before phase 2 was entirely done and they found something is good, it's ready to go, they went into 3, and then we had the vaccine rollout. Now this roll-on review is the first time something like this has happened in the legal framework for vaccines. And another discussion which is taking place among the drug regulatory authorities across the world, and there is a very interesting paper you can look at the US FDA website, where they are looking at lessons learned in terms of vaccine development, and whether we could extend that to make faster drug deliveries and drugs available to the people. So this is a bit of the background that I thought you would be interested in. A few quick points. I thought we want to hear all your. You have a very big panel, and it's very exciting what they're going to present. Few things I would like to mention is that trade law is changing over a period of time, and so does health law, because health is so critical. One thing which COVID-19 taught us was that health is paramount. You can do any amount of economic development, but if you have a public health crisis, it all comes to naught. So if health and public health are important, we also need to bear in mind, to that extent, health law is very critical. And in this one of the things, Dr. Surinder has already covered the TRIPS agreement, so I'm not going to go into that, except that the 2022 it's in common parlance called a waiver, but it is a decision in the WTO. There is a slight legal difference in that, because it is important for the countries to adopt that. And as of now, there is a vaccine glut. So by the time the decision actually came on the table, there is already vaccines which are not having an offtake on COVID-19. So unless what she mentioned in terms of therapeutics and diagnostics is considered, we don't know what is and not many of the pharmaceutical companies, even the generic ones, are ready to take it off, because many of them already have license agreements with the existing producers of vaccines. So this is the position where we stand today. I do want to flag to you that the world is changing at a very fast pace. We just opened up the chat GPT the other day, and we were throwing public health questions to them, and I was amazed at the kind of responses that were coming. So we do need to look at the AI space for public health, including for drug development. It is already being used by pharmaceutical companies to look at promising molecules, and also in terms of the CRISPR technologies, which are very important for development of biologicals and DNA modifications that we are looking for long-term diseases. So that's an area and space to watch, and we have this very young panel of researchers. I think they have their hands full, because ChatGPT and AI will inform whatever they are doing today in many different ways. And this is something they may like to keep in mind. And the final comment before I hand it back to Dr. Surinder is that I think we need better communication for health law. You know, I work in WHO, and everybody thinks that lawyers and legal knowledge of law is a nuisance because all they know about it is medical negligence. You know, it's like standing on the intersection of a crossing, and everybody has a free-for-all to go. You know the chaos that is going to take in the intersection if every truck driver and every car decides to go the way they want to. So there needs to be a method when we move forward. And in this, it's my earnest entreaty to ISIL and to all the legal scholars that you're all doing a good job, but I think we need a better communication of what our work means in terms of legal engagement for public health professionals. And the knowledge of law, there is a need to see that as a facilitator in their work rather than an impediment, because as I mentioned, the only thing they know, the doctors and nurses, and you know, WHO is basically doctors and nurses and you know, it's the health professional driven organization. That's all they can see. So we need to improve our communication, and this is something that we all need to work on better as we go along. So with these opening remarks, I think I hand it back to Dr. Surinder and her competent hands to run the program.
Thank you very much, Dr. Manisha. You're very right. Words for the opening of this particular session. We really appreciate that all the points have been highlighted, and you have told that what we as the lawyers, because we are all here, basically we are all from law, of course, except Dr. Manisha. So, oh, she's a lawyer too, so okay. So she can say anything with authority, so we will take it as a really something which we should seriously consider. She has rightly said that, you see, there is only one convention which the WHO has been able to conclude, and that is Convention on Tobacco, and I was the one, we have organized very big seminar while I was the director of the ILI. So it was after that. But now they are thinking about the convention on the pricing of the R&D and something like that, separate from pharmaceuticals, in the case of pharmaceuticals, from the R&D from the actual price which we have to pay. So this is all there. Now I come to the panel, which is really very erudite. I mean, a very knowledgeable panel, and it is crowded, I must say that there. And we don't have much time, maybe at the most an hour or so. So if I hope you would not mind if I say that please take, if you can summarize your presentation. It is a summary we would like to, because there is no time to give you full presentation. So kindly take 5 minutes if you can make it that way. So I call upon Mr. Shyam Ogang, who will be talking about the health, equity and international law. I will welcome him. He has come all the way from Kenya. Welcome. Wherever you feel convenient.
Check. All right. Good afternoon to all of you. My name is Shyam Ogang. I come from Kenya. Namaste. Ketheo. I know Hindi and I speak Hindi. And I'm currently a research scholar at the University of Delhi. But before I came to the University of Delhi, I used to teach at Egerton University in Kenya. And we used to have a project on social justice led by United Nations Development Program. And So every year we have a conference in December to present our research on social justice. And one thing that when I was researching, that I came to discover amongst the marginalized and vulnerable communities, the biggest problem is access to healthcare. And access to healthcare is a big problem in developing countries and is a big cause of poverty. For example, in Kenya, in a population of 50 million, in every year, 300,000 people, additional people plunge into poverty because of financial hardship as a result of access to healthcare. And in India, when I was researching, I found that in every year, 40 million people fall into poverty. 40 million additional people fall into poverty because of financial hardship when accessing healthcare. And it's a major problem. And if we are talking about sustainable development programs, we are talking about eradication of poverty, we cannot eradicate poverty without, first of all, ensuring that everyone has access to healthcare without suffering financial hardship. People are, like 500 million people in the world are an illness away from poverty. Catastrophic financial, health expenditure is a big problem, and that affects, in the case of India, 30% of the population. So I will not delve much into it because in the shortness of time. I'll just talk about equity. What is really equity? And in the sense of equity, I'll talk about health inequity. Health inequity is the unfair and unjust and pervasive disparities that subject a part of the population to financial hardship or some other form of hardship when accessing healthcare. In the form of, I'll talk this in the form of AAQs that we have in the Committee on the International Covenant of Economic and Social and Cultural Rights. I'll talk one thing about, let's look at the issue of privatization of health. For example, look at India, where we have so many private hospitals and very few public hospitals. I'll talk, for example, the case of Uganda in Africa, where majority of hospitals in Uganda are private. And then we had COVID-19. And then when COVID came, majority of the people are not in formal employment, they can't access insurance. And so what happens is the private hospitals increase the price, the demand goes up for hospitalization, prices increase, and people can't go to hospital, so they just wait to die. And should we wait for another pandemic to come and then cry about our health systems when we have been warned by the committee itself that we should regulate, first of all, ensure that we regulate privatization of health, and then increase expenditure and investment in health? Because one, privatization hides our lack of investment in health. We say we have hospitals, but can the poor go to those hospitals? No, because they're private and it's only the rich who can access them. So I'll not go much because of time, but I'll just talk about two things. We have to be creative in our finding solutions for the problem that we have of inaccess to health. Let us believe that it's possible, and we commit and imagine and act. 70% of the cost of healthcare is medicines or drugs. How do we deal with the issue of trips to ensure that the poor can also access medicines cheaply? And then on the issue of universal health coverage, how do we come and build up a social health insurance for everyone? How do we bring in the informal sector, which mostly misses out on insurance? Can we think in terms of maybe technological ways of bringing the informal health sector, or can we find out other ways? As we saw during COVID, we have to have national solidarity and international solidarity when it comes to health, because without it, we are going to crash once again. We have to be moral persons and having consciousness. Don't think that because you are rich and your neighbor is sick because he's poor, you will also not be sick. Thank you so much.
Thank you, Mr. Ogang, for your raising a very important issue, that is inequity, that is poverty of the people, and the cost of the health care. So all that can be taken care of. I mean, the intervention of the government or the better policies they are required. Thank you. Now I request Dr. Ajay Jaiswal, who is a professor, Department of Law from Kanpur. He will be talking right to health vis-a-vis technological issues.
आप सभी को मेरा प्रणाम। मेरे को जो बात करनी है राइट टू हेल्थ एंड टेक्नोलॉजिकल इशू पे। हेल्थ और टेक्नोलॉजी को देखने का जो दुनिया का दृष्टिकोण है, वैश्विक दृष्टिकोण है, वो 3 तरह के जूरिस्प्रूडेंशियल अप्रोच पे चलता है, मार्क्सिज्म, कैपिटलिज्म और फेमिनिज्म। हेल्थ को भी इसी दृष्टिकोण से देखते हैं और टेक्नोलॉजी को भी इसी दृष्टिकोण से देखते हैं। जो टेक्नोलॉजी का डेवलपमेंट हेल्थ सेक्टर में हो रहा है वो बॉडी को फिट करने के लिए हो रहा है कि शरीर आपका स्वस्थ रहे, जबकि जो हेल्थ है सिर्फ आपका शरीर स्वस्थ होने से नहीं स्वस्थ हो सकता, उसको स्वस्थ करने की प्रक्रिया से स्वस्थ नहीं हो सकता। बहुत पहले भारतीय मनीषियों ने एक सोचा था कि क्षितिजल पावक गगन समीरा पंच तत्व मिल बना शरीरा, और यही 5 तत्व ब्रह्मांड को संतुलन में लाते। जब तक टेक्नोलॉजी का विकास इन सारे तत्वों को, जिससे आपको स्वच्छ पानी मिल सके, बिना अल्टरेशन का खाना मिल सके, बिना अल्टरेशन का एनवायरनमेंट मिल सके, जब टेक्नोलॉजी इस पे काम करेगा तो बहुत सारा हेल्थ का जो इशू है, बहुत सारा हेल्थ के राइट का जो इशू है, वो स्वयं प्रोटेक्ट हो जाएगा। अभी जो टेक्नोलॉजी का विकास है हेल्थ के सेक्टर में, वो इलिट्स क्लास को ध्यान में रख के है, अभिजात वर्ग को ध्यान में रख के है। मलेरिया से, स्वच्छ पानी के कमी से, कुपोषण से, ठीक ढंग से सैनिटाइजेशन नहीं होने से बहुत बड़े पैमाने पे दुनिया में लोग मर रहे हैं। टेक्नोलॉजी उस पर भी काम करे, लेकिन उसका फोकस हेल्थ सेक्टर की तरफ नहीं, कि हेल्थ की तरह उसको माना जाए, कोर सेक्टर मान के इसमें डेवलपमेंट किया जाए। टेक्नोलॉजी कहाँ विकास हो रही है? एआर टाइप पे, ठीक है, कैंसर का, एड्स का, जिस पे बहुत कम संख्या है, उस पे टेक्नोलॉजी में काम होना चाहिए, लेकिन उसकी संख्या मरीजों की कम है और स्वच्छता के अभाव में मरने वालों की संख्या ज्यादा है। उस पे टेक्नोलॉजी काम कर ही नहीं रही, और कर भी रही है तो उसे हेल्थ सेक्टर का मान के काम नहीं कर रही। एक बहुत बड़ा टेक्नोलॉजिकल इशू ये है। दूसरा जो टेक्नोलॉजी का इशू है वो विमेंस के क्षेत्र में है। फेमिनिस्ट जूरिस्प्रूडेंस के अंतर्गत जितना भी टेक्नोलॉजी विमेंस के लिए डेवलप हुआ, चाहे वो सेरोगेसी का हो, एवार्सन का हो, वो सारा टेक्नोलॉजी महिला को महिला बनाने से दूर ले जा रहा, और महिला की वर्ल्ड वाइड सिर्फ एक ही यूएसपी है कि वो माँ है, और जिस दिन उससे ये छिन जाएगा उस दिन वो मार्केट में होगी। टेक्नोलॉजी उसको उस तरफ ले जा रहा। फिर एक दौर आएगा कि कोई ये नहीं कहेगा कि मैं 9 महीने आपको पाली थी, पेट में रखी थी, आपको पाल पोस के बड़ा किया। टेक्नोलॉजी से वो कस्टमाइज बेबी पैदा होगा, और वो जो चाहेगा, जिसके पास पैसा होगा वैसा होगा। शाहरुख खान साहब के पास एक बेटा है। तो टेक्नोलॉजी एक महिलाओं के लिए तो बहुत डेंजरस सिचुएशन खड़ा करने वाला है, लेकिन टेक्नोलॉजी से हम आप बच नहीं सकते। कोविड का दौर आया, अगर आपको कोविड से बचना है तो डिजिटल सर्वेलांस में खुद को रजिस्टर करना है। अब उस डिजिटल सर्वेलांस में आप अपना जान बचाने के लिए आते हैं, तो उसका कितना उपयोग होना चाहिए और कितना दुरुपयोग होना चाहिए। लॉ का रोल यहाँ पे है कि एक ऐसा लीगल मैकेनिज्म डेवलप हो कि जो भी टेक्नोलॉजी हो वो पब्लिक सेंट्रिक हो, स्टेट सेंट्रिक ना हो, उसका सर्वेलांस करके स्टेट फायदा ना उठाए, पब्लिक हेल्थ को प्रोटेक्ट करने तक हो, तब तो वो जो टेक्नोलॉजी है वो पब्लिक हेल्थ को फायदा पहुंचा सकती है। और टेक्नोलॉजी का डेवलपमेंट जो हेल्थ सेक्टर में है, अभी उसका जो दृष्टिकोण है, वैक्सीनेशनलिज्म से आप सभी लोग परिचित हैं कि वैक्सीन का डेवलपमेंट हुआ, वेस्टर्न वर्ल्ड ने अपने लिए आरक्षित कर लिया, बहुत सारे देशों को दिया नहीं, भारत में डेवलप हुआ, बहुत सारे देशों को दिया गया। तो ये सारे टेक्नोलॉजी, चूंकि हेल्थ पूरा वैश्विक स्थिति है कि सभी मनुष्यों का हेल्थ सुरक्षित होगा तभी ये वातावरण चलेगा। जो भारतीय दृष्टिकोण में कहा गया है, सर्वे भवन्तु सुखिनः, सर्वे सन्तु निरामया, सर्वे भद्राणि पश्यन्तु, जब इस दृष्टिकोण से हेल्थ को उसमें शामिल करके सारे सेक्टर को हेल्थ से रिलेट करके टेक्नोलॉजी का डेवलपमेंट होगा, तब राइट टू हेल्थ प्रोटेक्ट होगा। थैंक यू।
Thank you, Professor Dr. Jaiswal, for linking the health with the technological issues. So, of course, the points which you have raised, they are quite important, and I hope that policymakers will take cognizance of all this. Thank you so much. Now I invite Mr. Abhishek Majumdar, who will be talking on the conundrum of healthcare data privacy in India and analysis in terms of existing legal framework. I do wish that if we are talking about the international health law, we should relate our presentation with the international framework also, if you have any points. Kindly make your presentation in 5 minutes.
Let it be.
Good afternoon, esteemed chair, panelists. As Madam Chair has said, I could actually relate this to the international perspective, but that would take a lot of time, given that healthcare law in itself, when pertaining to India, is a very big framework. Now, of course, if I were to talk of the international perspective, it is the GDPR from which the data protection bill has been taken out of, or rather inspired, and on the other part, it is the HIPAA, which is the equivalent of United States when it comes to protecting data healthcare in India. Having said that, let's go on to healthcare data protection in India. First things first, there has been a stark differentiation in terms of the what we see and what we think of this particular topic, pre and post pandemic. Post pandemic, there has been a total need, or rather a shift to look at data healthcare and to look at digitalization of independent medical records. But it comes with its fair share of challenges. Now, to quickly jump on to the challenges, I would just share a statistic. Your data or your digital data consists every parlance of your independent identity, which is supreme to you, which is sacrosanct to you, right from your sexual orientation to your diseases, to what constitutes you as a person in terms of your health diagnosis. That is your health data. Now, when it is stored in anywhere over the server or anywhere like in a computer database, it is open to cyber attacks. Why I bring this to the topic is because we do not have a particular mechanism which provides for protection of data from digital healthcare currently. Now, to give you a brief statistic, in 2021, India ranked as the second most cyber attack prone nation in terms of healthcare cyber attacks, contributing to 7.7% of the total cyber attacks in the world. that is a whooping number. Let me just go on to what it entails. Now, when you go to a hospital, the first things which need to be given for your identification is an Aadhaar card, which is the primary document for your identification. It is stored at a local database with the particular institution, medical institution, be it public or private. But then again, what is the back-end firewalling system? What is the back-end system for providing protection of this digital health data? Why I bring this to the forefront? It's very obvious. Recently, a US cybersecurity firm, CloudSec, has stated that an attack from China compromised 68 lakh details, or 68 lakh independent details of these particular patients. And would you like to know the average cost of a single stolen file? It is $380 per single healthcare record. It is the highest across all industries. So I would quickly now come to the legal part of it, and of course you understand the importance of it. This is a brief judgment on confidentiality. It was given by Kerala High Court, wherein they, during the pandemic itself, they came to the conclusion that whenever a third party stores or is going to forward or express a particular kind of healthcare data, it needs to be anonymized before being shared with a third party and under explicit consent. When the consent is withdrawn, the data should not be processed or kept with that third party. However, whether it is being happening or not, that is it is open to debate. When we talk of the legal framework, there is currently, Information Technology Act, which is the primary act, the rules thereof, Digital Information Security in Healthcare, or the DISHA Act, and the other one is just a bill, the Data Protection Bill. The SDPI rules, or the Reasonable Security Practices and Procedures and Sensitive Personal Data Information rules under the Information Technology Act give sanctity to data protection in India. However, they do not fall sufficient. I'll tell you the reason why. The chunk in the armor of SDPI rules, so as to say, is that it does not provide any definition to health data, or health data processor, or health data controller. Similar is the case with Information Technology Act. It does not provide a definition to this. The Data Protection Bill as it stands today is also not a way forward, but a way away from the 2021 Act, in the fact that it also is not talking about sensitive health data information. It has just clubbed the data protection into a single rule of what constitutes health data, or what constitutes data. Nowhere is it mentioning healthcare data. However, what is this is my concluding remark, what is the way out? When we talk of data or data protection or privacy in India, we, especially in healthcare sector, we tend to put too much focus on data protection law, that is still a bill. But we do not give any regard whatsoever to something which has already been passed. Not just enacted in the parliament, it has been passed. It is an act, but does not enjoy execution right now. It is Digital Information Security in Healthcare Act 2018. It is India's HIPAA equivalent, which I talked of earlier. It's Health Insurance Portability and Accountability Act in US. And this particular
Conclude.
Yes, ma'am. This particular act of legislation gives sound understanding to data protection in India. However, it is still not executed, and that is the crux of the matter. Thank you.
Thank you, Mr. Majumdar. Really giving some insight on the data protection related to healthcare. Now, I call upon Dr. Dhubri Pradeep. Dr. Arushi Batra. Dr. Arushi Batra will be talking about the silence of right to health to bridge gaps in the performance of sportswomen. I think she has a lot of interest in sports.
Good afternoon to all. So I am here before this panel who specialize in health law, primarily because my interest falls in sports law as well as somewhat in health law. So I'll be talking about the health rights of sportswomen over here and how they can optimize their performance by taking care of their health. So we know presently our life over here today in the modern day life is marked by sedentariness, automation, technology, computerization, and what we have ended up is like that we keep on sitting hours before our laptops or TV, and that is what we have become actually. To relieve this has, ultimately, brought a lot of stress into our lives. This ultimately, to relieve this kind of stress, sports is one such thing which helps us or which play an important role in relieving this stress. Now, sports with its important qualities like team building, leadership, fair play, and overall personality development in an individual has played a massive role to develop an individual. It has played, an important role in everyone's life, be it male or female. Now, when I talk about sports, what we have thought about it, it has been a male bastion for a large part of our lives, at least my life, so I know for everyone's life over here. But in the last 40 years, what we have seen, there has been remarkably an increase in participation of women. And especially in countries like US, Korea, China, there has been an increase in the medal tally when it comes vis-a-vis the participation as far as their male counterparts are concerned. Now, this picture might seem rosy to you, but still there are challenges when we talk about, particularly with respect to the health issues. And health becomes one of the major challenges because that's often an ignored area, especially for women, and more so in case of elite sportswomen. Now, right to health, we have all seen it has been recognized as a fundamental right at the global level by the preamble of WHO, that attainment of highest possible health care is the fundamental right of everyone. It has been read under Article 21 as the fundamental right itself. But still there have been, what actually has been done for the right to health of sportswomen, that is what I can give an insight into. And how can we optimize the healthcare for women? Now, let's have a look at the challenges which sports women feel and how can we, or what we can do as a society to bridge those gaps to optimize their performance. So first of all, when we talk about, optimum performance, or when we talk about, what are the kinds of, talking about the body structure, the first problem is with respect to the anatomical difference between a male and a female body. So anatomically, physiologically, female bodies are made different. Even if we talk about adolescent girls, their body structure is different in a sense they accumulate more fat and less of muscle mass. So they are more prone to the ligamentous or sprain injuries, which are less in the male athletes. So adequate nutritional support and some kind of training is needed, extra training is needed. Similarly, the second challenge which is there, not only in India and across the globe, is the problem of sexual violence and sexual harassment. It has been largely rampant when we talk about the problem of sexual harassment, how deeply it is rooted, and most of the parents, how hesitant they are to send their daughters to the field just for the sake that their daughters could get harassed or sexually, sexual abuse could occur to them at the hands of the coaches itself, or by their male peers, or anyone else, anyone in the administration. So for this, what can be done? There could be prudent policies. Clinicians can give them proper sensitization, and many other things. For instance, POSH is applicable since sports stadiums occur within the definition of your workplace. So certain things can be done, because ultimately sexual harassment is one thing which is not only affecting the physical health of a woman, it is also impacting the mental health of a woman. Most of these players ultimately drop from the game altogether. The third problem which occurs is the problem of menstruation, which is impacting their health. And we know the problem of periods is not just painful, it is a taboo word even today. And there have been situations, as per the survey which occurred in 21-22, which was done by BBC, there have been 60% of the respondents which have confessed to it that they have some point in time missed their training owing to the menstrual cramps. And apart from the pain and inconvenience which is caused by it, there are other issues like a white dress, or the cramps, or the lack of sanitary bins which are there, a lot of running on the cricket field, which make it very difficult for the women to just bear with the menstruation and play all through days. And the saddening part is, to regulate it, the women have to use hormonal pills, which have its own side effects like anxiety, mood swings, weight gain, headaches, and so on. So ultimately it's the, altogether it's causing loss to the women only. So she has to choose between the play, or whether she wants to go ahead with the game, or whether she has to, drop altogether. And finally, the problem comes with the married female who have to balance their personal and professional life with, when they have to deal with the pregnancy and the postpartum stress. So that becomes, but we have seen the challenges of, we have seen the challenges, we have seen challenges like Serena Williams and Mary Kom and other players who have, actually once they have come to, they have come to the field after giving birth to their babies. So, yes, ma'am. So this is to conclude, I would like to say, even though we have challenges, but proper sports medicine, nutrition support and policies can, improve the health of women altogether and actually bridge the gap and enhance the performance of the women. That's all.
Of the highest attainable standard of health. So now I call upon Dr. Abhijit Dere. He will be talking on the need of transnational efforts for road safety rights under international health law regime. So now we will hear something about the international regime, health regime.
Good afternoon, everyone. I'll be talking on need of transnational efforts for road safety rights under new international health law regime. My contentions are, I'll be just briefing it out, and this is the scheme of presentation which I had prepared, but I think I have to skip few slides and I'll come directly straight to the point, that whether we need road safety or we need to identify road safety as a fundamental rights as far as our constitutional frameworks are concerned, and then parallelly, we have to think of, whenever we are thinking about the global international health law regime, we have to think of road safety separately. As of now, we are losing many lives, like the numbers show 1.3 million lives we are losing every year. These are all data collected from WHO, and WHO is rigorously working for the road safety rights and awareness and advocacy. So the fatalities which we are facing are creating again a huge loss to the nation as well as to the families, and as well as, again, this is going to hamper the global development. And that's why I want to raise the concern that road safety is a global issue, and it is a global health issue, public health issue, which we need to address at the international level also and at the national level also. So these are the data related which I have referred for this particular paper. So there are multiple resolutions passed at the international level. So most importantly, General Assembly resolution on road safety, which was passed by General Assembly, UN. Then there are, as ma'am has mentioned, World Health Assembly reports, resolutions are there. Global status reports are there. Till now 4 reports have been published by WHO. Then country profiles have already been prepared. And then research work had been done by WHO, GRSP, and BIGRs, and many other organizations which are rigorously working to establish road safety as a matter of public concern, public health. Yeah, these data I have already mentioned, and one thing I want to just highlight that 91% of world's fatalities on road occur in low-income and middle-income countries, which have only 48% of world's registered vehicles. So this is a cause of concern which we have to think of. And again, the most vulnerable road users are pedestrians, cyclists, drivers of motorized two-wheelers. Then, as I said, road traffic injuries have a serious impact on national economies, costing countries 3% of their annual gross domestic product. So, it is a 7th leading cause of death, road safety, in low-income countries, and 10th in upper middle-income countries. So the thing is that whether road safety is like we have, whether I don't know, the panel is more elegant on that, like they can throw light on that, whether we call it a pandemic or whether we call it endemic or epidemic, whatever. But the thing is that it is a cause of public concern. So 7th leading cause, and that is something which is preventable, completely preventable. That is our contention which we want to place it for. This is just the timeline how and when the efforts have been started, 1966, and they are still continuing. And road safety rights have also got the place in SDGs. These are the data which I had collected through questionnaire circulated to the experts. So most of them, they have agreed to the efforts, that efforts should be taken at the global level whenever it comes to a recognition of road safety rights as a global health perspective. And through the suggestions what we have received, like what is the solution for these things and how to go with road safety, or how to establish road safety to be a part of public health and global public health. So these are the safe system approach we had adopted under the aegis of WHO. So it talks about death and serious injuries are unacceptable, humans make mistake, humans are vulnerable, responsibility is shared, safety is proactive, and redundancy is crucial. So we talk about safer vehicles, safe speeds, safer roads, post-crash care, and safer people. So this is a safe system approach. And then what are the probable solutions for this? Through this paper I have come out with global best practices should be discussed and they should be promoted. Nations should be encouraged to follow the same. Vision Zero model, which had been advocated by Sweden for the first time, and now many countries, many states, they have coming up with this particular model. So we have to think like whether WHO, under the aegis of WHO, can we go ahead with the Vision Zero kind of policies. Public awareness, civil society initiatives, and transnational efforts are needed. These are all, again, as I said, how to call, what to call it is again open for debate. There is a very important UN initiative, that is Roads for All. So we have to think, whenever we are thinking about road safety, we have to think of all. Goal 3 of SDG, and then 3.6 target talks about 2020 we have to half by the deaths occurring on roads. Now it has been extended to 2030. And yes, ma'am. And the goal 11 talks about sustainable cities. So these are all the concerns which I wanted to raise, and we have to think of road safety because all of us, we have to come on the roads and there's no option to it. So that's why we have to think of road safety as a right, as a fundamental right, and we have to initiate some actions globally for it. Thank you for the opportunity.
Thank you, Dr. Dhire, for raising such an important issue, and that road fatalities, I mean, that is about 7th leading cause of death, I mean, in the world. So this is where the international community should take, our world community should take some action. But I wonder that local conditions may be different, so that has to be taken into account. Now, I don't know who was there. Dr. Amrita Verma. Dr. Amrita Verma is Dr. Amrita Verma will be talking on the unpenetrated practice, vaccine nationalism, changing right to health.
Very good noon to all of you. Today I am talking about unfettered practice, vaccine nationalism, challenging right to health. As time is running short, I will summarize my points quickly. Let us begin with what is actually vaccine nationalism is. Vaccines are the best chance to control the pandemic unless leaders succumb to vaccine nationalism. Vaccine nationalism is a frequent recurrence, especially during a brand new market distribution. It is also an economic strategy to hoard vaccination from manufacture and increase supply in their own country. The aim is to stock up and vaccinate the nation as soon as possible, regardless of the limited vaccine manufacturers' distribution for the rest of the world. High-income countries put their money in beforehand for many vaccine stocks, which hinders the manufacturers' ability to supply globally. The vaccines that wealthy countries pay for are enough to vaccinate their whole population twice or thrice, manifesting it against the global promises of equitable supply of vaccine among low and middle income countries, thus establishing the bias towards the population of all over the world. It leaves unprivileged countries with a lower economic status to struggle in paying dues for vaccinating their population as the prices inflate over the time. It also decreases the opportunity for developing countries to access supplies as they would be relatively out of stock. Thus, the risk of this recurring appears to be favorable with the crashing economies and exacerbating death rates. Nevertheless, the pertinent issue here is that once the vaccine is available in the market for public consumption, it should be distributed equitably among the nations without any necessity to negotiate its supply with high-income countries, governments, and relevant stakeholders such as multilateral organizations and pharmaceuticals. Irony associated with the situation is that high-income countries decided to invest in the stock of vaccinations instead of spending that money for immediate capacity building and delivery of life-saving drugs by healthcare system. Though it is not a new phenomena and has been maliciously practiced by several high-income nations during previous health crises, the prioritization of one's population is understandable. However, the method by which it has been achieved is deemed morally and ethically deplorable. It was not to aid ailing humanity at minimum cost, but to sell their product to other countries for a strong financial stock uphold. Another adverse effect is the ability to vaccine nationalism to stretch the duration of pandemic further. Consequently, there will be an increase of diseases, adverse outcomes, and the overload of already overburdened health system. Vaccine stockpiling will eventually be self-defeating, as evident, although most vaccine doses were administered in high-income countries, according to the study conducted by researchers based in Oxford. High-income countries such as Italy, France, and UK reported almost 1 million extra deaths than projected by epidemiologists. Better medical infrastructure, availability and accessibility of rapid testing, data reporting, transparency, and prevalence of underlying diseases, coupled with prevalence of majority of elderly population in geographical condition, can be the cause of more deaths in high-income countries. To control the pandemic, it is necessary to create COVID-19 communal immunity, thus reducing the virus ability to transmit across population. A large section of population must be vaccinated against the disease. To achieve this, the WHO estimates that pandemic effects may be not subside until a significant section of the global total is vaccinated. The pandemic will exacerbate already fragile health system and economies in underdeveloped and developing countries. To tackle vaccine nationalism, it is essential to develop a science-based strategy and mobilize an international collaboration and collective effort. The majority of global policymakers have limited role in managing health economics and not directly involved in clinical aspect of countries' healthcare system. Instead, the inflow of capital is controlled by finance ministries and disbursed by health ministries. This disjoint between the funds and allocation of the resources are misleading. Thus, the root of the problem is the supply versus demand mismatch in COVID-19 vaccines, which is an economic issue. Finding a solution to vaccine nationalism is a matter of adjusting the moral compass and supporting issues, supporting justice. While there may not be a straightforward solution, it is definitely not an impossible pursuit to back vaccine equity for all the nations. Thank you.
Thank you, Dr. Batra, Dr. Verma, for the unfair trade practice. So you have said the equity or equality should be there, that there should be vaccines should be distributed to all nations and to all persons. But you see, as a matter of fact, trade and charity, they cannot go together. So those you have, we should also look into the IP rights, and there are so many other laws, agreements which the countries have agreed, so they have to be taken into account as well before, you see, laying down the new rules. Of course, they do. So,
since Dr. Verma has raised a very important point, and you dealt with something very important, just to add to what she has said, actually when the vaccine distribution started, we had a time lag in WHO for almost 4 to 6 months because of the ministries of health not agreeing or not knowing what to do with indemnification clauses in the agreement. Because what happened was that, as I mentioned in my opening remarks, there was the crunching of the clinical trials that took place. So all these major vaccine manufacturers, AstraZeneca, and which was the Covishield from Serum Institute, and the other vaccines like the BioNTech Pfizer vaccine, they said that we have not done clinical trials like we were supposed to do for vaccine development. We have done clinical trials in a crunched fashion. A vaccine comes onto the market after almost 12 to 14 years of clinical trials. We are doing it in 2 years. So the governments must sign an indemnification clause. So we have to be indemnified if somebody dies because of the vaccine, because we have not conducted the whole clinical trial. We are doing the best we can in these emergency situations. So please sign those clauses. And neither at WHO nor in the countries was there enough legal expertise to actually sign these and to understand what these clauses were. And this was also complicated because we had to link each vaccine dose which was given by a nurse to where the manufacturer was. So the barcoding, the TBT agreement came into place. So there were many other things which are important. So to add to what Dr. Verma said, that you have dealt with a very important subject, but I think to give it a holistic view, some of the points that she has raised are very critical.
Thank you. And now we have, I think we have our last speaker with us, and that is Dr. Talukdar, who will be talking about the Alma Ata to Astana, Pledge for Primary Health Care.
Good afternoon all. I am here to present the paper on Alma-Ata to Asthana Pledges for Primary Healthcare. When we are talking about right to health, healthcare, everything has to be on the basis of its spreading or its availability to the urban people along with to the rural people. And in case of rural people, the primary healthcare sectors is the most important mechanism which addresses the healthcare needs of the rural people. So my paper deals with the most important aspect of rural healthcare, that is the primary healthcare available to them or not. The conceptualization of primary healthcare, whatever the World Health Organization done till date, has various aspects, I can say that one, but among that one, 4 major aspects are there. That it should cover the whole society approach to health, number 1. It should ensure highest possible level of health and well-being, equitable distribution by focusing people's needs, and not include only health promotions or disease prevention. Rather, it also include treatment, rehabilitation, and palliative cares also, and other aspect of curative healthcare within its ambit. Now, in my next slide, whatever I have tried to give an wholesome theory or wholesome approach that has been taken by international healthcare, international law, to address right to health within various instruments. As we all know, the primary recognition came in UDHR under Article 25. Rather, the most binding enforcement under Article 12 of International Covenant on Economic, Social and Cultural Rights. That is the cornerstones of recognizing right to health under the international law. Though afterwards that in Millennium Development Goals and Sustainable Development Goals, various right to health aspects has been taken care of. If I talk about the Millennium Development Goals, though there is no specific regarding right to health, rather they have addressed 3 major aspects: reduce child mortality, improve maternal health, and combat HIV, AIDS, malaria and other diseases. That is the primary goal set by in case of Millennium Development Goals. Whereas in case of Sustainable Development Goals, we must remember Goal 3 is the unique goal that is clearly mentioned health and well-being within the periphery of Sustainable Development Goal of 2030, which should be achieved by 2030. And it has also a connecting goal, that is Goal 6, clean water and sanitation, that dealt with that is very important for securing right to health also to the people. Now I come to the Alma-Ata Declaration. Why I have chosen this declaration? Because this is the 45th year of Alma-Ata Declaration. 45th year of, this is the 45th year of Alma-Ata Declaration. And now we should judge whether we have done enough to combine or to accomplish the goals set in the Alma-Ata Declarations or not. The goals which have been set in the Alma-Ata Declarations with regard to primary healthcare goals, it has various other aspects, like in the next slide I have done this, that it categorically specifies the responsibility of the government to formulate national policies, strategies and plan of action to launch and sustain primary healthcare as an important part of comparative national health system. And the second one is the most important one. Primary healthcare should be universally accessible in a manner the community and country can afford, and should bring healthcare as close as possible. This is important. Access to healthcare, we are always talking about access to healthcare. It's not that healthcare is available in India or not, but it is whether accessibility is there or not. Because a person who is living in a hilly area, he has to travel for a day to get the access. This is the scenario in India. In many parts of the world, that the scenario remains. So we should bring the healthcare as close as possible to the people. Now, in the next slide, I have tried to highlight 8 essential components of primary healthcare which has been highlighted in the Alma-Ata Declarations. Number 1, health education on the prevailing health problems. Number 2, nutritional promotion and including food supply. Number 3, supply of adequate safe water and sanitation. Number 4, maternal and child health care. Number 5, immunization against the major infectious diseases. Number 6, prevention and control of locally endemic diseases, appropriate treatment of common diseases and injuries, and last is provision for essential drugs. So these are the 8 essential cornerstones for primary health care as recognized by the Alma-Ata Declarations. Now I am coming from the Asthana Declaration. Why I have come to the Alma-Ata to Asthana? Because Asthana Declaration is the declaration which has been which has been adopted by the global arena under the international law and promoted by the World Health Organization and UNICEF on the basis of 48th anniversary of Alma-Ata Declaration to reaffirm the pledges of Alma-Ata Declaration. In Asthana Declaration, it has clearly mentioned three things. Sustainable healthcare. The prior session which we were holding over here, they're talking about sustainable development. Asthana Declaration for the first time recognizing sustainable healthcare under the international law. Along with it recognizes that not only what the Alma-Ata Declaration says, that it should have a clear impact on the healthcare or disease, infectious diseases or endemic diseases. It also talking about the vaccination, screening, prevention, control and management of communicable and non-communicable diseases, care and service that promote, maintain and improve maternal, newborn child and adolescent health, and mental health, sexual and reproductive health within its ambit. Now, just 2 minutes. Now, in the next slide, I have made a differentiation or have a comparative study on Alma-Ata and Asthana, what the development has been done. The primary recognition in Alma-Ata was that comprehensive national health system, whereas in Asthana Declaration, it is a commitment for sustainable health system for universal health coverage. This is the major aspect change has been done from Alma-Ata to Asthana. Now, in the second one, there is no recognition of social well-being in Alma-Ata Declaration. But as World Health Organization defines health as a not only the mental health, physical health, rather the well-being part of the health was there, that has been recognized in Asthana also. And the last one, I just mentioned the last difference, that addresses the main health problems in the community, that has been done in Alma-Ata. But in Asthana, we are not only communicating or limiting within that period. What we are doing, promoting, maintain, improve maternal, newborn child, sexual, reproductive health within its ambit. So the ambit of primary healthcare has been increased through Asthana Declaration. Now, I have just gone through the Indian perspective of this one, how India responds to the primary healthcare needs. In case of Alma-Ata, by adopting 1983 National Health Policy, India responses. Whereas in case of 2017 health policy has though not in parity with the Asthana Declaration, but it contains most of the pledges that has been given in Asthana Declaration. Now come to the major issues. What is the major issues with regard to the primary healthcare goals? Growing population and overburden situation of sub-centers and primary health centers. Number 2, lack of availability of doctors and medical professionals in primary health centers. Less of budgetary allocations in the development and establishment of primary health centers. Increase in out-pocket expenditure in screening, access to healthcare and lack of access to essential drugs, unequal assurance to the health needs in rural and urban areas, lack of international collaborations with regard to and lack of binding forces with regard to the World Health Organization's recommendations. I have given various suggestions. I just mentioned 2 or 3 of them and conclude the paper. Number 1, increase the budgetary allocations. Because after COVID, it should be done. We have already gone through the very bad situation and affected by them largely. What I like to mention, encouragement to the NGOs for ensuring healthcare access and access to medicines, access to drugs. And last one, but not the least, building international cooperation through active participation of all the countries and developed nations should provide aid for research, technology in case of underdeveloped and developing countries. Thank you, ma'am.
Thank you, Mr. Tanukdar, for at least, you have brought something international, that though it is a declaration, which is not per se binding, but you see, I think it has really laid down some framework for the primary health care for all the nations, those who have voted for it or those who have not voted for it over the period of time, because since 1978 to this day, that is there, so it will become a sort of a customary law and the countries should follow it. I'm really sorry because so many our speakers which have worked very hard could not get enough time to make their presentation because of the paucity of the time. Now, even though we have went into we have gone into our lunch time. Still, I request, if any of you have any question for the next 5 minutes, I mean, we can take those questions. Any question, anything? So that means everybody is hungry and looking for the lunch. So, yes. Sorry, can you repeat it again? Yeah, I think, as I told in the beginning, that is, it is now COVID-19 vaccine under the TRIPS agreement, because I mean they have agreed to give the waiver for the next 5 years from the IP, I mean the patent. Yeah.
Yeah.
We have an expert.
Yeah. So there. Yeah. So there is a lot of debate, as you rightly have pointed out, in the global press and also in the national press, which is looking at how effective the COVID-19 vaccines were. And it is still, there are a number of papers and a number of longitudinal studies also that are going on, not only in terms of the effectiveness of the vaccines, but also on the long-term impact of some of the vaccines. As you know, that normally vaccines are produced through an egg-based cell technology. So what they do is they inject it into chicks' eggs, and then the virus, and then that attenuated virus comes from that, and then we have the vaccine. This is the first time the mRNA technology was adopted by Pfizer, and this is a new technology, and it is going to absolutely revolutionize the way vaccines are being produced. So it is necessary to look at the safety, QSE, that is our code, the way we say quality, safety, and efficacy of the COVID-19 vaccines has to be reaffirmed in terms of many studies. So as I had mentioned in my opening remarks, the US FDA has already published a paper on that, and every FDA is looking at the effectiveness of the vaccines and how best did they perform. Be that as it may, it stands to reason that the pandemic did go with a lot of emphasis on vaccination. So each country and each national government is actually looking at their own dissemination of the vaccine and rollout of the vaccine among their population. As of now, it is still work in progress. And a lot of what we are talking about and what has come out in the press is also being included as part of the discussions which are there for a long-term pandemic treaty in WHO. We also need to bear in mind a little bit that a lot of these WhatsApp messages which have come to us, to our notice in WHO, is they are also morphed messages, where there were different companies and their people are put in different situations. Some of it is, so there are issues in terms of the open source communication and social media also, which we need to bear in mind. But this is still in detail some work in progress. I hope I have answered your question.
Yes, one question only we will take. No. Yes.
So that's a very good question, and I mentioned it in response to the vaccine paper that was here also. What had happened in WHO was that once these vaccines were produced, as I mentioned, we actually had those days were very interesting. Every week to begin with, And then every fortnight, all of us were part of a group all over the world, and we were looking at the latest vaccine information and the rollout of the vaccines. And the reason why UNICEF was set to roll out the vaccine is because UNICEF had a very good vaccine rollout system. They were already into child vaccine rollout. WHO was not into child vaccines where they had the last mile. And WHO established what was called the COVAX, the COVID vaccine facility, which was looking at the dissemination of vaccines. So in this process, when the vaccine was ready for rollout, and in fact a month or so before, they had to produce large volumes because why did BioNTech, as you all know, is a very small company. 2 Turkish young doctors, they are behind that technology, but they licensed their technology through, as Dr. Surinder mentioned, through the patents. They licensed their patents to Pfizer because Pfizer had the wherewithal of a global rollout. This little company could not do a global rollout. So when they were ready for that, then Pfizer and other companies, AstraZeneca and through the Serum Institute, they started asking WHO exactly what you said, that as I mentioned, that we have crunched it, so we have to move it out. So we need to sign the indemnification clauses. So because what the clinical trials showed was that overall the vaccine is effective. But if somebody has some morbidity and you have some prior disease tendencies, then it was not clear how effective the vaccine would be. And a second major difference was, for the first time we were giving vaccines to adults. इससे पहले कभी बड़े लोगों को वैक्सीन नहीं दिया था, बच्चों को वैक्सीन देते थे. Whether it was unheard of to give, or you gave it to expectant mothers because they were bearing children. So this is the first time that the above 80 and the older population was segmented out for early vaccine delivery. So at that time they were looking at these indemnification clauses, and as I had mentioned to you, there was no legal acumen with the ministries of health and also with WHO to understand what that meant. And each vaccine, if a person on the X health facility had a problem, that particular vial had to be related back to when it was manufactured. So we had a lot of work to do on the RFID and the barcodes, and this was a continuous debate, and it's still work in progress. We didn't get 100% because those big vaccine containers had to be reduced to this much of a vial, because once you open the vial, it's gone. So you had to actually do that as well. So there were a lot of issues in terms of the rollout. So to answer your question in a different way, that this was a work in progress at that time, and each national government in their national law has given their own response to the kind of indemnification that they would admit to this. And one of the issues which this young girl raised was that there was lack of vaccine nationalism, because what happened was that the rich countries were already ready with all of this. They had the acumen to look at those clauses. We had a tough time to understand it ourselves, and you can imagine that some of the smaller countries like Bhutan in my region, or Maldives, these countries and in Africa, it was a real debate how to understand what is happening and what do they really want us to indemnify. So these are some of the things that became very important. Sorry, it was a long answer.
No, it's okay. I think with this we conclude this particular session, and I thank my...
Yes. Can we take it outside? Yeah.
We will take it outside. Yeah. Yeah. So I thank the panelists, all of my speakers, learned speakers, and to my most close friend, Manisha ji, for giving us the insight into the problem and clarifying many issues. I wholeheartedly thank her, and I thank all the other those participants who are participating here. So thank you very much, and with this we conclude this particular session.
Thank you so much. On behalf of Society of International Law, we thank you for taking up your time for chairing this session, and Manisha ma'am also for such an enlightening discussion here. Thank you so much. And all the panelists also for live presentations. Thank you. Now kindly join us for the lunch upstairs on the second floor. Thank you.
Good afternoon to all of you. Welcome back to the session Azadi Ka Amrit Mahotsav, 75th anniversary of the India's independence, India's state practice in public and private international law. For just a small announcement, India's engagement in international law with South Asian and European nations, that session is being upstairs. So the panelists of that session kindly go to the room number 2044. In this parallel session, session 8, which has been dedicated to Azadi Ka Amrit Mahotsav, 75th anniversary of India's independence. This session will be chaired by Professor Monica Chawla, Head Faculty of Law, Punjabi University, and she is also Executive Council member of Indian Society of International Law. There is a small change in the keynote address. Ms. Uma Sekhar, Additional Secretary, Legal Entity Division, MEA, could not able to come, and at a very short notice, Society has requested C.M. Koteshwar Rao sir, who is a former Secretary General and also legal advisor to the MEA, presently a consultant at MEA, agreed to give an introductory remark and share his views on this important topic. Just to check that who are available among the panelists, Sri Anil Malhotra sir is with us, Dr. Bhumika Nanda is along with us, Mr. Sasank P. Kumar is around. Monica ji, kindly rub that one. Sasank P. Kumar, Kshitij Nalkande, not available. Dr. Gurpreet Singh is along with us. Mr. Sanjay Kumar, not. Now I am handing over session to Chair Professor Dr. Monica Chawla and Sri M. Koteshwar Rao sir to take.
Thank you, Vinay. Now I start with the session Azadi Ka Amrit Mahotsav, 75th anniversary of India's independence, India's state practice in public and private international law. I call the first speaker Shri Anil Malhotra, Life Member, and Ankil Malhotra, to present a paper on India's state practice in cross-country interparental child removal. Okay, please, okay. So I invite Mr. M.K. Rao from the Legal and Treaties Division. On behalf of Ms. Uma Shekhar, she was supposed to be here, so he's going to present.
Yeah. Thank you very much, Professor Chawla, for giving me and also I thank Indian Society of International Law for giving me this opportunity. In fact, as said by Vinay, I am representing the Additional Secretary of the Legal and Treaties Division, Ms. Uma Shekhar. Unfortunately, she is not available. I think she is busy with the Indus Water Treaty, where the World Bank has referred the disputes between two disputes, Ratlam and Kishanganga, to a neutral arbitrator, which is taking place in Washington, D.C. The other process, legal process, arbitration process in The Hague. The Hague panel held Sheen Murphy, Professor Murphy, who is International Law Commission member, they held a preliminary meeting where India did not submit any, they raised a preliminary objection. So it's going to be considered in the next 3 months. So it seems she is busy with that. So unfortunately, but I did not prepare anything because this is the India's practice of international law. I saw the list of speakers and their topics. I'll just say a few words briefly so that our expert Malhotra ji and other experts will take over. And as I saw, the first speaker is Mr. Anil Malhotra, senior advocate, and he has been extensively practicing in private international law. He is a prolific writer. While I leave the subject to him on the private international law, the specific topic, but I would like to mention on private international law, our former additional secretary, Mr. Narendra Singh, is here. During his tenure, India has become a party to the Hague Conference of Private International Law at The Hague in 2008. And also, we signed and we accessed to the 4 international conventions adopted by under the auspices of Hague Conference. I will just quickly give you the titles of these things. The 1961 Convention, this is the so-called Apostle Convention, 1961 Convention abolishing the requirement of legalization of foreign public documents. So you don't have to, one single public authority will be there. He sits in the Patiala House. Once Apostle signs it, that will be valid without any further authentication, valid throughout the contracting parties to this particular convention. The second is 1965 Convention on the service abroad of judicial and extrajudicial documents in civil and commercial matters. The third convention is 1970 Convention on the taking of evidence abroad in civil and commercial matters. The fourth one is 1993 Convention on Protection of Children and Cooperation in the respect to inter-country adoption. These are the 4 conventions which India has ratified for the first time during tenure, late 80s, late 2000, during the tenure of Shri Narendra Singh. And in addition to that, I see the topics that practice of international law, practice of India in international law, and other thing also I see there is someone is going to speak on the India's cases before the International Court of Justice. We have so far had 6 cases, including the last one, Jadhav case, and also the Italian Marinas case initially. So these are the 6 cases we had, and also last, but otherwise all other cases we are mostly respondent. In India, Pakistan, India, the first one is on Portuguese, the so-called local customary international, local custom that can be formed, that's the principle. And also I don't know whether the speaker has come about the India's position, critical analysis of India's position in the Russia-Ukraine conflict. Is the speaker is there? Speaker on this, Gurpreet Singh, you are going to speak. I keenly look forward to listen to him. But one thing I must, last time we had a conference here. Some of the executive members of the Indian Society of International Law, of course they're all professors, now they spoke condemning the Russia for the aggression, all these things. They spoke about humanitarian law, all these things. But basic thing what I think and the scholars should understand, there was an understanding between NATO and the Russian Federation soon after the collapse of the Soviet Union that NATO will not be expanded towards the east. And now the Soviet Union has become 15 countries, and some of the countries slowly joining the EU and also joining NATO. First of all, we must understand, is the oral agreement, gentleman understanding, is binding or not? I know under the law in the Vienna Convention, it should be in writing, but is it the ultimate law, ultimately binding law, binding? That one issue. There is another Budapest understanding that was also an understanding whereby Ukraine has given up its nuclear weapons. That also now they are insisting, that's also an element which has to be taken into account for any bilateral, any kind of settlement between Russia and Ukraine. Of course, it's not Ukraine which is fighting war. It's entirely the NATO countries, mainly United States of America. How could United States of America give 100+ billions of dollars? Is it for good for nothing? And Americans say always, there are no free lunches. So I think one has to understand beyond what's happening and the issues, and from that perspective one has to analyze the things. I am glad somebody is now going to prepare it, present it. I'm very keenly I'm going to watch. But otherwise I will, of course, with the permission of chair, I may keep any comments reserved. And I thank you very much for listening to me. Thank you.
Thank you, Rao sir, for the very wonderful introduction. In fact, you play a very pivotal role in India's movement forward. And I'm glad that you mentioned that India has joined the Hague Conference on Private International Law. We have signed the Adoptions Convention, we have signed the UNCRC, but the gray area is what we are going to talk about today. So friends, we are a corpus of over 30 million non-resident Indians. We live in more than 208 countries. We have huge cross-border migration. We are spread out all over the world. Our marital disputes have serious issues of rights conflicting vis-a-vis children are concerned. Now, when a child is removed across borders from one jurisdiction to another against the consent of the other parent or in violation of the rights of the other parent, according to Indian law, there is no wrong done. And the simple answer and reason is that the father or the mother doing so is a natural guardian, maybe Hindu law, maybe Mohammedan law, maybe Christian law, or maybe any other law. So because it is not statutorily defined as a wrong or an offense, either under the IPC or the civil law, we do not consider it a wrong. Now we are apart from 102 countries which are signatories to the Hague Convention on Civil Aspects of International Child Abduction 1980. This is a multi-country treaty whereby you create inside the country a body called a central authority which regulates the children, movement of children from country to country. And once a court order in a foreign jurisdiction is passed, it is accepted by a signatory country and subject to a judicial process, the child is returned. The situation today is no foreign court will allow a child to come to India when there is a broken marriage. Because they say if a child is going to India, the child will never come back. The Americans are very agitated about this because under American law, it's a federal offense under the UCCJEA. Most European countries consider it as a wrong. Now, the Hague Convention on Civil Aspects of International Child Abduction says that willful removal or wrongful retention of a child is when a child is removed against the consent of one parent, when the other parent is exercising parental rights by virtue of operation of law or by virtue of some domestic law of the country. Now, though it is called Abduction Convention, in the entire convention, the nomenclature is all civil because the intention is not to punish the offending parent who has removed the child. So where are we in this process? Our law is all guided by what the Supreme Court says. So from time to time, the Supreme Court has leaned in favor of child removal and sent back children on the principle of comity of courts. Justice Lukur, in a very vast judgment in Suryavadanan, went very far in saying theory of first strike, whichever country takes cognizance first, takes on. He coined the principle of jurisdiction of closest contact and comity of courts. A subsequent judgment by Chief Justice Deepak Mishra in another matter watered it down, did away with the theory of first strike, cut out comity of courts, and only left the principle of jurisdiction of closest contact principle intact. Now, thereafter there have been different views, but ultimately the Supreme Court has now started returning children. Two major shifts have been seen. Gender preference has been done away by the Supreme Court. You no longer can say, under Section 6 of the Hindu Minority and Guardianship Act, I am the mother, so the child's custody should go to me because the child is less than 5 years of age. Supreme Court says gender doesn't matter. And the next question which the Supreme Court has evolved is that if you have brought a child to this country and the child is habitually and permanently resident abroad, then the Supreme Court says it is in the best interest of the child to go back. Now, I have, because of the lack of a definition to child removal, arguing in the Delhi High Court and in the Supreme Court that we need to pick up the best interest of the child definition from Section 2, subsection 9 of the Juvenile Justice, Care and Protection of Children Act 2015. And happily so, the Supreme Court has done it. Why? We are a signatory to the United Nations Convention on the Rights of the Child. All the rights of the child in the convention have been incorporated in the JJ Act, which was amended in 2015. So per se, per force, JJ Act is not meant for juveniles in conflict with law or orphans or abandoned or surrendered children. They are meant for children everywhere. So this definition having been adapted, Supreme Court in a larger picture looks at the best interest of children, and if they find that the child's interest is more suited in going back, the Supreme Court has started openly now ordering that if the mother wishes to go back, it's her choice, we can't force her, but the children need to go back from where they came. Now, in this entire quagmire, we have an outdated, outmoded legislation, the Guardian and Wards Act of 1890, not 1980, but 1890. It is an antique piece of legislation drafted by the British to suit them, their own ends. And hopelessly, it looks at seeking single parent guardianship or single parent custody, which is in violation of all tenets of international law vis-a-vis children is concerned. The Law Commission in report number 257 in 2005, Justice A.P. Shah very exhaustively looked at amending the Guardian and Wards Act, the Hindu Minority and Guardianship Act, and bringing in concepts of shared parenting and joint custody. But the amendments have never come across. So what happens? A child is removed from a foreign country, brought to India, and the mother or the father who has removed the child rushes to the court, the guardian judge in a family court, to seek singular custody. The other parent follows with a foreign court order. So we are in a mess. One side is the habeas corpus and one side is the guardianship petition. And decisions vary. And litigation goes at a snail's pace. So it takes 2 to 3 years before a decision can be finally taken. Now in this big mess, the efforts, salutary efforts of people like Mr. Narinder Singh, as flag bearer of late Ramnivas Mirdhaji, who inculcated us and who was a very passionate person in amending family laws, we strive for India to move forward and take a path out whereby we can fall into a system of law. Now the question which I put to myself is, if we can do it in inter-country adoptions, why can't we do it in child removal? After all, we allow adoption of children, irrespective of marital status, to any person subject to his qualifying the adoption regulations. And we have a very systematic method of putting everything into place by CARA being the central authority to regulate adoptions, and everything is streamlined. Why can't we do it in abductions? What is the difficulty? Should we continue to have singular custody concepts? Should children suffer in silence? Should children grow up to be with single parents? Why cannot we take a call? I have been working on it for almost 30 years now. We got very close to it in 2007 when Mirzaji motivated, this was an international conference, and we had the Secretary General of The Hague, we had the Dutch ambassador, the British ambassador, and the Congress government agreed, but then the elections were announced, Parliament was dissolved, and everything fell back. But there was another development. I was an amicus for 12 long years in a matter removed from Punjab to England. This was a reverse removal. Before the judge demitted office, I gave him a report. We couldn't bring the child back. He referred the report to the government. The government in turn constituted a Hague committee, which was later known as the Bindal Committee. 6 honorable judges, 6 government officers, and I as a lawyer were in the committee. We did interviews for 2 years, talked to everybody, and we came out with a bill. That report and that bill hangs with the government. Again, we are back to square one. I think what we really need to do is we need to ask the Supreme Court in a given matter to lay down practice directions like we did in Vishaka. And over a period of time, it can happen that that will become a law. I, in 2 or 3 matters, was able to persuade the Delhi High Court and the Supreme Court to follow a mirror order principle. That is, if a High Court in India or the Supreme Court orders the return of children to a foreign jurisdiction, the order of the Indian court should be made a part of the foreign order. That is, mirroring the order. And with those sanctions which the Indian court requires for the spouse who has removed the children, those protections, the order can be incorporated in the foreign court order, and those protections can go across. The Supreme Court did it in Navtej Singh's case. It did it in Perry Kansagra's case. But Perry Kansagra refused to comply with the conditions. He has been convicted for contempt, and the matter hangs. But there is another bad side to it. Because we do not let fathers or mothers get access, the process of kidnapping has started. In Karan Goel's case, the father abducted his own daughter, went to Nepal, the US Embassy gave him shelter, and he smuggled the child out. We had Aman Lohiya's case, which I handled ultimately when he was brought back. He fled via Nepal to US, to Dubai, converted to Muslim religion, but he was brought back. So all this is leading from the frying pan into the fire. Should it go on? No way. When will the government make a law? We don't know. So I guess the only answer is, let the court lay down practice, Supreme Court lay down practice directions or some guidelines which uniformly get to be adopted and put in place. That's all I can say for the time being. Perhaps ISIL will be able to generate a momentum to make something going. And till then, we wait for the next conference. Thank you.
Now I invite Dr. Bhumika Nanda, Assistant Professor, Bennett University. She's going to present her paper on India and its practice. India and its practice in the recognition and enforcement of foreign judgment, a gender analysis of the conflict of law rule in the Indian context.
Thank you, ma'am, and thank you, sir, for your presentation. I know it is a long title. I was working on what to make it, but it's still in the process, and I'm thinking maybe later on can make it more concise. So as sir already stated that we do not have any guidelines so far as intercountry adoption is concerned, custody is concerned between the parents. What I was trying to do in the paper is that was trying to look at how the woman is placed so far as private international law is concerned, and I was trying to look at from the Indian context. So, Indian context. So what I tried doing it as, look at the very simple thing. See, one of the section which is there in CPC, which court generally follows all the time so far as recognition of foreign judgments are concerned. When we talk about conflict of laws, this is the one of the main area where you see that lot of judgments have been generated in the Indian context when there is any foreign element is involved, and now the party wanted to get it enforced in India or recognized in India. So when I looked at section 13 of the CPC, again, limiting the scope because I had no time, that much of a time to work on at length, what I did is that I tried to locate it within the two jurisdictions. So I looked at Supreme Court of India and the Delhi High Court because I'm based here. So these two courts I looked in to see that how many judgments have been given by the courts in the context of section 13. And within the section 13 around Supreme Court, I think I found around 22 to 25 judgments which were there. And in the Delhi High Court, I found around 55 to 57 judgments given in the period of 2000 to 2020. And during these years, I tried to look into how the woman has been placed on all these judgments. And surprisingly, barring only one or two cases where woman was one of the party in the contract matters or the commercial matters, most of the matters where women have been one of the party is primarily matrimonial cases and your child custody cases. And with that analysis, I try to apply into a relational feminist theory into see as how the now court has looked into those issues. And I do agree with sir that, okay, we do not have guidelines and therefore the court is themselves jumping whether to go welfare of the, the child should be looking or forum convenience sometimes, or sometimes they looked around to community of courts. But surprisingly what I found, or funnily, is that the court's decisions have changed or the analysis or the perspective have changed depending upon who is the party filing the case. So if it is the mother who has taken away the child and come down to India against the order of the foreign court, the court has strictly applied the first strike rule. For example, in the case of Surya case. So the first strike rule has been applied by the court, and the court has also applied the community of court as the predominant factors and given the judgment in favor of the father. And though given the protectionist order for the woman, that the woman has to be given maintenance, woman also has to be taken along with the kids to, I think that was UK, and then taken care of by the father and the husband. On the other hand, when I looked at another case decided by Supreme Court in the recent years only, I think the name was Pratik case. In that case, the father abducted one of the child. They had two child. One of the child was abducted by the father and brought to India. The child was around 2.5 of age, and by the time the case was heard before the court, the child was already 5 years. And here the court did not look at the comment, and the wife already had an order in the US, and where the order was given in favor of the wife that she can have the custody and the father would have only the visiting rights. Father flaunted those visiting rights, took away the kid, and then brought to India. The child was staying with the grandparents and was happy, no doubt on that. But the point is, the court did not look at the committee of courts here. The court did not look at even the first strike rule here, and only focused on the welfare of the child and presumed that the child who's staying now with the grandparents as against the child who would end up staying with a mother who's also working at the same time is not in the interest of the child. So my problem with the way the court has even applied whatever rules are there in the Indian context is that it is looking women in different relations. So the woman, when it comes to being as a mother, they have tried to look at women who's working. If she's working, they have questioned on her ability to take care of the children and therefore has given in the favor of the husband. And even if the husband was not there, they have given to the family of the husband. So there was one case was there of Saiba Ali, 2003 case. The husband was convicted for one of the offense, which was not there in the judgment. And the court agreed to still end up giving the children in the custody of the grandparents, saying that the mother would not be in a position to now take care of the child. And while sympathetically, agreeing to extend the visiting right of the mother, what the court did is that the court stated the children who were attending earlier the tuition need not attend the tuition now. That could be taken care of the mother when they go and visit the mother for their visiting rights on a regular basis. And the court would now get a report card from the school teacher as to how the kids are performing and then decide on the visiting rights of the woman. So when it comes to those kinds of rights, so far as woman is concerned for the custody, the court is very clear, very categorical in evaluating how she is doing well and how the children are doing well. But in other judgment where it ends up going to the grandparents or the parents, the court has not given any such evaluative theory, any such evaluative guidelines also. So the problem is that whenever the court is deciding it, the language matters, the legal language matters. So even if the court is presumptuously giving in favor of the woman, there are hidden guidelines which are trying to control the right of the woman in a way in which it has not been done for the other party. So this is the one aspect where I found, so far as the custody matters are concerned, and the way it has been analyzed by the court. On the other hand, if you look at the matters where the woman has her face, it's a matrimonial right, where they end up marrying an NRI, it turns out not so proper, and now they are seeking for a divorce, or the husband has given them the divorce in the foreign countries, and now the lady is looking for maintenance. In the courts, even though the court is trying to apply the section 13 in the way the Narasimha Rao judgment has done that, the court is very categorically putting certain terms, the language which has been used against the woman is the manner in which she is so naive, maybe so greedy, for example, looking for the greener pasture outside in a foreign country, as against looking for somebody who's an Indian-based. So the judgment which could have been given on the principles, normally the court has used these kind of languages which do show the kind of, the social kind of construction which is being practiced by the courts. I'm looking for a proper term which is not coming in my head right now, but it all shows that how the court is also biased in terms of, or the judges in fact are biased in terms of analyzing the situation, and their lens of deciding and applying the same principle differs depending upon who the party is, and the gender is a relevant factor in that. So it's still an ongoing study, so thank you for the opportunity here. I look forward for your suggestions and would try to incorporate in my paper. Thank you.
Thank you, Bhumika, for a very informative elaboration on the rule of conflict of law. Now we have Dr. Gurpreet Singh, Assistant Professor, Law Center 1, Faculty of Law, University of Delhi. He is going to present his paper on critical analysis of India's position in the Russia and Ukraine conflict.
Thank you very much. Chairperson giving me an opportunity to speak on this topic. I will begin with a little bit background. And this background actually came from the seminar which held last time here, in fact. Because in that seminar, many of the presenters have presented this fact that India should take a stand, clear-cut stand in favor of the United States or condemn the Russia. Therefore, I think that this compelled me to think about this issue. Even this is not from Indian scholar, but if we will recall a statement day before yesterday given by American senator, he said in a very clear-cut manner that steps being taken by India vis-a-vis Ukraine conflict so far are not enough, and New Delhi can do more. This is a clear moral challenge in the terms of Russian aggression, and Indian prides itself as a country based on clear moral values. And he said, let me quote, I think India can't escape from the fact that at some point is gonna to have choose a side. In fact, whose side India must choose? This is a question which has been persistent And even in Indian newspapers and many Indian scholars also believe that India must take a appropriate stand instead of having a neutral kind of stand. So I will examine first historical aspects of this issue. As we know that during the time of British, India was thrown into the two world wars, even without the wishes of Indians or Indian freedom fighters. Even when the League of Nations was made and the United Nations was made, India did not play a very significant role, as it is very much clear in the writings of many Indian scholars. After the independence of India, the choice before India was to in which bloc the India should join, and India adopted to have some kind of neutral policies, not to join either bloc, and India rather as being a founder member of NAM, also along with the third world countries, there is one very basic principle in NAM, and that principle is abstention from the use of arrangements of collective defense to serve the particular interest of any of the big powers. So all the NAM countries have decided not to be part of any bloc. However, in spite of these, India was always seen with the suspicion with the West, and particularly the West called the Indian approach is a subtle pro-Moscow position. And this became more clear when India adopted certain socialist patterns through the amendment of the constitution in India. Besides that, Russia has remained a very reliable friend with India too, that in 1955, the Soviet Prime Minister publicly declared Moscow support for Indian claim on Jammu and Kashmir. Besides, Russia has been used to exercise the veto in favor of India in the Security Council at least the 6th time earlier. This keeping Russia on the side through this veto-wielding prerogatives thus remains an important consideration that reinforces India's reticence to criticize India, even when behavior judged to be deplorable and on one occasion undermine the Indian vital interest. And subsequently, as we know that Indo-Pak war in 1965 and 1971, it was the USSR which extended the strategical help to the India, as well as the Russia was the major supplier of weapons and military equipment for the defense. And as according to the 1990s data, 90% of the weapons were supplied by the Russia to India. So, although in last 2 decades, India has changed little bit position. It has become, it has a good tie with the United States now, but does it is going to change that position which India has with the Russia or not? The time will tell, I think, in this regard. If we look at the constitutional positions, Article 51, which is the bedrock of Indian foreign policy, there is one relevant provision. Let me quote that when in Constituent Assembly, when this question came up, then in constitution makers were very much aware of the history of the both world wars, and they emphasized on this fact. Unlike before, India would not be dragged into the quarrels of other countries and would not align with the power blocs. So whatever the position of India has, it is consonance with the Indian constitution as well. But whether Indian position is totally neutral, I think not. If we look at the statements which are given by the Indian permanent representative in the United Nations as well as by the Indian foreign minister, it is very much clear that India has tacitly disproved the Russian-Ukraine war. Now, how it is clear? Because India has urged for the respect for the sovereignty and territorial integrity of state and called for the immediate cessation of the violence and the hostility. This diplomatic language confirms the principle of a UN Charter and tacitly conveyed to the Russia that it is not happy with its aggression against the Ukraine, and rather the Indian Prime Minister, when he said 2 days not an era of war to the Putin, it confirmed the similar kind of positions. But in spite of that, this question again came up that why India is not taking the side of a clear-cut side. I think India has already made it very much clear when this statement has been given that whose country has been violating this principle of UN Charter. So again, one more important things which India has been adopted, that is in UN Security Council resolution. Till now, 6 resolutions have been brought in the UN General Assembly, and in all 6 resolutions, India remained the abstensees. The reason for which India has given in clear cut that this war could only be resolved through the diplomatic efforts, through the dialogues between each other countries, they would sit together and resolve their differences. India has also got this opportunity to ask a pertinent questions in the last General Assembly resolution, where the Indian ambassador put 3 important questions, and these 3 important questions: are we anywhere near the possible solution acceptable to both sides? Second, can any process that does not involve either of the 2 sides ever lead to a credible and meaningful solution? And third, which is most important, is has the UN system, and particularly its principal organ, the UN Security Council, based on a 1945 word construct, not been rendered ineffective to address contemporary challenge to global peace and security? So India also highlighted that United Nations as an institution is in great danger because it has lost its relevance. Particularly the Security Council has lost its relevance because it is not able to stop these kind of conflict. So my analysis of entire is that can be put into the 5 points. Number 1, India's approach towards the Russia and Ukraine conflict has been shared by its supreme strategic interest in the global south. It must be seen from the trajectory of India, Pakistan, and China relations. India's substantial reliance on Russia in the defense sector is another major factor which cannot be ignored. Number 2, at the same time, India, without naming and criticizing Russia, has disproved the war and expressed her unhappiness. It becomes very much clear from the fact that India expresses its concern regarding the violation of principle of UN Charter, including the principle of the sovereignty and territorial integrity of the states. Third, India has also given a strong message to the West, and particularly to the US, that India will decide its foreign policy independently without any outer pressure based on its strategic regional interest. Hence, India cannot be treated as a satellite state. Fourth outcome is, during the General Assembly debate, India, while raising the concern on the humanitarian crisis, also raised the question regarding the effectiveness of the United Nations as an institution and reiterated its stand to reform it. Otherwise, it becomes totally irrelevant. And fifth, which we can draw the conclusion from here, that it could also be predicted that India's position will remain the same in future too. Thank you very much.
Thank you, Dr. Gurpreet, for a good paper. Now I would request the audience, if they have any questions for the panelists. Yeah. Do we have?
It does not look like in near future that this is going to happen, although one day they have to set on the table, because United States want to finish the Russia. And India wants that Russia should survive because we have to have a regional balance. We have to keep in mind China and Pakistan. So India could think about in the line of these. There is some kind of articles or some statement in newspaper that India should mediate between them. India would only do so if it is requested by the both parties. So in near future, it don't seem to be very much possible. That's the time. What the time will bring, it will be depend on the future. Nothing can be said, because if you look at West has also intervened in many countries, in Middle East crisis, in Iraq, in Afghanistan. Then why not there was so much hue and cry, and why not now? So there is double standard in international law. Not in law, in fact, but international politics, I would like to say rather. So unless the regional interest or national or international interest, these all are conflicting in one domain. So that's what I can say right now.
Anyone else?
Does the panel think that the double standards that I believe America is guilty of will finally resolve this matter? Because I believe USA is actually fueling the war. So I would request your comment on this, please. I have studied this war. I have studied military history, military geography. So I would request your views. Thank you. I'm ex-military, 4th generation.
Yeah.
I come from London.
There are a couple of points. Before going to the question posed by him, and as our Dr. Gurpreet mentioned, yes, there are 6 resolutions adopted by the UN General Assembly. Six resolutions adopted by the United Nations General Assembly. Can you hear me now? Yeah. So if you see recently, the latest one is on 23rd February, a day before, one year before the invasion, the so-called invasion or conflict. The resolution adopted by 141-735. And if you go back in the month of March 1st, I think, March 1st of 2022, the resolution was by again 141. And in between, when Russia declared that the Donetsk, Luhansk are part the so-called self-determination, etc., that time the voting was 143. So the analysis of New York Times, it's only mostly the Western countries and also Japan, Korea, Australia plus all East European countries, they are part of this thing. But otherwise, largely, more than half of Africa and 1/3 of Asia, they remain not aligned with the Western. They are not going to be led by the United States of America. That is analysis, and if you want, I can send you. This is just a day after the voting. The New York Times published. It's very good with the diagrams, etc. That is one thing. Second thing, yes, I think double standard which you mentioned, it is true. Just one example. Take for example, International Criminal Court. What is the stand of United States of America? Even assuming that Trump administration has, when there was the former OPT, that Office of Prosecutor Office, she from Ghana, I think she's from Ghana, she raised the issue of investigation into Afghanistan issue. Immediately, their visas were cancelled and they banned. She could not travel to New York to present her 6 monthly report before the Security Council. And of course, and even they threatened the judges, whoever ICJ judges. But what is the situation now? There is a change of government. Situation has not much changed. They are still non-cooperative. And another thing, the United States of America entered into almost 90 countries, including India, I think, Bangladesh. any soldier captured, any American soldier or any American captured by them are charged with the violation of the humanitarian law or war crimes, they should not be handed over to ICC. They should be sent back to the so-called Article 91, 90, yeah, that the convention. So they are maintaining the policy. But when it comes to their own interests, whether it is in Somalia or Uganda, for example, Uganda where LRA, Lord's Resistance Army, they are just putting in money and they have sent their own people, 500 Americans, they are sitting there, they are actually guiding the Ugandan government, Museveni government. But why you are not cooperating with the ICC on the issues where you are involved? So obviously that's, and why they suddenly they found it is a very good to invest so much of $100+ billions of dollars, even approved by the Congress. There is $300+ billions of dollars they seized the account. And recently, Ms. Ellen, the Federal Reserve Chair, she also made a statement. She came here and ongoing, she dropped in the Kyiv, and she made a statement, we are still trying, and the seized properties of Russia cannot be given to you. We are compensated for you. Compensation is nothing but for all the arms they are supplied for $100 billion, they take it. That's the issue. But anyway, having said that, so far as India is concerned, I hope I clarified your issue. So far as India statement is concerned, if you read carefully, this.
So would you agree with the fact that even the Americans and the leading academics are saying that America is fueling the war and is profiting from this war? So they have no intention. In fact, they are selling their oil and gas to their own allies, NATO allies, at 4 times the price. And they destroyed the pipeline. That is also proven now.
Yeah.
So,
journalist, I mean, I don't want to talk so many things.
And what is staggering that their own allies, NATO, cannot stand up and tell them, don't do this, we are suffering and you are profiting from the war.
No, the allies, European allies have had to come up to that level to stand up against America. Even Germany, France, Italy, they are somewhat wavering. That's what the internal news says. But anyway, I'm not getting into this thing.
Thank you.
Yeah. And so far as India is concerned, there are 2 important elements, whether you see the statement of March 2021 or the statement made the last February. One is territorial integrity of the states have to be protected. That is one issue. Second is security of the states have to be assured. These are the 2 elements. Because the other thing which Indian government is addressing is if Russia puts or China puts the bombs next to the say Mexico or Cuba, will America be happy? They won't do anything. So that is the issue we have to see. So with that, I think I close it. Thank you.
Thank you everyone for patiently listening to the session. So I thank Mr. M.K. Rao, Mr. Anil Malhotra, Dr. Bhumika, Dr. Gurpreet Singh for the contribution of valuable papers, and all the faculty, the researchers, students, and the life members who have come for this session. Thank you so much.
Tea is ready at the second floor, so We will resume the session 4 o'clock as
Good evening, Professor Ricky Lee. I'm audible to you? Yeah, we are unmuting you. Just hold on. Yeah, can you speak? Please speak. We want to test your audio. Professor Ricky Lee. नहीं आ रहा आवाज. Can you speak again? Your voice is not coming to us. Professor Ricky Lee, am I audible? Professor Ricky Lee, can you speak so that we test whether your voice is coming or not? Yeah, it's coming now, but it's low. Kindly raise the voice little bit more louder. Yeah, Ricky Lee, please speak again. Professor Ricky Lee. It's still very low. It's very low. Yeah. Can you speak again, Professor Ricky Lee? It's coming, but very low. Very low. Yeah, can you speak again, Professor Ricky Lee? It's very low. Hello? Sorry, Professor Ricky Lee, can you speak again? Yeah, it's now perfect. It's perfect. Yeah, it is. Now we are able to hear you.
Testing.
Yeah, it's. You are audible. We are hearing you.
Excellent. Thank you.
So welcome you all to this plenary session 4. This session is devoted to the emerging issues in space law, and I hope that you might have enjoyed the different sessions which are in contemporary areas of international law. This is a very important area. Space law is fascinating to all of us. Space is fascinating. And outer space is most fascinating to all of us. It was very early in 1959 when V.K. Krishna Menon, he had predicted that we are not far from the time when human beings will not only be sending things into upper atmosphere or into space, but will themselves be going, returning and living. 1959, he had said these words, and I think that now we might have heard that how we are making inroads into the outer space, going to the moon, trying to explore the asteroids, and you might have heard that many of the tourists, now the tourists are of different types. Some of the tourists are space tourists. So people spend lots of money to make a voyage to the space. You know, I have heard people pay crores of rupees. 10 years back, 2 crores of rupees were paid to just make a voyage towards, okay, I'm so happy to see the moon, right? So we all look at the moon, but then taking a closer look at the moon and how it looks like. So this is a, but then many different issues are emerging, like what is the importance of private sector? Because traditionally, the state has been the sole regulator, and international law is there. So we have a very normative system of international law on outer space. But then this is now changing. Emerging areas in space law is that how the private investment, which can make such tourism to space and outer space, possible, that can also be examined. Perhaps the panel today that will examine all some of these issues. And you see, apart from that, space debris, the issue of space debris, that is also because now we have lots of, moving articles which we set, and we, the people of various countries of the world, we send those things into the orbit, Earth's orbit. So, and then they are there, because you might have known that once we send a particular thing into the orbit, which is geostationary orbit, it becomes very difficult to again, bring it down. So you see that what would be the responsibility of the states, and if we allow the private sector, what would be the responsibility of the private sector? How, if there would be dispute, how this international dispute would be resolved. So these are some of the issues in the space law that perhaps today some of the panelists, they would be having a look at it. And today, what I see that we have a very good number of panelists here. We have Professor Ricky Lee from Jesus College, Cambridge, and he is the keynote speaker of this session. And then we have Dr. Malay Adhikari from Amity University, Calcutta. And then we have Ms. Harpreet Kaur, who is the guest faculty in Faculty of Law, University of Delhi. And then we have Mrinal Sharma. He is in Terry School. So any other panelists? I think that they are not there. So these are the 1, 2, 3, 4, and 5 speakers in this session. So I hope that this session would be very enriching to all of us. Let us start with Professor Ricky Lee for his keynote address. Ricky Lee.
Thank you very much, Professor Jha. And first of all, my gratitude to the organizing committee and the Indian Society of International Law for their kind invitation. Am I audible at the moment, and are you able to see my presentation? Sorry, wrong screen. That's better. Again, thank you for your kind introduction and also for the invitation to address the conference today. I shall be brief. I note from the program that there are a significant number of speakers who will educate us on some of the more specific aspects of space law, somewhat rather emerging and critical issues that are acute for both the international community as well as for the private sector. What I want to focus on for my brief remarks are some of the more holistic myths and emerging trends that exist in space law, and hopefully provide some overview and background on some of the perhaps hidden trends and also some apparent trends in the evolution of space law in the last 10, 20, 30 years or so. So first, let me talk about some emerging trends. The United Nations Space Treaties were developed in the 1960s and 1970s. The Outer Space Treaty was adopted in 1967. The last United Nations Space Treaty, being the Moon Agreement, was adopted in 1979. there has not been any multilateral United Nations treaty on space law since 1979. There has not even been any progress or development or even initiative towards formulating or proposing a new treaty within the United Nations Committee on the Peaceful Uses of Outer Space since 1979. What we instead see is a evolution from developing what we international lawyers would refer to as hard law, binding treaties that have been adopted in the United Nations framework, for which there are 5, into what are development of soft law through the 1980s and 1990s. There have been General Assembly declarations that have been negotiated and adopted by the UN Committee on Peaceful Uses of Outer Space on issues such as remote sensing, on television broadcasting, on the use of nuclear power sources, but none of them have evolved into treaty, nor are there any move or initiative towards developing them into treaties. We are now in more recent decades starting to see that the bulk of the work of the United Nations Legal Subcommittee, and for that matter, the work of the international community in the development of space law, moving towards even softer instruments than General Assembly declarations. We are seeing, for example, space debris mitigation guidelines that are nothing more than guidelines. We are also seeing recommendations from the committee and recommendations from space agencies. So we have evolved or devolved, depending on your perspective, from enthusiastic negotiation and adoption of binding hard law treaties to now where the only thing that gets adopted by the committee are guidelines that are non-binding. They don't carry any force of persuasion by the General Assembly in adopting them, because the General Assembly does not even bother adopting them. So the force of law behind the development of space law have certainly decreased in the binding effect they may impose on the international community. Part of that is also because of the substance itself. In the United Nations space treaties, all 5 of them, we see legal principles being laid down. Indeed, the Outer Space Treaty is called the Treaty on Legal Principles in relation to the exploration and use of outer space and celestial bodies. The entire purpose of these international treaties were to lay down principles, not so much any of the procedural aspects and some of the mechanical aspects that we often find in multilateral agreements, but almost each and every provision of the Outer Space Treaty lays down a brand new principle of international space law. And that either gets expanded, elaborated, added on, expanded upon, or extrapolated through the other 4 United Nations space treaties, be it on international liability, be it on registration of space objects, be it on the rescue of astronauts and return of space objects, or for that matter, even resource exploitation on the moon and other celestial bodies. These treaties lay down legal principles. But if we look at the agenda and the work and the report of the Legal Subcommittee and the UN Committee of the Peaceful Uses of Outer Space through the 80s, 90s, and the last 2 decades, we are seeing the focus shift from focusing on legal principles to definitional issues. For example, what are the state practice and opinion jurists in relation to how they view what's the launching state? What are the state's opinions in relation to the demarcation between sovereign airspace and outer space? So we are seeing more and more the downgrading of the work of the United Nations and the other multilateral fora from actually considering or formulating broad legal principles to focusing on definitional issues, evolving to now focusing on policy value. We see, for example, in the General Assembly resolutions that were adopted by the United Nations, that we go from issues such as remote sensing, the legal principles dealing with direct television broadcasting, and nuclear power sources, to the last one, the principles on international cooperation and harmonious existence in space, none of which contain legal principles, none of which are legal principles. So we are also seeing an evolution from the formulation of legal principles to what are now policy statements or value statements on the part of the instruments or documents that are produced by the United Nations multilateral framework. And perhaps as a knock-on effect from that we are also now seeing in the space sector the development of increasing internationalism and privatization in the activities of the sector itself. From the government programs of the 1950s, 1960s, 1970s, to the international cooperation that exists through the European Space Agency, the International Space Station, and now increasingly the private sector is playing a more and more significant role in the development of space activity. We saw in the last 2 years the so-called billionaire space race, where it is the private enterprise that are developing and building spacecraft and sending private spacefarers, as well as ferrying government astronauts into outer space. As that trend continues, we are also seeing some possible or potential degradation of the rule of law in the space sector. Because while government programs and intergovernmental programs are of course subject to the application of international treaties, the private sector would only see themselves bound by domestic statutes. And in the absence of domestic legal framework in some countries, we may be seeing the erosion of compliance with international law, or B, private enterprise choosing flags of convenience for their operations. If, for example, they are going to have people permanently employed on a space station, are they going to willingly subject themselves to European labor regulations, or are they going to choose more flexible and more liberal jurisdictions and employment conditions? Is that going to lead to a spiral of laissez-faire regulation in space, where it will again be the Wild West, that whoever first comes will get the best rules that only are applicable to themselves? And the final trend that I want to talk about, of course I pretty much have already addressed, is the evolution from multilateralism to focus on the United Nations being the primary forum for the development of space law principles in the 1960s and 1970s, to increasingly bilateral cooperation arrangements. Australia has a bilateral cooperation arrangement in space with Russia. The Artemis Accords, of which 23 countries have signed, are bilateral arrangements between NASA of the United States and the individual space agencies of those 23 countries, of which Australia is a party. So rather than having a multilateral framework and Artemis Accords that of which all 23 countries are parties to it with each other, what we have are 23 bilateral arrangements between the United States and those 23 signatories. But what is ultimately going to take center stage as space law becomes increasingly privatized and the space sector becomes increasingly privatized is that only the domestic law is going to be binding and applicable to these private enterprises. And it makes the need for legislating, or at the very least implementing the legal principles in the Outer Space Treaty and adopting them into domestic law becomes very important. There are a significant number of countries, of which at least there are 30 to 40, that have legislated on private launch activities and private satellite operation activities. There are also a handful that regulate remote sensing specifically. There are now 4 countries, an increasing number of them, who have also legislated on the exploitation of mineral resources from asteroids or the moon. as the space sector evolved and become increasingly privatized, the avoidance of the phenomenon of flags of convenience is going to need to remain for many countries, particularly established space powers such as India or emerging space powers like Brazil and Nigeria, to consider legislating a framework that is comprehensive enough to cover all space activities and also broad enough to ensure that on any occasion where India or Brazil or Nigeria may be found to be responsible under the principles of state responsibility, that they can pass on those important obligations as well as the liability to the private sector. In the last few minutes, I want to talk about some myths that exist in space law. I read very often in commentary that space law is lex specialis, that it is considered that the 5 United Nations space treaties, or 4 if you don't count the Lunar Covenant, contain a legal framework within itself. The comparison is then drawn between space law and, say, international humanitarian law or WTO trade law. The difference, though, is that international humanitarian law and WTO trade law both specifically have treaty provisions that say it is lex specialis, that it is supposed to prevail in a case of any conflict over general principles of public international law. In space law, the position is in fact the exact opposite. Article 3 of the Outer Space Treaty specifically says that general public international law applies to outer space, and general international law applies to space activities. So far from being lex specialis, space law invites the application of general public international law to space activities, space applications, and exploration and use of outer space. Another myth that is often raised is that property rights in space are prohibited. It is said that because you can't own any part of outer space, it doesn't matter how many flags are planted on the moon, they can't own it. The reality is that Article 2 does not say, of the Outer Space Treaty, does not say that at all. Article 2 of the Outer Space Treaty speaks of national appropriation, an appropriation to sovereign title by the state. It does not in fact prohibit property rights. There are a significant number of commentators who say that the absence of property rights pose a significant obstacle to exploration and exploitation of mineral resources in outer space. I would agree with that. That is precisely the reason why Article 2 does not in fact prohibit property rights. It prohibits the assertion and exercise of sovereignty. If we think back to the 1960s, the United States and the Soviet Union did not know which one was going to win the race to the moon. It made sense for them to ensure that whoever got to the moon first, whoever planted a flag on the moon first, do not get to then declare the moon as their sovereign property, as they have done throughout the world. That principle in the 1967 Outer Space Treaty continues in that form and continues to that effect. It only prohibits state appropriation of sovereign title. It doesn't prohibit property rights itself. And if we look at for example, the building blocks on space resources that the Hague Roundtable on Space Resources had produced, or for that matter the Artemis Accords, they say that the exploitation or the utilization of space resources is compatible with Article 2 of the Outer Space Treaty. And the only basis for that is that property rights are allowed under the Outer Space Treaty. The third is that because it's called the UN Committee on Peaceful Uses of Outer Space, because we speak of peaceful applications of outer space, there is the misconception that military activities in the use of space are unlawful. We know, of course, that that's not true. GPS is a military application. Remote sensing, of course, is a military application. And even just in the last 12 months, the development and the use of GPS, communications, broadband internet by satellite, by both sides of the Russian-Ukrainian conflict, clearly shows to us that military activities and use of space are not unlawful. The development and testing of anti-satellite weapons by several countries, including India, in the absence of legal protests about their legality, suggests that they are in fact lawful. The Outer Space Treaty, in particular Article 4, only prohibits two things. One, weapons of mass destruction. Two, military uses of the moon and other celestial bodies. That means that as long as we are talking about conventional weapons, space is fair game. And to a very great extent, it goes back to my first point about space law not being lex specialis. There is a very common idea, often asserted, that we don't want to see space become a theater of war. But what we have to recognize is that international law, particularly international humanitarian law, applies to outer space. So if you are a state commanding officer, you have a choice between destroying a satellite, which kills nobody, or the ground receiving station of that satellite, which kills, say, 30, 40 people and can be rebuilt in a week. The humanitarian law obligation imposed on you requires you to blow up the satellite, not the ground section. So the ideal one may express in space, for the sake of argument, let's say that military activities or the use of force in space is in fact unlawful, which it is not. But if, for the sake of argument, it is, the international humanitarian law obligation to minimize casualties, nevertheless is going to make one choose to destroy a space asset ahead of a terrestrial asset that may lead to casualties, which only proves space law is in fact not intended to protect specialities. Finally, the UN space treaties are often considered outdated or obsolete because the last one was formulated in 1979. However, almost every bilateral treaty, almost every single piece of domestic legislation still refers back to the UN space treaty. They speak of their own compatibility with the principles that are laid down in the Outer Space Treaty. As international lawyers, the more we suggest that those legal principles that are formulated in the 60s and 70s are outdated or obsolete, the more we are encouraging contraventions and violations of those principles. What we should in fact be doing, both as international lawyers and as responsible members of the international community, is to encourage compliance with existing treaties. No state had yet to date withdrawn from any United Nations space treaty. One has given notice of their intention to withdraw from a UN space treaty, namely Saudi Arabia and the Moon Agreement, but it has not yet taken effect. So in the absence of any state openly suggesting that the space treaties are no longer applicable, surely they are not neither outdated nor obsolete. Hopefully the last 15 minutes, I know I have spoken very quickly. I hope I have given all of you a brief overview and some thoughts of some of the emerging trends, as well as some of the myths that exist in space law holistically. I thank you very much for your attention, and I look forward to listening to the other presentations of the session. Thank you very much.
Thank you, Professor Ricky Lee from Jesus College, Cambridge, who was presenting a keynote address on myths and realities of contemporary space law. And he was right in pointing out some of the things like how the outer space law, international law particularly, how it has moved from the principles to the definitional issues now. So now it is becoming concrete, more concrete. 70 years back, it was not in that shape. It was just having some principles. And how the private enterprise is taking part in the outer space exploration, and how there should be fixing up of responsibility of those actors, private actors. And he was also pointing out that the multilateralism which was prevalent in the 60s, when for the first time outer space international law was starting to evolve, from there onwards we are now moving on to bilateralism. So you see that, you know, any sort of cooperation, but that is must. Without cooperation, we can't move forward in the outer space. He was also pointing about the myths. Some of the myths like property rights are prohibited in outer space, but that is just a myth. He was pointing out that we are now exploring, you know, we are not exploring only on our mother planet, but we are moving, you know, in any direction and want to explore. But then how to control, because earlier the principle was that it's this, the whole, it is a heritage of all the people. But how far it is the heritage, how it is going to be appropriated by the nations by using technology, that is also one of the issues facing international law. Now, thank you, Ricky, for your nice keynote speech. I hope that you might hear us. Thank you so much. Now we will move on to our next presenters. The first is Dr. Malay Adhikari. He is in Amity University, Kolkata, and he is speaking on institutionalization of space law in India. 7-8 minutes. So this is a space, international space law panel, so we give proper space to everyone. Technology is very useful. We can hear anything from England, but you see sometimes technology has its own problems. So can you now? Yeah.
Good evening all, respected peers. My topic is institutionalization of space law in India. Professor Lee basically talking about the space law in international domain. But my topic is prepared especially on India. How space law evolves and what is the infrastructure. Basically, it talks about the infrastructural development. The purpose is, we know the Space Activities Bill already drafted in 2017, but it is not act till now. So there are so many efforts from the very beginning, directly or indirectly. Now, institutionalization in space law. What is institutionalization? Now, institutionalization basically here means that how the people from India thinking about space law, directly or indirectly. Maybe it started long back. The history basically relates with Professor Meghnad Saha. And that time government instructed and he did for different purpose. And he set up National Almanac Unit in Kolkata. Now it is popularly known as Positional Astronomy Center. Perhaps we, the students of space law, may not actually look back, but the history will be different if Saha will survive more than Bhabha. Till now I am not getting any writing or anything that what is Saha's contributions towards development of space infrastructure in India. Generally we start with Bhabha. Okay, but it is not like that. Now obviously the number 2 I am not saying, people know. Point number 3 also, Sarabhai also. But the point number 4, that is International Geophysical Year, IGY. Hopefully many of from the audience, they know what was happening in 1955. So just like Chandrayaan, just like Mangalyaan, so all over India, people are very much enthusiastic about the IGI. And that time it was radio. Okay? And the leaders behind that, few names are there, but there are other names also. But S.K. Mitra, Krishnan, A.P. Mitra, all are leading one. And obviously Ramanathan and Sarabhai, they are joining the second category. Then Sarabhai took the lead through Physical Research Laboratory or PRL. And obviously then again Department of Atomic Energy. But there may be one question that why actually I am putting all these things in the platform of space law. Because when they are developing this thing in the background, there are some indirect development of space law and absolutely our own that may not be related with international space law. Obviously we cannot ignore international space law. The follow-up is in COSPAR, then ISRO. Then Space Commission, 1972. But the Space Commission in 1972 and right now, there is much difference. Expansion of members, and members are from different categories. Foreign Secretary previously was not member. But hopefully, if I am not wrong, post Chandrayaan, Foreign Secretary added in the Space Commission. Then the next part, that is modern institutionalization, and that is we are much more interested. And this starts post Chandrayaan, 2008 onwards. It is basically on commercialization and privatization. And there is one significant characteristic that commercial private actors, not only private actors, commercial private actors, those who have no names or fames, they are joining hand in Chandrayaan and post Chandrayaan. And they are forming lobby, they are discussing, interacting, that why law is required, and that time we do not have that draft. So they have several meetings, initiatives. They are meeting with the top leaders in space. And gradually, the space activity bill formed. But there is another point to be observed, that this shift, basically, like the previous time, that is Sarabhai or other people's time, and post Chandrayaan, it is organization centric. So when it was originated, there are few names, Bhabha, Sarabhai, like that. But post Chandrayaan, the small private actors, they take the leads. And I think this is very good sign to develop space law in India. And That is one of the reasons that why the space activities bill drafted so quickly. Now there is institutionalization outside Department of Space also. There are few names because they are the major actors, but there are other actors also. Now related with the FICCI, long back they started with first 2008 with the geospatial sector. And after that they have the interactions over the space law and space activities related to this. CII. Now CII had major role. They conducted at Bangalore biennial space expo, and all the major private actors from India and outside India, they gathered, they deliberated, and lots of issues related with India and overall they discussed. And definitely these all enrich the future development of space law. Now other bodies and society, obviously here ISIL, okay, long back we are discussing, deliberating on space law. This is also contributing towards our own development of space law in India. There are ORF. Now there are few scientific bodies like Indian Society of Remote Sensing, Society of Geomatics. Though they have small scope, but in their conferences, symposiums like that, they are also deliberating law related with space. Because for their activities also, law is required. Now apart from these, I am just sharing one incident. There are many engineering and technology graduates. They would like try to develop the rockets, air rockets. And the first legal point they are facing, that what are the rules and regulations to fly it up to some kilometer. And there are some restrictions. And then they started thinking about space law. So their interactions also enriching this institutionalization process. Now this modern institutionalization too, if we break up, it basically relates with this our Antrix Devos issue, 2011. So that time the government bound to think law related with space differently. But now the concept totally changed in India. In any platform, basically related with the commercial platform, they are not saying space. They are always saying new space. Okay. So title of my topic may be Institutionalization of New Space Law. Now this new space basically covers private actors, entrepreneurs, startups. So they contributed, and how actually they develop their programs and side by side the law. Now under Department of Space, we know the NSIL and InSpace, the two entities we developed. So DOS also developed this new space policy also, but it is not in public domain. Now time is short, so recommendations are very few. So we have to deliver it in different fora, and it is not only that in legal fora, we the students of law will deliver it, maybe the people who are working on space, they also get some space, and in their programs also, we also supposed to get space. So this is much more required. Otherwise, this new space law we cannot develop. Thank you.
As the chair, perhaps I am given the liberty to, little bit change the format, because I think that just after the presentation, if the questions which are coming to your mind that may be asked, because maybe that you may forget after that. So just I will take any question from the first speaker. Malay Adhikari was the first speaker. Do you have any questions? Anyone? So if you have no questions, then I will just ask you, Malay, that so do you think that more institutions are needed in our country, or are you satisfied with the institutions which are existing?
Maybe both is needed, but if we actually interconnect with each other, that is always better, technology and law. Because they are also thinking, they are also interacting over law, but that time we are also not getting, because we are not there. Okay. And another point is that the industry people, what they are thinking, because this new space totally stands on industry.
That is fine, but any institution which you think that it should not be there, or you think that no, it should be there, one more, two more institutions must be
No,
there?
obviously, one or two more or many institutions may
In
be
which
there.
area? In which area?
Obviously related with the space law.
No, but in which specific area?
In specific area, I mean remote sensing.
No problem, just you think over it.
No,
Thank you.
remote.
So, yeah, we have one more.
Yes, yes, sir.
Student chapter. As he was telling about institutionalization, to promote the space law, that particular chapter we opened in Indian Space Research Organization at Bangalore headquarters. Somehow that is not working. If you kindly enlighten us, what has happened to our institution and why we are not promoting that one along with our law students. We should also involve them. Earlier we used to involve all science and engineering and also aerospace and electronic people.
That's what I was asking.
If Malay sir will take interest since he is teaching,
okay,
so we can involve our law students also in that one, so that we can give some technical instruction.
Just briefly, if you can add to that. What was the region of failure of that institution? How can we involve more?
Last 7 years.
Yes, yes. Yes.
Want to add something?
No, I think not.
Okay.
Time.
Yeah, please. So thank you, Malay. He was trying to emphasize upon the contributions of many people and objects, and how Chandrayaan that ignited our interest, how Mangalyaan ignited our interest. Oh my God, we can now see our own space object that is going towards the Mars. And you know what? That interesting story which is coming up is that now we are going to explore Venus, and some country says that Venus belongs to us. So you see that Mars and Venus, these are the two important things that we always hear since our childhood. So if Mars can belong to everyone, how can Venus belong to one? So that is a very difficult issue that we can think of. So what Malay was trying to tell us that how the long journey started by Saha to Bhabha, and from Bhai, but there should be next should be the contribution of Malay into the international space law. Thank you, Malay, for taking up the issue of institutionalization. Let us move on to our next speaker, who is Ms. Harpreet Kaur. She is the guest faculty in Faculty of Law, University of Delhi, and she is going to present on ADR in space, vistas of dispute. Please.
So,
good evening, everyone. With the short time that I have been allowed to speak for, I will quickly talk to you about the dispute that is at hand, the issue that is at hand rather, and then identify the lacunas or the gaps that we have identified with the current regime of space law, wherein we have conventions, treaties, agreements catering to the space-related disputes, but trying to see how they are lacking with regard to the dispute settlement when the space-related dispute occur. And why this particular issue becomes more imperative to be discussed today is with the presence of private entities in the realm of space and the evolution of space law in presence of these private entities. So what we have identified is that space-related disputes can be settled by adjudication, inquiry and investigation, negotiation, consultation, mediation also. But what we have realized is that probably the most viable dispute mechanism that can be adopted with regard to space-related dispute is arbitration, wherein we have seen that Permanent Court of Arbitration had adopted the optional space rules in on December 6th in 2011, which is based on the UNCITRAL model of arbitration, where the other mechanisms fail is something that can be pointed out with regard to why we are proposing that arbitration should be taken up as an alternative dispute resolution with regard to space-related disputes. So we have identified that there are few lacunas. They can be from the perspective that the legal framework pertaining to space law, Outer Space Treaty, Rescue Agreement, Liability Convention, Registration Convention, and Moon Agreement are not sufficiently providing for arbitration with regard to space-related disputes. So one of the first lacuna that we have been able to identify is that these treaties, these conventions or agreements are not providing the mechanism to private entities. It is only related to states, and they are much more state-oriented. The dispute settlement mechanisms are more state-oriented, wherein you will find that even if the non-governmental or the private entity is to settle its dispute, will have to be sponsored by the state, and only then a mechanism like consultation can be taken up with regard to the private entities. And we, especially if you look at liability convention, there's a limited scope with regard to compensation. It only deals with claims compensation, which is very limited in its sense, and limited in the sense that it only relates to damage done by space objects. But what about other damages done by other activities, space-related activities, is something which it is silent upon. And also, liability convention lacks the binding capacity or authority over the issue that can be settled thereunder. We also found that the Outer Space Treaty is also not covering private entity. So if it's not covering private entity, there's no question of seeing settlement related to space-related dispute with regard to private entities. And state here specifically is liable for non-governmental actors. So private entities have not been covered. Non-governmental actors will only have to be sponsored by the state itself. So states are the only actors as far as Outer Space Treaty is also concerned. Then liability convention, which is only providing for dispute resolution, is pertaining to claims, and registration convention, though it is affecting the private entities, but in a very limited sense. And last of all, the Moon Agreement, which is quite dormant in its application, it is acknowledging commercialization, therefore it is covering private entities, but because it's so dormant that it becomes difficult for space-related disputes to be settled thereunder also. Another gap that we have seen, have identified, is that these treaties are state-oriented. So private entities do not have a legal status conferred onto them. If they will have to go for the settlement, they will only have to be sponsored by the state, which is a great lacuna on part of these treaties that have been provided. And the last gap, very quickly, which can be identified, is that there is usage of ambiguous terms like national activities, non-government entities, and damage. These three terms specifically are so ambiguous, ambiguous in the sense that they are so broad in their connotation that they are applicable to anything and everything, makes it difficult for the private entities to be covered thereunder. So when we deal with national activities, it could be interpreted either that it is an activity taken up by the state, which means that commercial activities are outside of the purview. And another interpretation that can be attached is that national activity is only that activity which is within that particular state. So meaning thereby, what about those entities which are private entities operating in the state but performing somewhere else? Swarm is one of the examples where the US did not allow it to launch its satellite, and it opted to launch the satellite from the Indian territory. So the lenient state is often taken advantage of. So these entities have a way of flying from one state to another state. So where is their liability residing? Another term which has been very vaguely defined is non-government entities, which only means in intergovernment organization. Again, here private entities are not covered, and damages is another word which is not defined properly, which only means or takes the meaning that the direct physical damage can be compensated, not the indirect damages that can be compensated. So in light of these lacunas, the ambiguous terms that have been used, the lack of the fact that private entities have not been covered, compels us to propose that arbitration should be taken up as an alternative to settle the disputes with regard to, because now the presence of private entity is more than ever. And what we can also suggest is that, just 2 minutes. What we can also suggest that is the domestic law, the national space law can be more efficient in covering private entities, and we can look at the Indian territory, we can look at CPC where it under section 89 is prescribing arbitration, that before going into adjudication, the state itself is going to ask the parties to go for arbitration. Arbitration, because it's more flexible and autonomous, can be opted, but to bring the private entities to that point where they opt for arbitration is the most difficult one. So what we can do is that we can create, just like UNCLOS, we can see that there could be a specific chamber designated with regard to space-related disputes, settlement of space-related dispute. And there can also be a standard format of agreement, arbitration agreement, because that will also help the parties to not evade or escape this mechanism on the point that to draft an agreement in itself is a tedious task. So I would conclude by stating that arbitration has been found to be most viable, but we need to see that the optional space rules that have been adopted by the permanent court of arbitration should see some modification or amendments in this particular direction, the lacunas that we have identified. Thank you.
Thank you, Harpreet. So, do we have any question from the audience? Yes, there is one.
Am I audible? Yeah, thank you so much. So I was saying that, ma'am, thank you so much for this brilliant presentation. So my question is specifically about this, sir and ma'am, that when we were talking about dispute resolution, and I understand how important it is to strengthen the dispute resolution mechanism when it comes to outer space. Like you mentioned about outer space treaty, ma'am, like it says that, the outer space is not for national appropriation. So the question is that instead of, do you think instead of even thinking of including private entities, first it is important to democratize the dispute resolution system or have one in such a manner that the free rider problem doesn't come up. Like a classic case is that of, how SpaceX wanted to have its own ambitions in Mars and etc. So the direct liable state party should be the US, right? So strengthening and democratizing such mechanisms and regimes in a manner that first the states are liable, because ultimately I'm not sure, but I still feel that it should be still more state-centric, so that states can take up more liability and obligations they should have. And then, we can think of including private entities, because the free rider problem is very important, and anything can happen because the dual use dilemma also comes in technology, be it nuclear weapons, be it outer space. So, that's
So
about
what
it.
do you think that you say that state-centric international law which is existing today, that is fine, and she needs some modification in her conclusion?
So my point is that definitely we need to address private entities as well, but that should be rooted out through democratizing these spaces in a manner that the state parties have the obligation to meet the requirements.
Have you got the question?
Yes, sir. Thank you. Thank you for your question. I think what I have understood from your question is that you received that the lacuna that I was identifying is that these legal frameworks are more state-oriented in the sense that I'll state what I meant by state-oriented. I meant that they are only providing option of settlement to the states. The private entities themselves are not covered. So state will only have to sponsor them. I'm also on the same lines as you are. All I'm saying is that the state should also have a space in the legal framework when they should be the minute they will be identified, they will have the alternative of not going to the state first, get a sponsorship, and then get the mechanism use that particular mechanism
Thank
for
you for your
settlement.
question. Thank you.
Right? Thank you so much. Thank you.
Thank you.
Thank you. Now we have the last speaker. As you might be noticing for the last half an hour that we are discussing outer space, international law on it. So we are giving ample space to everyone, but as you might be noticing that we are now trying to regulate outer space also. So we are now trying to regulate this panel also. So now we have the last speaker, Mrinal Sharma, who is from Terry School. From which Terry School? Delhi. So Terry School, Delhi. He will be presenting on critical analysis of international space law regime with special reference to space governance and growing private sector participation in the space. So you have a lot of followers here, so please conclude because they might be no. we are just few minutes short of valedictory session. In 5 to 6 minutes, we will start valedictory.
Good evening to everybody. As I have been told that I have a little less time, so I'll just move to the main points of my presentation rather than giving the critical analysis of the space regime, which we were very rightly taken to by Professor Lee, where he stated that the issues, where he busted the myths of space law, per se, of privatization, private property in space law, or and then he took us to the issue of multilateralism in space. So my presentation particularly is about the space governance in respect to private state actors and the increasing amount of private state actors that are coming in the international space law regime. And is the space law regime of the current world adequate to accommodate those people or not? So I'll rather skip this. And access to space has been a new resource to a lot of societal states, and new non-governmental and governmental actors have come into play. The commercial market of space tourists is also recently developing, and which was hardly envisaged in the space treaties when the space treaties were being formed. So the technological development has also sparked innovation, and with this there have been a lot of changes in the current space law sector per se. We are talking about space mining, we're talking about space tourism, we're talking about appropriation of space properties, and which is prohibited. But when we talk about appropriation of space properties, we can pose a question of occupation versus appropriation. Would the advancement of mining and research in exploration of in space could lead to another wave of colonization, in particular in space or celestial bodies? Because as we already know that a lot of these celestial bodies are rich in precious metals per se, uranium or any other of that sort. As due to the plausibility of time, I would just talk about three things. That is the glorification of space in the military sense, as one of our the audience from the audience has already talked about the duality of technology. So I'd like to give an example of the Russian and Ukraine war, where a technology of space geo observation was used, basically satellite imaging, which was done by a private actor in particular, of which hailed from United States, was used by the Ukraine government and sold to the Ukraine government for and which it utilized in preparing in advance for wars with Russia. So the question here lies that what is the ethical means, or what is the ethical genesis behind this, or how can this be addressed in space law, or does the space law have anything to regulate this? The answer is actually no. I don't think so, as for my research goes. Another example that could be used is that when we talk about transfer of property of space objects, basically when we talk about a transfer of satellite from one state party to the international regime to a state party which is not a part of the international regime. So how does this work in the space law regime? So this is one of the examples could be taken from the NavSat which was done between USA and Netherlands. Another is the ambiguities and the loose definitions of the international space law regime, where, yes, I just concluded, is space law regime, sure, sir. So another issue, lastly, I would like to conclude by saying that with the principles enshrined in the outer space treaties, as which states that the outer space is and the resources are a heritage, a common heritage of mankind, and astronauts are considered as the envoy of mankind. However, these do not fit into the privatization of space. per se where such space exploration would take a lot of resources, and safeguarding the interest of private actors in space is also necessary, which need to be looked upon. Thank you.
Thank you, Mrinal, for sticking to the time limit. I'm so sorry that I could not give you a lot of time. But you had made a lot of efforts to give us a very good presentation. So with this, I hope that you must have enjoyed I'm not also willing to take any question. If you have very pressing question to ask, I won't stop you. But otherwise, it's time for the start of valedictory address. Thank you so much for being present here in the Space Law, International Law session number 4. Thank you.
With thanks to the chair as well as panelists for this sessions, and immediately we are going to continue the valedictory session. Just 2 minutes it will take to arrange the dais, and we will begin with the valedictory session immediately.
A very warm good evening to the galaxy of intellectuals, invited guests, professors, students, ladies and gentlemen. I am Dr. Kanika Sharma. It's a matter of immense pleasure to stand here before all of you this evening. I, on behalf of the Indian Society of International Law, once again welcome you all to the valedictory session of the 3 days 9th International Conference on International Law and Changing Global Order, organized by the Indian Society of International Law, New Delhi. To grace the occasion, we have Professor Bharat Desai, sir, Professor JNU. We welcome you, sir. Professor Anupam Jha, Treasurer ISIL and Professor Delhi University. Professor VG Hegde, sir, EC member ISIL and Chairman of the Organizing Committee of 9th International Conference. We welcome all the guests on the dais and off the dais. I request Dr. Luther Angrezi, sir, Joint Secretary, Ministry of External Affairs, Government of India, to kindly felicitate our guest of today's evening, Professor Bharat Desai, sir. Now I request Professor Desai, sir, to present valedictory address on the title Global Order in Perplexity, Making International Law Work.
It's really a pleasure and privilege for me to be here at this premier international law institution in the heart of the city of Delhi. I'm a life member of this society, and really I greatly appreciate, I'm touched by the gesture of my former students, colleagues and friends, from different areas. We have been, although I have been, it's a very rare occasion when I come to this side of Delhi, very rarely some, like Asiatic lion rarely ventures out of Gir forest, So I rarely come. It's almost some 20 years where I have not been, barring some few occasions on an annual conference. So it's again, I greatly appreciate it. It's my special privilege, to be here, to be invited to address this valedictory, session of the International Conference of the Indian Society of International Law. Now, the task at my hand, is very simple. What I thought was, since this is an international conference where plenty of teachers and students from different parts of India have assembled here, and I just had a chance to had a cursory look at the program of the this 2-day program, where many sessions where different areas have been sought to be touched upon by different scholars, and that actually motivated me to take a particular little approach, that unconventionally, like most of the valedictory address where people simply speak up, in that. But I thought maybe this is something what I will normally do in my international law class, because the very purpose of the Indian Society of International Law is to disseminate, teaching and research in the field of international law, to promote awareness, and about the, international law as an instrument of state policy. That is exactly and I have literally grown with this Indian Society of International Law right from being a student here, for years together, So with that hindsight, with that advantage of being there, I thought this will little make some sense, because the world as we see today, it's witnessing a lot of churning, huge churning from different dimensions from which whichever dimension you look at, it's a very, very troubled times in which we are living, the time of perplexity, huge challenges,
And if you can, because there are some doubts, like in my own classroom or elsewhere also, people normally ask question that is there international law? Does it really matter? Is it really working? Is it effective? And so logical corollary which people question ask is that सब international law fail हो गया है, United Nations fail हो गया है, काम नहीं करता है. There is a lot of skepticism. Day in and day out people have been asking. Then that logically raises the question that does international law matter? Is international law relevant? Is it effective? And ultimately, what is international law? What task does it do in the international society? And that is one of the most important tasks, because you need to at least know issue rather than trying to find fault with it. And we need to also be aware that international law basically is a human construct created by human beings. It's an instrument which is given in the hands of the sovereign states, which will naturally use their own to further national interests. An instrument is an instrument. It can be put to good use. It can be put to bad use. Ultimately, it's a human nature. So what I thought was to, with a little background before I start this. I had the privilege of having a one-on-one interface with the Honorable Prime Minister of India. Basically trying to sensitize, and one of the things which we tried to touch upon was in the aftermath of the surgical strikes by India was what I pleaded for was that to take international law seriously, we need to take it seriously basically, and I tried to spell it out. And one of the requests which you make is that at the heads of state, heads of government level, at least you want your Prime Minister to speak language of international law. And I was trying to decipher that, does it really make a difference? Has it really percolated? And I chanced upon, I think some friends from the Ministry of External Affairs sent me a small video clip where it has been shown, it's about 50 seconds. I'm sorry that the specific, couple of lines which the Prime Minister is speaking, that probably has been, muted. It's not coming out very clearly. But this is available. This clip will be available. Now let me try to, give you little peep into couple of those, this is exactly what normally I'll do with before my class, series of those events in different areas ranging from migration to humanitarian crisis to sexual and gender-based violence, to environmental issues, to trade issues, to human rights issue, because people literally they're puzzled, that where is international law? And question is, does it really work? Does it really work? What kind of a function in international, like we are located as a part of the School of International Studies, that there's a basic underpinnings of the entire area of international relations, is provided by international law. It's so inextricably linked, that you are hardly able to differentiate, between international relations, carry the entire conduct of your foreign affairs, It's interwoven. When the Prime Minister of India says respect for international law, that is exactly what that clip was saying, that respect for international law. Indian Foreign Minister Dr. Jaishankar, alumnus of my own school, has been saying, commitment to international law. India's briefing document before the United Nations Security Council spoke about commitment to international law. So when you have things at the message is that at the highest level, heads of state, heads of government level, when you reiterate and underscore the very significance of international law, it does matter. And you'll see that series of those events when we will have these meetings taking place under India's presidency, G20, you'll find the heads of government coming here, the foreign ministers coming here and speaking that language. And through this little PPT, I'll try to take you through that, encapsulate it and show that different areas. It doesn't just is a pictorial. I hope. So I think this was we had on 2nd of March the G20 foreign ministers meeting. I'm just zeroed in on some of the specific paragraph with the Prime Minister of India himself saying that we must acknowledge that all multilateralism is in crisis today, and the architecture of the global governance created after the Second World War was to serve two functions: to prevent further wars by balancing the competing of interests, and second, to foster international cooperation on issues of common interest. And the experience of the last few years shows the financial crisis, the climate change, the pandemic, the terrorism, and the wars clearly showed that the global governance has failed in both its mandate. Now, most interestingly, you saw that because of the polarization and the sharp divergence of views on so far as the Ukraine crisis standoff is concerned, there are different wavelengths from which different people, the Western Bloc is looking at it differently. Russians have been saying that this is a special military operation, and India has been taking a balanced view, although India has been talking about diplomacy and dialogue and saying that, well, respect for international law. And here is because of the lack of consensus in the final, consensual statement had not come out. So this is the chair's summary, which explicitly says, this is paragraph 4 of the statement issued by the foreign minister, says it is essential to uphold international law and the multilateral system that safeguards peace and stability. This includes defending all the purposes and principles enshrined in the Charter of United Nations and adhering to international humanitarian law, including protection of civilians and infrastructure in armed conflicts. The use or threat of nuclear weapons is inadmissible. The peaceful resolution of conflicts, efforts to address crises, as well as diplomacy and dialogue are vital. Today's era must not be of war. The last line is exactly the words which Indian Prime Minister used, in his, there's a conversation with Russian President Putin, and so now this is, with India's presidency, now this is part of the final communique issued, the consensual, or it's a chair's summary. You will find it interesting, the same paragraph 4 issued by the foreign minister's summary is also, verbatim taken from the G20 finance minister statement. The meeting took place in Bengaluru on 25th of February. You'll have the complete identical paragraph 4. So that shows the consistent position, and probably this credit will go to India's presidency, the draftsman, although the statement is very long, usually G20 statements, But the beauty is at least one single paragraph right at the outset, is exclusively dedicated, for instrumental. You have the reference to the principles and purposes of United Nations, the international humanitarian law, prohibition of threat or use of force, Article 2, paragraph 4 of the Charter of United Nations. All those elements which will matter, they are there as a part of this vital paragraph. You have the reference again on the bilateral visits. So what I wanted to see was when the heads of state, heads of government meet, the question is at that level of confabulations, do the issues figure prominently? Because you'll find across the world when these global leaders, when they assemble and talk to each other, you have invariably these issues, I'm saying architecture of international law, instrument of international law, the principle and purpose of United Nations Charter, they do figure in. There are people who are very well-read, well-run, they have the excellent, draftsmen, they have the backup support teams are very good, their foreign ministers are very well-read. So what that you require, because here are the issues which are very complex. You have to, from a futuristic gaze you need to address. Now he's a newly elected German chancellor who came here, and again Germans have a different view. They have been long-standing those differentiation with the Russians, Russians and Germans, Russians and French. It's an old European warfare which has been going on. So now this is coming out with a full force. Here is a German chancellor who again talks about, now they explicitly harp upon aggression, word aggression, which has a different connotation. India has undermined, and it's very right, everybody has accepted that India's vital national interests will require not only energy but other things also. So India has been trying to moderate. So this is also one of the, I would say, one of the excellent, kind of role that you, as a moderation, role of a moderator, not the extremities, because life is not about extremities. If you can have a little dampen, like this is exactly what the Russian foreign minister came and urged the Indian interlocutor, saying that the war is going on, please come and help us to diffuse and resolve the crisis. You have the 11th special emergency session of the General Assembly. On 2nd of March, finally the emergency special session, and you have the situation, the General Assembly where the numerical majority of the states, and the resolution got finally adopted by 141 votes in favor, 7 against, 32 abstention, which includes China and India. And here are the elements where, because here the Russians don't have the veto power. In the Security Council, all resolutions have been blocked. But so was the case when we needed it. When we faced the music, we had the entire Western world war against us, it was Russians who stood by India. Every single vote which was to be taken, on issue like Kashmir and other, Russians had vetoed. You could imagine the consequences if that veto was not exercised. And this veto was not inserted in the charter in the feet of absent-mindedness. It was done with a purpose. It was done with a purpose. That in all situations of collective security, you need to have a consensus, And obviously, that these 5 big powers are, again, they're more equal than the others, Otherwise, the charter would not have been accepted, That every big power will try to do it, I will not go into the greater. But here are the issues where explicit issue about the sovereignty, independence, unity, and territorial integrity of Ukraine. It deplores Article 2, Paragraph 4, one of the cardinal principles of prohibition of threat or use of force has been articulated by the General Assembly. What I am indicating is there are many areas where future research, people will be, this is exactly what we need to embark upon. We need to put that under scanner, saying that does it really matter? The context in which this resolution, and most importantly, the legal character of the resolutions of the General Assembly. This has been an old debate, because these resolutions are recommendatory. Is there any recommended resolution which has a legal effect? That any student of international law shall have to really, my take will be that General Assembly is the plenary organ, it's a conductor of a grand orchestra, numerical majority, political organ of the United Nations. So many of the resolutions, although they are recommendatory, will have a substantial amount of normative character. Substantial amount of normative character, Not all resolutions can be dismissed like recommendatory, because it all depends who makes the recommendations, And so this is a very, I will not have the time to again go into that, but it's a very important thing where General Assembly has banked upon the 1950 resolution called Uniting for Peace resolution during the Korean crisis. So this is the 11th emergency special session, and many people have not noticed what they have tried to do. The resolution which the General Assembly has adopted after the consistent veto which was used by the Russians, in the Ukraine crisis, because people have ignored that part. What the resolution says is, what I call as the blunting the edges of veto, exercise of veto. That as and when any particular permanent member of the Security Council uses the veto, within 10 days, the General Assembly will convene the emergency special session, and the veto wielding, veto exercising the power which use the veto shall have to come to the General Assembly and explain the veto. The very fact that you are asking the use of veto, power which uses the veto, to come and explain, that itself is a huge dampening effect. That itself is a huge dampening effect. The very fact that probably many people have, again, what I notice, many people have not even paid attention. You have, for the first time, a use of force which invokes the Charter of United Nations. We also did it when we used the surgical strike only under right of self-defense, Article 51, because no other provision allows us. We did the same thing. Russians have done it. They say special military operation, Article 51, right of self-defense. Most importantly, Russian president, the statement was immediately provided to the UN Security Council. Immediately. Every single communication, if somebody does not want to see, somebody has a problem about noticing the actual working of international law, here is the actual working. Every single military operation taking place, both on the sides of Russians and the Ukrainians, is reported to the Security Council. The only thing is, the Security Council cannot take action. Security Council cannot take action because of the veto power. But the very fact, this is where the beauty and majesty of the working of international law takes place, that you report any shelling of a fuel depot or any school or hospital or church, immediately is reported. Russians also report and Ukrainians report. The very fact that you go to that peace enforcement organ of United Nations, what else will you require? And the discussion takes place in the Security Council. Except one presidential statement, no particular peace enforcement resolution could be adopted by the Security Council. And this is exactly what as a permanent member of the Security Council has the strength, because of the very inherent nature of the power they have. Now here is something, again, probably you must have seen. I'm just flagging things. People, if you read day in and day out in the newspaper, here are the issues which will inextricably have, those elements of international law. Tell evidence. If people say, where is international law? Here is international law. Russian president again addressed after on the first anniversary of the Ukraine operation, and when he says, West started the war, and we are using the force to end. So it's like a smart lawyer, like they say the glass is half empty, glass is half full. Both sides, have the story to tell. Who will decide? The time will decide. Who is right, who is not right, And I think, Russians have been saying that we have been pushed in the corner. And this is exactly what the right of self-defense is about. When a state's existence is at threat, if you go back to the time of the legality of the threat or use of nuclear weapons case, the advisory opinion given by the International Court of Justice, this is exactly what the court said. जो हमारे कहा जाता है ना संस्कृत में, नरोवा कुंजरोवा, that Ashwatthama hato, Narova kunjarova. Ashwatthama is killed. I don't know whether it was the human being or the elephant. Half truth, So the truth lies somewhere, And in a sense, that you'll try to use your whatever the capacity which is available to defend yourself, right of self-defense. Even the International Court of Justice said in the legality of threat or use of nuclear weapons that if a survival of a state is at stake, and if a state uses nuclear weapon, whether that will be legal or illegal, they say we don't know. It's like a famous Yudhishthir story. They say, I don't know. You go and you make the law and come back to us. Means the very survival is stake. It's the right of self-defense in a municipal system also. If somebody is posing a threat to you, you have the right to use force any amount just to survive. Either you kill, like in the army, either you kill somebody or somebody kills you. So survival is at stake, and this is exactly what is an integral part of the architecture of international law. The global humanitarian crisis is one of the biggest crises the world faces. Like on 20th of February, the UN relief chief Martin Griffiths went in this meeting in Riyadh, said that the humanitarian needs span across the world, and that you have the largest food crisis in the modern history. Largest food crisis in the modern history. 350 million people are really starving. And unprecedented amount of more than $54 billion worth aid that you require, and the money is nowhere available. People are dying, people are hungry, starvation, conflicts are taking place. It is going to upset the entire apple cart. One of the biggest worry in the United Nations headquarters is what will happen to your sustainable development goals. All parameters have been thrown to the winds. Completely, it has been turned to be topsy-turvy. And these are the three things with the UN Relief Commissioner has zeroed in. One, old wars don't end as new ones start, like the Democratic Republic of Congo. For decades together, Congo is a turf war. More than 17,500 UN peacekeepers are stationed in Congo. Even UN peacekeepers themselves are being attacked. Look at the crisis. We ought to know. I've written on that part that when the humanitarians themselves are under attack, what do you do? And who becomes the sacrificial lamb? Who are the cannon fodder? The Indians, Pakistanis, Bangladeshis, Nepalis, Sri Lankans. Because the value of life in this part of the world is very, 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 very low. Is they provide the peacekeepers. I think often we have the dead bodies coming here. Indian peacekeepers have been attacked. Like in a UN compound, the rebel groups launched the attack. So what I'm talking about is, you have one of the biggest, how do you rein in those warring groups? How do you rein in the people? And many of the countries, the resources have become the curse. And I suggest you, if somebody has the interest, please, listen to the speech given by Denis Mukwege, the recipient of the 2018 Nobel Peace Prize. He said, my country is among the most wealthiest country in the world, but it's among the most poor. Our resources have become our curse. Warring groups, rebel groups, diamond mines, gold, cobalt, nickel, the multinational corporations, they are playing the proxy wars. The entire African continent, if you can see, the conflicts are raging. And who will stop them? Now you put the blame on United Nations, you find fault with international law. What can international law do? International law cannot penetrate into the minds of the people. Like if you look at the preamble to the Constitution of UNESCO, it says, the seeds of war lie in the minds of men. And by building the defense of peace, we'll be able to usher in a new world. The Charter of United Nations says the scourge, युद्ध को अभिशाप कहा गया है. It's appalling evil. Then why do people fight? You have a huge amount, and then you assemble here where you ask people to donate money. And money is not available. People are starving. And we saw that both in our neighboring countries, when there is a standoff in Afghanistan, when Taliban simply, stormed to power there, in utter defiance of all international norms, you couldn't do anything. You couldn't do anything. All diplomatic missions, they had to run away. India had to abandon our own those billions of dollars worth projects there. We couldn't send the relief material. We decided to give 50,000 tons of wheat to Afghanis, and you have to cross the Pakistani border. We gave it to the World Food Program. The convoys are not going. Look at the problems. And if it falls into the hands of the rebels, again you have no control. We send some 20,000 tons of rice to Sri Lanka, for instance, when the people were starving. So look at the world in which we live, When you have a huge crisis on your hand, there is no time for ideological warfare, There is no kind of writing in those glossy things, in a very, very difficult to understand language, highly complicated English, language. When you write those things, you need to have what my plea will be, solution-oriented thing. The world needs solutions. World needs ideas, because there are human beings involved. Not only human beings, your environment, wildlife, nature, everything. The very, very survival it will be at stake. You have other issue which came up, probably, I don't know how many of you noticed this, when the United States, Senate passed a bipartisan resolution, and, recognizing Arunachal Pradesh as a part of India. Because we still have a problem with the Chinese. Whenever the Indian Prime Minister or the President of India visits Arunachal Pradesh, Chinese protest. They say this is a disputed territory. So when you talk about, here is the issue of recognition, visits of heads of state, heads of government, or endorsement from the most important part is the US recognition of the McMahon line, which is during the colonial period. Obviously, we have the issues there, but once you recognize the McMahon line, many of these issues, will be resolved, I think, so this is a very, very important milestone. I think this will require more scrutiny. I'm saying that here is one of the most important, instrumentality of international law, recognition or providing sanctity when the states will accept, those disputed territories, which are part and parcel of those things. You have another facet which probably you must have seen, many of the people have been fascinated but have not attracted much attention, is this transcontinental translocation of animals. Look at that part. If somebody says there is no hope, here is the hope. That these animals, very beautiful animals, creatures, they become extinct. You bring, you see, hear the stories. There's entire jumbo carrier, brings those crates of cheetahs. Initially 8, then followed by 12, I mean, completely different habitat from Namibia and South Africa. Some 20 cheetahs have been released into Madhya Pradesh, Kuno National Park, And how much planning, everything. And you have the bilateral agreement. So probably what we will require is, again, little push, giving a push to strengthening of the international wildlife law. You'll need to, because why the species become extinct? Because there is a trade. Huge thriving trade. The tiger, elephants, or rhinos, for instance, they get killed. It's a multi-billion-dollar business. You need to see to be believed, the kind of the pictures which are available. Or like what people call in many of the African places, called the blood diamonds. Blood diamonds. You wear this, those things which are basically from the skins of the animals. You carry the blood of animals on your body in the fashion parlors of Europe and elsewhere. So one of the most important, here are the issues which we need to really place them under scandal. If the lawyers have to play the role, if the scholars have to play the role, here are the issues where you need to come out with those things, that what do you do? How will you do it? How will you make this international law, these different facets of it? Time will not permit to go into those different areas, but I'm just flagging the broad area. You need to fill up the lacuna, fill up the gaps, Here is another crisis on the other hand, the sea level crisis, global sea level crisis. They say the sea level is actually rising, and the impact of the rising sea is already creating new sources of instability and conflicts. Large part of it, probably you have seen in India's coastal areas where the flood waters are really, gushing in and absorbing entire communities. You have the vanishing coastlines, endangered nations, forced migration, competition over natural resources. Many of the island nations are afraid that they might be submerged, completely submerged, like Maldives or like Sri Lanka, or even in so many parts of India's coastal areas. They say because of the rising temperatures, the seas expand, the sea level they rise. And this is the highly unprecedented, the WMO figures they show that the global average sea levels have risen faster since 1900 than any time in the preceding century in the last 3,000 years. If somebody says the telltale effects of that, global warming and the rising sea level, that scientifically it's being shown that in last 3,000 years what you have noticed, because it's happening at a particular level which will be unbelievable. It has a huge kind of consequences. And the global oceans have warmed faster than the past century, than any time in last 11,000 years. The oceans are getting warmer and warmer. And you can imagine the consequences. Once they become warmer and warmer, what will happen to the entire, lives, which are there, the fish and all the creatures which are there, what will happen to it? You have lot of whales, coming to the coastline, completely, they get suffocated. There are many coastlines where you find the dozens of whales or sharks coming and simply, getting suffocated and simply dying on your coastline. If you imagine a situation, if that happens here, all marine life coming to the shore, because they become breathless. Plenty of plastic is there. By year 2050, if you do not change your ways, there will be more plastic in the oceans than even fish. All your land-based sources of pollution getting dumped into the ocean. So here are the real thing. That is exactly why, and especially when we talk about the blue economy. Indian Prime Minister has harped upon the blue economy. If India has the stakes, and there are other challenges. I have not mentioned about the maritime piracy. Indian Parliament has just passed a law on combating maritime piracy. Indian Navy and Coast Guard will be there. So there is other threat, when you talk about the blue economy. You have again the Operation Dost, which India has been doing that. Now people say what it requires. Basically it's a committee of nations, international cooperation, friendly relation. Within no time, you can see the empathy immediately. And if you see the pictures and those moving accounts, the Indian Air Force flight carries those 99-member Indian team member led by, including Major Beena Tiwari, who set up 8 hours they travel, they go through the Arabian Sea because you can't, overfly the Pakistani territory, 8 hours flight, then further 5 hours of road travel, setting up the hospital, you don't sleep for 2-3 nights, and immediately the hospital must start working. Look at the relief, and you don't know the territory, you don't know the people, and still you just bring out the bodies, from that wreckage. You carry the machines and everything you carry with you. Look at that part, huge, gigantic. Within no time, you respond to these things, And here is the Turkey, Syria, more than 42,000 people got killed. This is one of the example of nature's fury. And here is the example where you need the tightening or working on what I would call it the, international disaster law. International disaster law. What will you do with these ecological upheavals? In fact, I wrote one of the piece, almost at the outset of my career, and if somebody is interested, it's available in the Social Science and Medicine Journal on managing ecological upheavals, which sought to mention, for instance, called for the Comprehensive Global Convention on Mass Disasters, encompassing sharing of data, transfer of disaster management technology, developing countries, to the developing countries, the need of the hour. So this entire disaster law, both man-made and human, because these things are going to grow. Earthquakes, tsunamis, pandemics, huge amount of things. International health law again needs to be revitalized. I'm just flagging the nature of the challenges which you face, And there is a huge room for the scholarship, international law scholarship, to contribute to those things, additional contributions, आपके पास झगड़ा करने का टाइम ही नहीं रहना चाहिए. There is enough time, enough time. More than any multiple lifetimes you can spend to address these issues. And I would say, from the rostrum of this Indian Society International Law, I will urge everybody to come together, and apply that. This is a very constructive, creative, it's a humanitarian work. If you cannot do justice to that instrument of international law, we'll be really failing in our duty. You have the again issue. I've just flagged it. I will not go in. Female genital mutilation. More than 200 girls and women have been subjected to FGM throughout the world. More than 4.3 million girls and women will be subjected to FGM in 2023 alone. 2023 alone. These are the United Nations figures. They talk about elimination of FGM. We have published a full article, if somebody wants, in Indian Journal of International Law, Society's flagship journal, in 2020 on elimination of female genital mutilation, making international human rights law work. Please take a look at that part. How much is the kind of the appalling crisis we have? And the domestic implication, we have a case, Sunita Tiwari's case, pending before the 9-judge Constitution Bench of the Supreme Court of India. 9-judge Constitution Bench. We don't know when that will come up for the hearing, but here is the issue. You have a real issues, And they say, where for all non-medical purpose, more than half of the United States, those constitutional units have prohibited the FGM. European countries have prohibited. African countries have started prohibiting. Look at the things. The question is this instrumentality. The entire framework on which you work, is international human rights law. You have about half a dozen special rapporteurs of the Human Rights Council, which have been really concerned about it. On violence against women, there is a UN Special Envoy, Secretary General Special Envoy Pamela Patton. She is looking at the violence in conflict zones. Look at what I'm mentioning is look at the activism, look at the engagement, look at the resources involved. So please don't be dismissive कि सब UN कुछ नहीं करता है, खत्म हो गया है, fail हो गया है, वो क्या करता है, ठीक है? वो gossip में चल सकता है. You don't know the kind of the nature of the people involved, the kind of the pain and the suffering, the kind of the risk people face. I've written something on the risk with the humanitarians face. You go in that firing zone, you go in where your lives are at risk. You don't know whether you'll come back alive or not. In fact, I had a chance to talk to the former president who had just demitted office, Dr. Peter Maurer, for years on a Skype call. And I told him, I said, how do you muster up the courage to move from Haiti to Yemen to Sudan to Ukraine, And he said, at the end of the day, I am really convinced, I really hope against hope, that these forces which engage in death and destruction, mayhem and killing the people and causing, they say they are not invincible. They are not invincible. So what do you do? How do you do? Hope against hope. There are death and destruction where there are people are wailing, starving. There is nothing there. It's a completely ghost town here. So huge amount of things are there where we need to address. There is another issue which again became a bone of contention. Like Bangladesh foreign minister on a visit to Sri Lanka ran into the Pakistani foreign minister and asking for the accounts. कोई कहता है ना सब कि हो गया भूल गए. It's a past is past. This is exactly where the past will haunt you. It doesn't leave your track. He said, you owe an apology to us. And Pakistani foreign minister, she said, we have our compulsions. Because she knows that she cannot even go home if she tenders an apology. But you have to account for it. Here is a monument prepared by the people, on the outskirts of Dhaka, Mujib Nagar, showing that more than 200,000 to 400,000 Bangladeshi women were raped in the last final days of when the Pakistani army surrendered. When they surrendered, still, because they thought they will hit where it hurts you most. The sexual and gender-based violence. They thought the rape is cheaper than the bullets. And that is why most of the conflict zones, rape has become the norm. Because it hurts you. It's a naming and shaming. And most of the things, is not even raised before any of the criminal tribunals also. And this is one of the most important issues which has to be yet to be cracked. One of the, and as I said, 2018 Nobel Peace Prize to Nadia Murad and Denis Mukwege was exactly to focus upon this kind of a inhuman, most atrocious kind of a shame that we have. Other issue which I'll quickly wind up, is like a lot of people have been talking about the Indus Water Treaty. We know 60 years have been over. I just wrote a piece on environmental policy and law. 60 years of the Indus Water Treaty, in the era of climate change. A look ahead in the hydro diplomacy and treaty law. Now, there has been, because this is a unique treaty where World Bank is sitting there, and there is a receding flow in the all the tributaries of Indus. I was a coordinator of an inter-university consortium, 4 universities, Sikkim, Kashmir, Jammu and JNU, with 18 crore rupees given by Department of Science and Technology. It's a sin to be believed how much, the shrinking of the Himalayan glacier is going to pose a threat in the years to come. The water flow will be receding. So if the water itself is less, what will you share with them, And we have been talking, the Indian Prime Minister has been talking, blood and water cannot go together. Or some people have been saying, turning off the tap. You can't turn off, you can't, switch off Satluj River. And you have not been able to use the water. Most of the water goes, into the Arabian Sea. Now, finally, what I wrote in 2021, saying that, it will require India to take the lead from the front to bring the review of the 1960 IWT, especially in the light of the climatic changes, to the negotiation table at an appropriate time. For the timing, it needs to be celebrated that IWT has stood the test of time for 6 long decades. It will necessitate a common understanding and sagacity among the Indus Basin riparian states for the future betterment of the common hydrological resources in the interest of the teeming millions of citizens. And ultimately, we did serve them the notice, finally. Now, under what provision, whether that will matter, whether is it a fundamental change of circumstance, which will require, because the Indus water, the IWT does not provide for withdrawal. There is no provision for withdrawal. In the changed circumstances, on the ground that the glaciers are melting, the river, the water supply in the Indus, all the rivers, is declining. And also interestingly, as this article itself spells out, it was some time ago, even Pakistani Senate also passed a resolution saying that we need to have a revision of the Indus Water Treaty. Because it's a very complicated issue. Each time India is being dragged to the things. Our former student, Luther Rangreji, he is the joint secretary. He can tell more about it, how much it costs us whenever we are dragged to an arbitration, Kishan Ganga arbitration. Millions of dollars you end up paying, to the permanent court of arbitration for any trivial issue. Pakistan, rakes up the issue. And so the question is, it enhances the cost. And we don't have the bilateral relations at that level where you can sit across and come out assessment of the common hydrological cycle. It will require, maybe, we don't know how much time it is. But probably, we are bigger ones. We have, this treaty itself is a sign of India's magnanimity towards Pakistan. We were very generous. जो बड़ा है वो तो वही तो जनरस होता है. छोटा दिल और छोटी सोच से कभी दुनिया कभी नहीं बनती है. Nobody has been able to. This is what former Prime Minister Atal Bihari Vajpayee said, that with a small heart you cannot become great, and with a small mind you cannot be standing tall. So again, it's the onus is on us, and probably since we already fired the salvo, let us see whether Pakistan comes around and what response they give so far as the revision of the treaty is concerned. Grave threat to international peace and security. I'll quickly again. This was January 2022. UN Deputy Secretary Amina Mohammed, she went and said, this is one of the biggest issues, the grave threat. Plenty of resolutions I'll suggest to you. Please take a look at the resolution of General Assembly. They run into something more than 300. Each of them are very painstakingly designed, even if they are recommended in nature. Look at the churning which is going on. Somebody thinks about it, somebody worries about it, somebody works hard, somebody lobbies for it. And again, for the General Assembly itself does. And here is an example which again, the UN General Assembly, took the initiative to refer the issue concerning the occupied Palestinian territory to the advisory opinion of the International Court of Justice. Although we know that its advisory opinions are advisory, in 2004 also the International Court of Justice gave the advisory opinion and Israel simply sat over it. But Israeli Supreme Court also said this is a violation of international law. So what will be of impact is whether we need to take a call, whether the case study or the scenario which prevails in the occupied Palestinian territory, because we also have our own area under Pakistani occupation. It's called Pakistan occupied Kashmir. The law of occupation, the whole law of belligerent occupation will be at stake, And it remains to be seen whether we take a stand, because we have to do the homework. Again, the same thing will apply. And the advisory opinion given by the International Court of Justice will have a thing. Again, the UN Secretary, I compare him in one of the recent things which I wrote last week, saying that the plight of the UN Secretary is akin to a lonely house sparrow. When her forest was on fire, she was running from pillar up to post, asking everybody to save the forest. You can listen to his speeches everywhere, because he's a politician, the former Prime Minister of Portugal, he has a political stature, so he has the capacity to shout. Sometimes you shout, you complain, you speak, you remember, you speak, and you bring the issue to the forefront. If you too much you shout, somebody will give attention to you. And he's the Chief Executive Officer of United Nations, and he says, plenty of things, Like Burkina Faso, again, abduction of women and girls. Look at those warring groups, Boko Haram and IS and plenty of them. The plight of the women and girls who live in those conflict zones is unbelievable. Mass abduction of the girls and women. Still, as if, it's a medieval, period where they were used, still they say they are used as a bushwives. Most of the warring groups, they use them as bushwives, like what the Japanese did in the Second World War. They set up a comfort stations, with the girls and women who were taken, from the Indochina, for instance, That made the Japanese very unpopular. Very unpopular. People still don't trust. Here is the example where, you imagine the life of the people there, for instance. The other issue, like the world energy transition, probably we are waiting with a gasping for the fresh breath, where, how will that happen? We have to move away from the fossil fuel economy, which is one of the most polluting, cancer-causing, and huge cost for a country like India. Thankfully, since we have the excellent relations with the Russians, and we have got the cheaper oil, we have got the rupee-ruble trade, etc., our economy has survived. Our economy could at least weather this storm. Without the Russians, that cheaper oil, we would have been devastated. But the question is, in the sooner or later, we have to move away from the fossil fuels. The time has already come. Whether we go for the solar, we go for the hydro, we go for whatever the other renewable source of energy, wind power, geothermal, that we have to find. Each one shall have to find the resources. You need energy. And the question is, how far we'll do. India has mooted that body called International Solar Alliance, already set up in Gurugram. But I'm told that most of the money India herself has invested. Most of the member countries have not. So we have to probably take a call. The estimate is by year 2050, more than 90% of the global energy could be from the renewable sources. That itself will be thing. But we have to move away. Don't need to open new refineries. You don't need to have the new oil wells. You have to move, and that will take a huge political cost. Like what the Germans did. They switched off most of the nuclear power plants. Moved away. Took a political decision when the Green Party came to power. Green Party was one of the critical alliance partners. All nuclear power stations stopped. France is doing it. They're huge component. They encourage every single home to go for geothermal. Can we do it? Like we already have in the most of the urban cities about the solar panels and other things. So we shall have to move that. We shall have to walk the talk. Okay, but we need to have the policy, legal instrument, institutional architecture to have that huge, I would say, historic energy transition which the 21st century will call for. Without that, we are going to be having in an unbelievable kind of a crisis. This is something, a book which came out, that we need to again know as to what goes into the things, when actually we celebrate the writing of the judgments of the international courts and tribunals, what called the everyday makers of international law. This probably I thought I'll flag if somebody has the interest, you can pick up this, somewhere from the literature, Or women fighting for the rights, again under this is what I'm talking about, 31st of December, when the word came, the year came to an end, around the world, half of the global population facing that kind of unprecedented kind of a crisis, ranging from Afghanistan to African countries, or even many of the other countries, One of the most vulnerable, and you have your own examples, where, they are like even women also bear the consequences of the climate change, The violence during the pandemic, unbelievable amount of kind of the violence took place, They say both the perpetrators and the victims were confined to the same place, Violence has really spiked during the entire pandemic period, And they say 1 in 3 women globally have been subjected to sexual violence once in their lifetime. Look at the figure. Unprecedented amount of violence which take place, and we know it very well. What happens in the heart of the capital of India? We have the law, we have the stringent penalty, the death penalty. It doesn't deter any of them. So mere existence of a law, that per se, so कोई कहता है सब international law क्या करता है, international law क्या करता है. International law cannot go and catch hold of the people, cannot go into the minds of the people. Harshest penalty thing. Again, that is exactly why you need the mindset, attitudes. That's exactly what the education, role of the education is there. You must hope against hope. You must believe in something. You must remain engaged. And that is exactly the story, you find the changes are coming around. Large number of the areas where the changes are coming out. Here, femicide, countries like Mexico and Brazil, large number of women being gunned down, killed. Figures are unbelievable. They say you come out of the home, you don't know whether you return or not. Simply gunned down. There is so much hatred, so much venom. Societal structures are such where there is complete insecurity. The figures are again they say more than 1,000 cases of femicide last year, in Mexico. 1,000 women gunned down, simply. Mexico, Brazil, Latin American countries, So femicide has emerged as one of the biggest issues. You have the issue like global migration. It's only I have seen the United States-Mexico border, seen to be believed, how the people simply want to flee, to simply want to run away. The entire fence is electrified, and yet you are not deterred. By somehow you want to do it. I'll just wind up. You have the plenty of more than 2.2 million migrants, they faced encounters during 2021 and September 2020. 2.2 million migrants, who simply want to get out. Sheer desperation. I don't want to go into the stories of how the entire Mediterranean Sea has become the ground, where boats are sunk by the Italian Coast Guard periodically. Large number of people from Punjab, Gujarat, Kerala, youth, they are lured by the people. हमारे गुजराती में कहावत है, हिंदी में भी है कि जहाँ लालची लोग होते हैं वहाँ धोखेबाज लोग भूखे नहीं मरते हैं. If there are people who are greedy, the cheaters will not go hungry. And that is the example, because your society is such. कहाँ जाना है? Foreign जाना है. Minimum LLM of a foreign degree will be required. Foreign, F capital. If that is not a case of colonialism, what else it is? What is foreign? We are so crazy about the foreign. So you are paying the price. People simply run away. People simply want to run away from that risk zones, You have Afghanistan. I don't want to again mention much. All women have been put behind the veils, completely with the stroke of Taliban coming to power. And all the crimes committed by Taliban have gone unaccountable. When Taliban came to power, some of the veteran Indian diplomats, who are very practical, काफी समझदार लोग हैं. Retire होने के बाद लगता है कि कहाँ दाल गलेगी, वो हमें निकालना है. तो said, let us recognize, let us with Taliban, let us talk to them. How can you talk to a renegade element which has committed those unbelievable crimes, You need to close the chapter. You must hold them accountable. And you saw, Government of India put it on hold. We will talk to them, not have any truck with the Taliban. They have to account for it. And all the things. And United Nations cannot do anything. The Secretary is pleading. The special envoys are pleading, saying that you allow them to come out of home. Let them have breathe fresh air. Education, forget about it. Employment, forget about it. You are talking about like a medieval times, for instance, And this is one of the biggest things, where Americans were part for 20 years in Afghanistan. They bought their way out, all for 20 years. And suddenly you vanished. You had a bilateral agreement with the Taliban, so-called Amirat of Taliban, Islamic Amirat of Taliban, and you ran away, simply. A superpower runs into an agreement with a non-state actor. Unbelievable thing. For their own interest, they came for their own interest, ran away for their own interest. And Taliban now has become law unto itself. Question is, how will you reign in Taliban? What will you do? That is one of the biggest challenges that you will face. You have the scores of terrorism, as you saw, as our term to the Security Council came to an end. The Indian Foreign Minister personally went to New York, chaired a session on 15th of December, and this was basically about the acts of terrorism, where Indian sponsored resolution, UN Security Council resolution 2664, 9th of December, that you need to at least, it will be worth reading, where India, this is exactly where our leadership could be there, but people don't share your wavelength. When we wanted, India wanted, Indian Foreign Minister wanted in the draft, when the statement came out, we wanted the terrorism to be considered as an existential threat. Everybody disagreed with India. Resolution was adopted by 14-0. The irony was, since President of the UN Security Council has mooted the resolution, Now you can't vote against your own resolution. You can't vote against it. So we had to abstain. So 14 to 1. Look at it. This really calls for your leadership, you know. Okay? You need to really do the soul searching. And people wanted it to be one of the most serious threat to international peace and security. Full stop. That's it. It's not there. Of course, they say more than 8,000 terrorist activities. So, but they say, well, it's one of the threats. For us, we call it existential threat. So completely so you have a different perceptions in a global order where terrorism, you know, really is rampant. So question is, how will you articulate? And so we need to keep engaged, stay engaged, and talk about that part, saying that, again, you cannot have selectivity when acts of terrorism are there. This is exactly what the Americans didn't listen to you till the 9/11 came up, you know. Once it hit them, they thought, yes, it's a real challenge. So you have to, I think, show them, but at least it was probably fruitful. We could have really pushed the envelope during our presidential this membership of the Security Council, but now we shall have to wait for, I think, maybe next 10 years, when again, India shall have a chance to be a non-permanent member of the Security Council, because the permanent membership, you know, is still elusive. We don't know. I don't think any in the foreseeable future you will have that, and I don't think we'll have other things coming out. Planetary crisis, again, the whole global environmental crisis is heading to a situation when you are saying that moving from a common concern to a planetary concern, at a planetary level kind of a crisis, which every single part of the world you are facing that crisis. And this was the COP15 meeting of the biodiversity in December, where you can look at the harmful subsidies which might come under scanner. You have 30% of world's lands, oceans, coastal areas and inland waters, you know, which need protection. So your human habitation, human use itself has become one of the menace, you know. So these are the things which we need to really prepare, the things which require a phenomenal cost. I have not included the desertification, where India wants 30 million hectares of land to be reclaimed, you know, out of it. You know. Look at the nature of the challenge: biodiversity, desertification, and here is the climate change. If somebody wants to read my preface, you know, it's environmental policy and law. The issue has just come out, issue number 5 on 6 in December. Almost a dozen articles, you know, will come out with a special, including by Daniel Bodensky, you know, on what I call as the climate change conundrum, where the most serious part is most of the developing countries have what is called, popularly called, backtracking from their commitments. The agreement is there. What will you do with the agreement? You don't care. Money is elusive. So we are running that, and I remember fondly, one of the very finest, Indian diplomats, who is no more. Only day before yesterday he passed away, Chandrasekhar Dasgupta. I really fondly remember my association with. I used to be part of the India's official delegation to multiple kinds of negotiation, especially on climate negotiation. He was one of the pioneers. When this whole principle of common but differential responsibility was mooted, he was the most articulate, ace negotiator from Indian side. So when we know it, when we do the homework, when you know the intricacies of international law and do the homework, it works wonders. When India takes the leadership, but you need the homework, you need the clarity. And who will do the research? Who will do the homework? That is one of the biggest challenges. So I think this is exactly, and probably we are heading toward a situation, where, many of the people are not aware that the General Assembly has passed a resolution calling for a summit of the future on 22nd and 23rd of September 2024. So it's 1.5 years, countdown has started. What lies in the future, we don't know. India shall have to take the lead so far as the preparation is concerned. I'm already engaged into calling for additional contributions from around the world, almost, and people have provided me 55 additional contributions in last 2 years, 55 additional contributions from all parts of the world. 2 books have come out, the third is in the pipeline, International Climate Change Law. Probably in the next couple of months it will come out. So what I'm saying is, from a scholarly domain, you need to remain engaged. It's an ideational matter. It's not necessary that you need to be sitting in Harvard, MIT, or Stanford. It's doable. It's possible. We need to take it to that level. So I'm sure this is going to be the kind of the new challenge, new orientation. Again, multilateralism, where India took the things on 14th of December. Again, Pakistan occupied Kashmir issue, which Organization of Islamic Conference, when the Secretary General visited, we protested. Again, this is the flip side, where we always protest about the legal character or sovereignty of a particular territory. And we lambasted, I think the External Affairs spokesman said that any attempt to interfere in meddling in India's internal affairs. So these are the issues. When somebody visits your area which is disputed, you really, shout at them. So this is again a very integral, consistent practice, you know, where you don't want any acquiescence, principle of acquiescence to be applied, and this will be very important. Gender parity for equality, again, United Nations system is buzzing with the whole idea, where more and more women representation throughout. They say almost they reach the, you know, in the higher echelons of the United Nations, you know, where the, you know, they say it's vital for the United Nations to have it, you know, and there's a global shift in the recognition. When many of the countries, you know, in 1945, San Francisco Conference did not even allow women to vote. Just, we have started from 1945, when all those 51 delegations present in San Francisco, that opera house in San Francisco, the country member delegations did not allow women members to even vote for their country. And now we are here, you know, year 2023, you know, in the beginning, where, you know, you have almost heads of state, heads of government, you know, members of parliament. Now, the latest figures show that every single country which boasts of a parliament, now there are women members of parliament. We have reached to that level. Global gender gap is one of the biggest issue. You know, I'll you know, urge people to take a look at 2022 global gender gap. It's again an unbelievable kind of a one half of the population. You don't consider them to be even the equal. That is one of the biggest challenge, I would say, for international law. Advent of the new technology, I will not go into here is the Punjab sector, where again you have the drone, menace of drones coming out, and you shoot it down, carrying a lot of narcotics. It's a hidden war going on against you. The question is, what will you do? How will you regulate the new technology which is really sweeping the whole area? You don't need the physical weapons, you know. You have the things, you know, each time how the border security force, you know, and you have the narcotics, weapons coming out. So that is again, you don't see the enemy, and the things are coming. So we face, I think Punjab border has become really a problematic, where you need to really find innovative solutions. We do it. Obviously, we are trying, but the very nature of the problem is such that you need to really rise to the occasion. And finally, you saw that this picture, you know, from my own home state, my very near to my own place, you know, where this family of 4 people, they came, there are, as I said, you know, कि जहाँ लालची लोग होते हैं, वहाँ जो धोखेबाज लोग भूखे नहीं मरते हैं. Each of them, they were brought here, they were trafficked. Delhi is the hub. People are brought to Delhi, taken to Calcutta, and from there, you know, taken to long flights to Canada, and from Canada side, they are pushed into the American border. This family of 4 were frozen to death in minus 39 degrees temperature on January 19, 2022. And that shows, you know, no reversion was caused. किसी के पेट का पानी नहीं हिला पूरे मुल्क में. किसी को नहीं लगा कि सब we must stop it. Canadian government woke up, they said nothing doing, never ever will allow anybody to die on our borders. And they're not from a very ordinary, they're all comfortable family. Have a huge three-story mansion, lot of agricultural land. So why do people migrate? Why do people leave? पंजाब में जो होता है ना, हर घर में ऊपर पंछी लगाया हुआ है कि पुत्र वहां है. पुत्र क्या करता है? हिथ्रो एयरपोर्ट पर झाड़ू मारता है. पुत्र टैक्सी चलाता है. That is a matter of pride for you. वो प्रजा को क्या करोगे आप? So we need to at least do the soul searching. ये हमें खुद को इसका उपाय ढूंढना है ना. Why do you run away? Why do you run away? And I think this is again a very big issue. I will not go into that. And trafficking is one of the most important issues. You have a United Nations Convention against Transnational Organized Crime. So here is the convention I thought I will bring to it. So just to wind up, I just provided you little peep into this pictorial kind of developments which have been taking place, some about 30 issues which I thought, and I thought this is the right occasion when plenty of people who presented those research things and questions. I'm sure this is literally, I would say, food for thought, and on the premise of the Indian Society of International Law, and I hope and pray that, well, many of you who come from different parts of India, you know, hopefully you'll take a cue, at least with that kind of a belief that here is a instrumentality of international law, which is primarily, you know, which will further a state's interest. The instrument it works. So the question is, if you have howsoever perfect or genuine instrument or a system is, if you have the dishonest intention, you can't blame the instrument, you can't blame the system. Who doesn't let international law work? It's a human beings, people themselves. So you need to educate them, you need to really prevail upon them. You need to ensure that issue, you know, that what leads to warfare, what leads to conflicts, what leads to this entire atrocities, the exploitation of the human beings by human beings, migration, trafficking, violence. And every society shall have to find the things. International law can only reflect upon it. So what I'll appeal for, you know, it requires a hardcore research in all those areas of international law. It's a huge challenge. I'm sure probably, what I call as the taking international law seriously. And I hope and pray that most of those law schools, which India has a mushrooming growth of the law schools, apart from teaching, apart from prioritizing that teaching, at least you leave some scope, which will help India to resolve our own problems, so legal problems, and India which wants, jo kehte hain sab ki, we want to be a Vishwa Guru. We want to be sitting on the global high table, and you need the ideas, you need the solutions, you need that cutting edge research. I hope that people here, and especially, since ISL has one of the biggest libraries in international law, these things will percolate down, it will inspire a lot of people, and I hope and pray that things will take a better shape for the future. Thank you.
Many thanks, sir, for such a detailed, insightful, and lively presentation. Now I request Professor Anupam Jha, sir, to kindly give the address to the gathering.
Good evening, namaskar, shabba khair, sat sri akal. We have reached the valedictory session of this 9th International Conference 2023. I hope that this might have been truly delightful and enriching. On this last session, I must appreciate the people who have played a great role in making this conference a truly memorable one. First of all, I must appreciate Professor Bharat Desai for his kindness to grace today's occasion and share his thoughts with the participants. His words are always sagacious, and you might have seen that his words are truly embedded in international law. He has devoted himself fully on the promotion of international law in our country and also in many other countries. It was he who forged friendship with many universities to collaborate in international law, doing research in international law, including Delhi University. It was he who provided opportunity to me to meet Professor Hegde, who is also on the dais. It was he who made me to write, some papers in the areas of climate change, as I was thinking that how important is the area of climate change in the current times. And I have also taken interest in writing on renewable energy and all. As you might have seen that there would not have been any other person better than Professor Desai to give the valedictory address today. I must tell you, Professor Desai, that your followers, your friends, and your students have made this international conference a truly successful and memorable one. I thank you once again for sharing your thoughts with us. This Society of International Law is led by Senior Advocate Padam Shri Praveen H. Parekh, and I must appreciate his kindness in hosting an inaugural dinner for all of you, and perhaps you must have enjoyed it. So, although he is not here, but I must profusely appreciate the gracious thing that he had done. Apart from that, I must appreciate today the academic committee members of the Executive Council of Indian Society of International Law, especially Dr. Gandhi, Dr. Johar, Dr. Aftab Alam, Dr. Luther, Dr. Chakka, and the Conference Academic Committee, which has been headed by Professor Hegre. I also appreciate the special panels supported by International Committee of the Red Cross, UNHCR, Center for International Trade and Investment, and WHO to make this conference really international. To further make this conference truly international, I must put on record the support provided by Dr. Sunil Agarwal for roping in South Korean scholars to constitute the Law of the Sea panel in this conference. I appreciate the physical presence during the various sessions of many of our life members, including Professor B.C. Nirmal, Sri Narendra Singh ji, Vijay Kumar Singh, M.K. Rao, Rashmi Salpekar. Apart from that, Deep Shikha ji. Apart from that, I must also thank Dr. Kishore Singh ji for gracing many of our programs in this conference. I must take note of all the members of Organizing Committee of International Conference, namely the Deputy Director, Sri Vinay Singh ji, and all assistant professors of the society, without whose sincere efforts this conference would not have been successful. Lastly, I must say that the staff members of Indian Society of International Law have done a very good job to do all the things, do all the logistics very successfully. There was no hiccups in the organization of this program, this conference, for the last 2 days and 1 evening. I must appreciate all the participants who have come from all over India and abroad to present and participate in this international conference, which has truly made it, a very successful 9th international conference hosted by Indian Society of International Law. And this Society of International Law was established in 1959, and today we have concluded the 9th international conference of our Indian Society. So it's a great journey that we have finally accomplished. As far as I am the treasurer of the society, I have given free hand to organize this international conference with the help of the Executive Council members. So this program is also successful because of the support of, I said, Ministry of External Affairs, who have given a lot of financial support to finally make it successful. So thank you so much for all of you who are present here today, and to make this international conference a successful one. Thank you. Jai.
Thank you so much, sir. Now is the much awaited time, that is distribution of certificates. But before that, I request Professor V.G. Hegre, sir, to propose formal vote of thanks.
I'm not going to take much time. Already Professor Anupam Jha has already mentioned many of these things. First, let me thank him for chairing the valedictory session. And also I wish to thank my colleague, senior colleague, Professor Bharat Desai. I think his talk actually provided the excellent valedictory sort of an address to a program which we called Azadi Ka Amrit Mahotsav and International Law. So he covered range of issues which included both the global and the Indian context. So I think it was he gave various references to various problems, issues and why we should take international law seriously. And this is his passion. I know him for many, many decades now. So he has been arguing for why we should take international law seriously. So I think he continues in that mode, and then he has given us a treat for last 1 hour about this. I'm sure many of you who are here, young scholars, will take it. And I already, Professor Jha has mentioned, but still let me thank the President, P.H. Parekh, office bearers, and the EC members. And let me also thank Dr. Shikhar Ranjan, who was the Secretary General till recently, who actually formulated and did a lot of good work. And all the chairs of the sessions, including some of our esteemed EC members who gave time to chair the sessions, and all participants, and particularly young scholars. Actually, they thronged the, our society, and it was really nice to have them, spend time with them, and particularly many foreign delegates, already mentioned by Professor Anupam Jha, and also who came online. This is a hybrid mode conference, and there are many life members and associate members have actually could able to, and many of them have written to us that they could able to watch and then listen to some of the excellent presentations made by many of you here, including many of the foreign members from wherever they are. And then let me also thank, I already said it, but still I must say, as the chair of the organizing committee as constituted by the Executive Council, thank Dr. Luther Rangre ji, Professor Manoj Kumar Sinha, Professor Anupam Jha, of course he is the treasurer, Professor Rashmi Salpekar, and Dr. M. Gandhi. These were the constituting the organizing committee. And then we also had a finance committee which was headed by Mr. Sanjay Parekh, but of course Anupam Jha, Professor Anupam Jha is the sort of, who is the one who actually take the most of the burden. And with Professor Manoj Kumar Sinha as part of the finance committee, and then Mr. G.V. Rao and myself constituted this committee, which actually could able to arrange this program for 3 days. Then, but at the most time he said, but still already I just want to say, all our teaching and research staff, which included Vinay Kumar Singh, you have met most of them, Dr. Anwar Sadat, Dr. Parneet Kaur, Dr. Kanika Sharma, office staff, Raki Bakshi, Ravinder Singh, Santram, then Ravinder, Saurabh, and then Ramesh Singh, of course, all of them have really helped, and in this program. Rapporteurs, particularly we had 3 rapporteurs who actually noted down everything. We proposed to put this particular work by the rapporteurs on the website of the society in the coming days, which include Surya, Gayatri, and Shabnam Khan. Thank you very much, rapporteurs, for being there in all the meetings. Well, our library, as Professor Desai mentioned, we have one of the best international libraries in this part of the world. We have Dr. Meenakshi Bhan, Sanjay, Menaka, and Rahul. I'm sure why I'm saying these names are because you young scholars particularly, you all know them, many of them, you have met them, all your problems and things like that, they have solved all these problems. But do visit our library, take advantage of that, and then, and thank you very much, and come again, and society is yours, and let us all build international law very well. That's one of the motto of the Indian Society of International Law. Thank you very much.
Thank you so much, sir. Now I request Professor Bharat Desai, sir, and Professor Hegde and Professor Anupam Jha, sir, to kindly distribute certificate of presentations to the presenters. Mr. Wad. Bhumika Nanda. Malay Adhikari. Mr. Malay Adhikari. Harpreet Kaur. Gurudev Sahil, Jyoti Singh, Mohammad Sufyan Khan, Dr. Komal, Mani Pratap, Dr. Swati, Santosh Kumar, Mr. Sunil Agrawal, Anshul Saxena, Mr. Umang Modi, Ajay Bhupendra Jaiswal, Tanvi Anand, Rekha Goswami, Brijesh Nanvi, Miss Amrita Verma, Dr. Balaji Naika, Dr. Snehal, Surapalli Parshanath, Miss Shritha, Mr. Vijay Kumar Verma, Mr. Dinesh Tripathi, Rekha Goswami, नहीं Dr. Komal, Mr. Dinesh Tripathi, श्रीथा वो है पीछे,
आप अपने पास रख ले रहे हो ना?
नवीन एस,
आप अपने पास रख
ये वाले नहीं आया ना सर? Which one sir? कौन सा बोल रहा है? नहीं, इनका सर्टिफिकेट तो नहीं मैंने अनाउंस किया अभी, नहीं है। Mr. Sudhir, दीपशिखा का है ही नहीं सर्टिफिकेट कोई भी, नहीं सर। मिस खिनकौर, लास्ट ये नवीन, मिस अंजलि, संतोष कुमार उपाध्याय, मिस्टर गुरप्रीत सिंह, अंकित मल्होत्रा, अनिल मल्होत्रा, ये भी नहीं है, गोयल भी नहीं है, ये है ही नहीं ना, ये है ही नहीं, रागिनी मैम वगैरह तो है ही नहीं ना। मिस्टर श्याम ओगांगा, मिस भव्या, मिस मेंढा काव्या, मृणाल शर्मा, मृणाल शर्मा, मिस ज्योति, मृणाल शर्मा, ज्योति, मनाली बंसल, डॉक्टर नितेश, मिस्टर साहिल, मोनिशा, मोनिशा साई, मिस कनिका केसर, मिस्टर देवाशीष दास, आयुषी अग्रवाल, मिस्टर नीरज कुमार सेठ, अक्षिता कोहली, नसीबा, श्रीवानी चिंताला, निखिल सिंह, लक्ष्मी नायर, आशीष कौशिक, निवेदिता सिंह, मिस यामिनी, मिस यामिनी, शिवांगी विशिष्ट, अस्वाति मधु कुमार, अभिषेक, मिर्जा जुनैद बैग, अरुणवा बनर्जी, अजीत विलियम, दृष्टि अलग, दृष्टि, हुसैन मीर, कथिर थरसिनी, मृणाल शर्मा, हर्ष कुमार, कृतिका कौशिक, तसीम कौसर, मिस श्रद्धा दुबे, मिस वर्दा मोने, मधुस्मिता, नवीन कुमार, संध्या शर्मा, सानिया खन्ना, सुशील कुमार, सबीहा, any one of the presenters who is left? सर्टिफिकेट लेके ले Please, those who have missed their certificates, please come on the stage, and others, they can contact Ms. Rakhi Bakshi. She is sitting outside the auditorium. अंजलि और एक इनके साथ थी वो उधर होगा अभी देख लेते हैं करेक्शन भी just contact the person who is sitting outside and if there is any correction in the certificates kindly contact the concerned person he is also sitting outside the auditorium what's your name I'm again announcing the names